ಸಮಾಚಾರ ಇವತ್ತು ಈ ಕಡೆ ಬಂದಿಲ್ಲ ಸರ್. ಲಾಸ್ಟ್ ಲೈಟ್ ಹಾಕಿಲ್ಲ ರವಿ. Total 26. 26 ಮೆಮೋಸ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. 26 24 ಇದ್ದಾರೆ. 6 ಇವತ್ತು ಮತ್ತೆ ನಾಳೆ. automatically ಹೋಗುತ್ತಲ್ಲ. Yes. Any memos? Appeal ಇಲ್ಲ. ಮುಂಚೆ ಕೊಡೋದು ಫಸ್ಟ್ appeal.
That interim order is very clear, my lord. If the lordship says that, my lord, to cure all defects, they are not.
Any adjournment? List 1, page 3, serial number 10 to 13, page 4.
List 1, page 3.
Page 4, serial number 14 to 17.
Counsel for the petitioner, praise for time.
15.
Next.
Page 5, serial number 18 to 20. List 1, page 1, serial number 1, Pradip Kumar KN.
Sixth time it is listed, sir. Counsel for the petitioner, praise for time. Officer has raised as many as 10 objections. Matter is listed for the sixth time. Do not find any reason to adjourn the matter. However, to offer final opportunity. Next. Serial number 1. Yes.
I'm appearing for R3.
Yes.
See, there is an order to pay 15,000 rupees salary with the backdating interest at 18%. And the order has been done in the month of January. And the case is going on for the last 7 years. And I'm living in penury. And these people are simply dilly-dallying to pay me the salary also. Even subsistence allowance has not been given to me. I'm living in penury. My family is living in penury. And for the last 3rd of June, they have filed this application, and 10 chances have been given to them, and still they are going on.
There is no stay of the order.
There is no stay of, but they are not paying us the money.
Now what is to be done?
Reject the petition, my lord.
On merits ಮಾಡಬೇಕಲ್ವಾ sir?
ಅಲ್ಲ
Now
ಡೆಲ್ಲಿ
the
ಡೆಲ್ಲಿ
office
ಮಾಡ್ತಾ
has
ಇದ್ದಾರೆ.
raised objections. He has to
ಬೇಕು ಅಂತ
comply
ಡೆಲ್ಲಿ
with
ಡೆಲ್ಲಿ
that.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಾಟ್ ಕಂಪ್ಲೈಂಗ್ ವಿತ್ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಟ್ ಆಲ್.
Oh, you execute the order in accordance with law. There is no stay.
ನೋ ಸ್ಟೇ, ನೋ ಸ್ಟೇ.
101 is,
Correct.
101 is there, my
Correct.
lord.
You get the order executed.
ಬಟ್ ಬೇಕು ಅಂತ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇದನ್ನ.
Madly, sir, they are entitled to do and they will do it. You have to take recourse to the
They
law.
will take recourse.
Yes, that's all. Stay is not granted.
Okay.
Pursue the matter.
No problem.
Next.
Serial number 2, K. Lakshmikant, Government Advocate.
ನಿನ್ನೆದ ಎಲ್ಲಿದ್ದಾರೆ? Yes.
Your Lordship,
ಆಯ್ತು, they will keep the witnesses present. ಅಷ್ಟೇ. ನೀವೇ ಕ್ರಾಸ್ ಮಾಡಲ್ಲ, ಮತ್ತೆ you are taking advantage of your own contention. You cross examine all those witnesses. No. You have to apply your mind, sir. ಅವ್ರು ಏನಾರು ಬೇಕಾದ ಹೇಳ್ತಾರೆ. No. ಏನಿದು, ಏನ್ ಮಾಡ್ತೀರಿ ಇವತ್ತು? On merits, I'll dismiss.
case and counter case, Your Lordship.
How many witnesses are produced before the court?
As on date today, CW 2 to 5 are kept present, Your Lordship. CW 3 and 4 are 2 to 4 are kept present, Your Lordship. Next date is 18/12.
CW,
CW 1 is completed, chief is completed. CW 2 to 4.
CW ಅಲ್ಲಿ PW ಆಗ್ತಾರಲ್ಲಮ್ಮ. How many witnesses are examined? PWs 1 to
Only
4
one.
or 1 to 5?
PW 1 is examined.
CW 2, even the chief examination
No,
was
not
not
there, Your
held.
Lordship. It's one.
You kept them present.
We have kept them present
Why
on 3
chief examination was not held?
3 occasions. We have kept them present, Your Lordship. One day there was a delay due to PP was absent. That's it, Your Lordship.
Why chief examination was not recorded?
Counsel for accused A1 and A2 were absent, Your Lordship, two occasions. There and EP was filed for CW accused number 4. CW 2 to 4 were present and bound over as prayed for time ಅಂತ ಇದೆ. ಯಾರು ಪ್ರೇ ಮಾಡಿದ್ರು ಅಂತ there is no.
Go and cross examine. ತಗೊಳ್ಳಿ. Accused number 1. ಏನ್ ಮಾಡೋಣ ಸರ್? ಅದಕ್ಕೆ ನೀವು ಫಸ್ಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಬೇಕು. PW 1 ಕ್ರಾಸ್ ಮಾಡಿಲ್ಲ ನೀವು. We will cross examine along with other witnesses ಅಂದಿದೆ.
ಅವರು ಚೀಫ್ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ is moved, Your
The
Lordship.
other witnesses to be examined. Accused number 1. In SC 5065 of 2022 on the file of so and so first parallel is seeking grant of bill for so and so perused materials. Point for consideration. My answer to the point in the negative for the following reasons. The FIR in crime number 77 of 2022 of Kikeri village, Kikeri police station was came to be registered against accused numbers 1 to 5 for the offence punishable under sections 143, 504, 323, 324, 354B, 302, read with section 149 of IPC. After investigation, charge sheet came to be filed against accused numbers 1 to 5 for the aforesaid offences. As per column number 17 of the charge sheet, accused number 1 to 3 picked up quarrel with the deceased. Case number 1 abused the deceased in filthy language. In the presence of the eyewitness CW1 and CW2 and assaulted him with a club. He snatched the machete from the hand of accused number 2 and assaulted the deceased on his head. Accused number 2 again snatched the machete from the hand of accused number 1 and assaulted the deceased, causing fatal injuries. Thus, it is the contention of the prosecution that accused number 1 and 2 have inflicted fatal injuries by using the deadly weapon, that is the machete, which resulted in the death of the deceased. The only allegation made against the other accused is that they abated commission of the offense by accused number 1 and 2 and have assisted them. Therefore, accused number 2 to 5, 3 to 5 are already enlarged on bail, subject to conditions. But accused number 1 and 2 are the authors of crime, which is punishable either with the death or imprisonment for life, are denied the discretionary relief of bail. There is the PM report, postmortem report. Have you produced? Ilva. Even the PM report is not produced before court by the petitioner. Admittedly, the deceased died at the spot. He died at the spot. Deceased died at the spot. Died at the spot. On the way to the hospital. Deceased died on the way to hospital. There are eyewitnesses to the incident, and there are other material witnesses to support the case of the prosecution. The petitioner had filed a criminal petition number. Earlier petition number 111718 of 2022. The same was came to be dismissed. Disposed of with the liberty to the petitioner to move similar application before the trial court after examination of material witnesses, that is CWs 1 to 7, 14 to 17. Next one. Now, admittedly, CW1 is examined as PW1, but he is not cross-examined by the petitioner. Stated that on few days CWs 2 to 5 were kept present, but their examination in chief could not be carried on as the advocate for the accused was absent. On other dates, the case was going to be adjourned for similar reasons. It is stated that the advocate for the accused requested the trial court to permit them to cross-examine all the material witnesses at a stretch. I think this is causing delay in trial. However, that cannot be a justification for the trial court to postpone the matter, ignoring the fact that the petitioner is in judicial custody. However, the petitioner is not entitled for grant of bail at this stage, as the material witnesses are to be examined before the court. Hence, I answer the above point in the negative and proceed to pass the following. Petition is dismissed. Prosecution is directed to keep the material witnesses presented to the court, and the counsel for the accused to proceed with cross-examination of all the material witnesses. The trial court should take into consideration the fact that the petitioner is in judicial custody since long and should expedite the trial. Yes. Dismissed. Adi ide, modle ide. You first cross-examine all those witnesses, material witnesses. Prosecution has to keep them present and examine in chief. Yes.
Serial number 3, K.S. Mallikarjun.
Of his objection. One objection is a comply madi. ಏನು ಅಲ್ಲರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಅದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Praise for time. Next.
Serial number 4, G.A. Mithun, Chandrasekhar Chandrasappa.
First pay the amount. First pay the amount.
They have given proposal for 3,75 lakhs. Bank has accepted it. And they have to pay the amount on or before 15/3/2024. That is the status as of.
I will record your submissions and dispose of the petition.
Yes.
Why? No. Once you pay the amount, the order impugned goes. If you fail to pay the amount, there is no question of pay it immediately. Yes, whatever it is, as per the proposal, as it was accepted, you have time till March
15/3.
15/3. Pay the amount within that time. I will record his submission. I am recording his submission. No date, sir. No date. Then go on with the matter. No. Either you should go on with the matter. You are not arguing the matter. You are not paying the amount. You are not allowing the court to record his submission and dispose of the petition. It is a deadlock, aste. You are not interested in anything. You are only saying, I am ready. I am ready to argue. I am ready to pay the amount. Everything. For everything you are ready. Pass over. Seek the instructions and come back.
Serial number 5, Ashok Kumar, Chandrasekhar P. Patil.
This case appeal lies to KAT Lordship under section 46 of Savarda Act. Last occasion also they have taken time to make submission. The award was passed under section 37, Lordship. Appeal lies to KAT under section 46.
Pass over. Let him come.
Serial number 6, Venkatraman KS, SK Srinivasan.
Your Lordship, in this matter, there was an
No.
in this matter there was an interim order conditional upon us depositing the amount. That amount has been entirely deposited. This is a writ of mandamus as against cooperative society. They have filed an application seeking vacating of stay.
No, when such a conditional order was passed?
This was
21/8.
21/8, please. That has all been complied with.
1 minute.
21/8/2024. Yes. Last year.
When you deposited 50 lakhs,
Your Lordship, it is totally 3.15 lakhs in 3 matters put together, Your Lordship.
We have deposited on
It has been deposited on
18/9/20.
18/9/2024. In one matter, 2 crore 50 lakhs.
no, order sheet in WP 22390
Double
dated
two,
21/8/2024.
please.
It says order dated 7/8/2024 is stayed
Please.
till next date of hearing, subject to the petitioner depositing 50 lakhs.
Yes.
That has been
Respondent
deposited.
number 3.
Please.
That has
So
been
50 lakhs
deposited.
has been given on 18/9 in
Yes.
22390. In 22391, 2 crore 50 lakhs has been deposited, Your Lordship, on the same 18/9.
Two and a half crores.
Please, Your Lordship.
And another case, 15
And
lakhs.
22479,
Yes, 15 lakhs.
please.
In all the 3 cases.
In
it
all
is
3, it has
deposited.
been complied. Now they have filed an application seeking vacating of stay. Your Lordship, kindly permit us to file a detailed rejoinder in view of the fact that they have filed this vacating only because there is an,
Instead of that, you address the arguments on merits.
Your Lordship, the reason being, in this matter, the fraud that was played was they have sanctioned further loans which we had not sought for and diverted that to the son of the main person.
Should be considered on merits.
Please, Your Lordship, might I be permitted to produce that in view of the fact that they have not shared? My entire prayer itself is.
No, you admit that pursuant to this order, conditional order, they have deposited the amount.
In compliance with the High Court directions, they have deposited the amount.
Yes.
The total principal amount is 38 crores, madam.
Yes.
And the
You may
total
not
outs.
you may not have any objection for them to address the arguments on merits.
I don't have any objections. I'm okay with it.
So get ready to address the argument, whatever the document.
That, yes, please, rejoinder one.
Produce it and go on with the matter.
Please.
I need a specific date, maybe.
Yes.
Your Lordship, might I also seek that they provide those documents because we have never not even signed for those additional loans.
The documents.
That is the relief which gets into the root of the
That is
petition.
true. That is probably my main
That's a
relief also.
disputed questions of fact.
No, no,
That's so that when they file the rejoinder, I'll explain it to
First
you.
week of January.
Please, please, please.
Learned senior advocate for the petitioner submits that in all the 3 matters, the conditional order to deposit the amounts is already complied with, and that the petitioner will address the arguments on merits,
Yes, ma'am.
subject to the respondent producing the relevant document. Which are the relevant documents according to you?
Loan documents, Your Lordship.
Relevant loan documents. However, learned counsel for the respondent number
2 and 3, my lord.
2 and 3. What is your contention? Why the loan documents could not be produced?
They were, this loan was sanctioned in 2016 and 17, my lord. At the same time, they became members of the society. We have furnished them the membership certificate also. They have the original. We can furnish the photocopy of it. And as regards the loan sanction proposal and everything, we have furnished a copy to them.
No, no.
We'll furnish. That's not a problem. We'll furnish that copy.
However,
We'll furnish a copy.
respondent number 2
They've executed a mortgage deed also. We'll furnish that also.
is that the petitioners are already provided with copies of all the loan documents.
Yes, Srinivas.
However, he has no objection to produce copies of the same
Yes, ma'am.
for perusal of the court.
Obliged.
For final hearing.
A
The
date may
interim
be
order could be
specified, ma'am.
extended.
First week or second week.
Interim order may be extended, Your Lordship. Interim.
I put interim order is to extend, madam.
Your Lordship, interim order is extended.
Yes,
Please,
extend.
oblige.
Serial number 7, A. Vijay Sai.
I appear for the petitioner counsel, my lord. Application has been filed to recall the order dated 4/11/2025. Office objections is there. If your lordship permit, we will comply the same.
Any objections are there?
Additionally, 2 objections are raised.
Petitioner seeks permission to comply with the office objections in view of IA 1 of 2025. Since the petitioner has come up with the application IA 1 of 2025 seeking recalling of the order dated 4/11/2025, dismissing the petition for default, the petitioner is permitted to comply with the office objections within a week.
Please,
Yes.
Acham.
Next. Pending consideration within a week from today, pending consideration of the application. Yes.
Serial number 8, Dev Prasad Shetty.
Kindly pass over one. Senior is held up in the tribunal.
Pass over.
It was for the petition. We have finished the arguments. It pertains to the Chelur Manchenadi, my lords. The arguments were heard completely. The petitioners wanted to give a judgment pertaining to subject to outcome. Based on that, my lords, on their argument, had asked us to clarify on 2 points. We are ready.
Senior has to.
I think it is heard at length.
He must be the successful candidate, my lords.
ಮತ್ತೆ ಅವ್ರದ್ದು ಏನಿರುತ್ತೆ?
Where 2 talukas were given a representation. The amendment 12(5), we said 106.
Yes.
We will complete, my lords, there are only 2 points.
I think the other day.
I wanted to cite 2 judgments.
Judgments to contend that even the beneficiary of the order need not be heard. That is the decision.
Subject
And
to outcome and
once
the gain on.
if it is made subject to outcome, in case the petition is allowed, all subsequent these things will get obliterated is the argument, my lord.
Yes.
Please. The lordship may.
On behalf of 7th respondent, the petitioner society has not issued authorization. That is what the letter given by the petitioner society. Annexure is not.
Our preliminary contention was petitioner is not authorized to question the same.
Issued a letter. I need to file it with memo.
I had argued, my lords, that under section 29, they are not authorized by the. My lords have already taken a view that it's only the CEO. They claim it under a letter.
The society.
Please, he cannot represent, and it's not his case, it's not his personal.
Yes.
And they want to convert it into an election petition by questioning 29 GJ.
Yes.
Now the society wants to place on record that he is not authorized.
With court. This is 2019 6 SCC 559.
Yes.
In this, my lord,
Why you are relying on this?
it is once the petition, it is made clear at interim order stage that all those subsequent proceedings would be subject to result of the petition.
Copies may be.
ಮೊನ್ನೆನೆ ಒಂದ್ ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೇನ್ರಿ ಇರ್ಬೇಕು ನೋಡ್ರಿ, ಕೊಡ್ತೇನೆ. ಸೀಮಾ ಸರ್ಕಾರ. It was a case wherein the judgment in 2019 6 SCC 559, there was a no confidence motion moved against the sitting president. Contention taken was the no confidence motion on that day's meeting. There was no quorum. Meeting was, as there is a failure of quorum, meeting was cancelled by the CEO of the Panchayat. The authority reversed that decision, saying it is no quorum was there or something. That was challenged when they treated that as passing of a no confidence motion, and election was announced. That was challenged in the writ petition. In the writ petition, though petition was entertained, the election was not stayed. It was made clear that it will be subject to result of the petition. Now, kindly see paragraph 41, that would be the last page.
Yes.
Resultantly, the follow-up action taken against the appellant, asking him to step down, therefore also would be known as implied. This court today ordered so had made it clear that consequential election to fill in the vacancy arising due to removal of the appellant would be subject to outcome of this petition. Accordingly, we hold that all steps taken after the order of the executive officer on 2/1/2017 be treated as non-est in terms of this order. As a result,
So if the petitioner is successful, yes,
succeed on the ground,
if we are
that
successful,
this particular bylaw was not registered in accordance with the direction of this honorable court.
all further steps
All further steps,
Will be-
changing the voter list, all those things will, including the election, the result will go. 42 gets what it is said. As a result, we allow this appeal, set aside the input judgment in order of the High Court in so and so, and instead, we dismiss the writ petition filed by respondent number 6, and to do complete justice, we direct the restitution of the appellant to the post of Pramukh of the little Andaman Panchayat Committee, as its tenure would otherwise have expired in September 2020. The district administration shall take up follow-up action. Then in another case, as regards the hearing of the beneficiary of subsequent development, that is 2016 to SCC 779. In this case, briefly stated the facts that a fair price shop was allotted in favor of the appellant before the Supreme Court. The respondent before the Supreme Court. What happened was, it was kept under suspension on allegation of contravention of license condition, and an inquiry was started. During the period of that suspension, it was allotted or an arrangement was made given to another third party. That fair price shop was allotted to a third party.
yes,
Ultimately, in the inquiry, in the appeal filed by the respondent and fair price shop holder, he succeeded in the appeal. The cancellation of his license was set aside. The third party who was allotted filed the writ petition before the High Court, claiming that in allowing his appeal, my allotment is cancelled. Therefore, I am an affected party. I should have been heard.
yes,
That writ petition was entertained by the High Court at his instance, but ultimately High Court said, even after this, he would not be entitled to the benefit, but he was made as a party, he was heard. For that, Your Worship, can we go to Para 53? Para 50 and 53. Para 50. Or whether just for the purpose of facts, but I will read 49 also. In the instant case, shop number 2 had become very appellant was allotted a shop maybe in the handicapped quota, but such allotment is the resultant factor of the said shop falling vacant. The original authority, that is the respondent,
Original allotee.
that is the respondent, aside his cancellation and ultimately succeeded in appeal. We are not concerned with the fact that the appellant hearing was allowed to put her stand in the appeal. She was neither a necessary nor a proper party. Appellate authority permitted her to participate, that neither changes the situation nor does it confer any legal status on her. She would have continued to hold the shop as the original allotee lost the appeal. She cannot appeal the said order in a writ petition because she is not a necessary party. It is the state or its functionaries who could have challenged the same in appeal. They have maintained sphinx like silence in that regard. Be that as it may, that would not confer any locus on the subsequent authority to challenge the order passed in favor of the former authority. She is a third party to this litigation and to be listed in this context. In 15 and 53, it is explained that a subsequent allotee or a candidate does not get a legal right, is a stopgap allotee.
Yes.
Then para 53. We have referred to the said decision of Ramesh Shirakan case in extenso as there is emphasis on the curtailment of a legal right. The question to be put is whether there is curtailment or extinction of the legal right of the appellant. The writ petitioner before the High Court was trying to establish her right in an independent manner, that is, as an independent legal right. It is extremely difficult to hold that she has an independent right. It was the first allotee who could have continued in law if his license could not have been cancelled. He was entitled in law to prosecute his cause of action and restore his legal right. Restoration of legal right is pivotal, and the right moment this attempts being over, he has to come back in the same position. His rights get revived, and that revival of the right cannot be dented by a third party. Then, for a moment, your document introduce the interim order passed in this petition. That was on 20th May 2025. In the almost must be second page of that order. starts with the sentence. 14 section 12 it starts with the section. It is submitted that as per
Page number 2 now.
must be page number 2 in the
Order dated 20th May. So page number 2 ನಲ್ಲಿ one
section 12(6) ಅಂತ ಒಂದು reference ಬರುತ್ತೆ ಅದು ಆದ ಎರಡು sentence
12(6) ಆಯ್ತು.
12(6)
It is the grievance of the petitioner.
It is the grievance of the petitioner. It is the grievance of the petitioner that despite there being a specific order by this court to act as per the modifications proposed to the bylaws, the respondent number 2, without there being any such proposal, has passed an order under 12(6) of the Act as per Annexure H on 9/5/2022, which substantially alters the composition of the electorate of cooperative societies. It is submitted that as per 12/5/25 proposal, there are 18 cooperative societies in Rohini Taluk and there were 11 cooperative societies in Manchanelli Taluk, which included 2 villages, namely Tondevali Hobli and the Deepalya Hobli. It is submitted that in view of Annexure H order passed under 12(6) of the Act, dated 9/5/25, there are 26 cooperative societies in Rohini Taluk, 3 societies in Manchanelli Taluk. It is submitted that the said order under 12(6) of the Act is directly in the teeth of the order passed by the court in petition number so and so, and the connected government council however submits that with the appeal has nothing to do with the present litigation. But contra government council appearing for respondents submit that as per the order passed under 12(6) of the Act, the remedy for the petitioner is elsewhere. Therefore, they could not have litigated the matter in this request. Secondly, it is submitted that the order in WP so and so was challenged in discovery only in respect of some portion of the order and it is submitted that in the recovery determined the order the calendar of events of the election has to be continued to effect. Therefore, it is submitted that the recovery determination is of no relevance and there is no need to pass any remark. In this regard, the council for responding relies on the judgment of this court in Lakshmikant Vajpayee versus so content and electoral votes once published cannot be altered. It is pertinent to note that this court in WP so and so has specifically directed that the section 12 the election has to be held in pursuance of the proposed amendment under 12(5) of the Act. Now, the other councils appearing for respondents are unable to point out whether there was any such proposal under 12(5) of the Act, except which are dated 3/8/24 and 5/8/24. Therefore, it is evident that the preparation of the electoral roll is not in pursuance of the proposal under section 12(5) of the Act, but it was on the basis of the order passed on 12(6) of the Act. To this extent, there is deviation by the respondents. Question is whether the above deviation would be fundamental in nature and it would initiate entire election is a matter to be considered. This court, being vacation court, cannot go into the intricacy of the order passed by this court in WP number so and so, which runs to nearly 218 pages. Therefore, in witness of things, this court is of the view that the election as published by the respondents shall be proceeded with and result of such election would be subject to final outcome of the present litigation, which shall also be considered along with the WP number so and so. So specifically, it was made clear that the further proceedings of the election would be subject to result of this court.
Yes.
As I pointed out earlier, the present respondent number 7, who was the rival candidate to the petitioner number 2, could not have contested in that constituency if the bylaw was properly registered as per the proposal under 12(5). Therefore, my respectful submission is the respondent number 7 comes into picture only after this order.
Yes.
It was said to be, it was specifically made clear that it will be subject to the result of the petition. There is one more judgment, my lord, I will give that paragraph. It was in respect of Maharashtra local body election. Elections were proposed to be held by making reservation in favor of backward class, which exceeded more than 50%. Matters were went up to Supreme Court. At this stage of recently, Supreme Court said, though it's a question with some constitutional points are involved and importance, but we will not stay the election which is already calendar of years is announced. Let the elections go on, but the result of that election will be subject to the result of the SLP because the order made by the Supreme Court in respect of elections of a local body, that is panchayat elections, which are under Article 243E and 243U. Even in respect of that, ultimately, the SLP was admitted and appeal was allowed, holding that more than 50% reservation which has been made will have to go. That means about 16 seats which are above the 50% reservation. Election was cancelled by the Supreme Court on the ground. It has been specifically made subject to the result of the petition. Now that we are allowing the appeal, those 16 seats election is cancelled. So election will have to be held for those 16 seats, treating them as general seats. Or if they are other name, it appears that getting the copy, there is some difficulty that I will give it. Therefore, my submission is the hearing of respondent number 7 as the things stand, as of a legal right, is not entitled to be heard. With regard to my earlier friend's contention with regard to this thing, resolution authorization, may be noted, the petitioner is admittedly the delegate for contesting this particular election, elected by the society. After my election, the electoral roll was changed. After my being elected as delegate and I was to take part in the election, the electoral roll was changed. Therefore, even as a delegate, I am entitled to question these proceedings because I am authorized to contest the election. Ultimately, that election should be in accordance with law. As far as election matters are concerned, once the society makes a person as delegate, the entire election proceedings are his responsibility. He will be the candidate, he will be the voter. If the election is postponed, if he wants the election to be held, necessarily he will have to take upon himself to do all those things. Because Krishna Rao Gori, 2021 6 SCC page 73.
Yes.
I have just handled the paragraph.
Para 29.
Please, para 29. Para 28, 29. The 27, from 27 itself. In conclusion, we vote that section 12(2)(c) of 61 Act is an enabling provision and needs to be laid down to mean that it may be invoked only upon complying with critical conditions as specified in the constitution bench of this court before notifying the seats reserved for OBC category in the local bodies concerned. Further, will quash and set aside the impugn notification to the extent they provide for reservation of seats of OBCs being wide and non-esteemed law, including the following action taken on that basis. In other words, election results of the OBC candidates which have been made subject to the outcome of these petitions, including the so notified in the election program concern issued by the State Election Commission are declared as non-esteemed law. And the vacancy of seats caused on account of this declaration will forthwith filled up by the State Election Commission with the general or open category, open candidates for the remainder of the term of local bodies concerned by issuing notification in that regard. And it was made subject to result of the petition. Supreme Court said those additional seats, in that case it was 13 seats.
Yes.
They were declared, that election was declared as non-as because earlier a condition was put that it would be subject to result of the petition.
Yes, anything?
My submission, my lord, the petitioner society has issued a letter, even it is addressed to petitioner, that no such meeting was conducted on 13/5 as per annexure A, and no such authorization was also given to the petitioner. I may be permitted to place that memo.
Yes.
I may be permitted to place that memo along with letter issued by the petitioner society. According to the society, no such meeting was taken place on 13/5, and it is created. Even that letter said to be addressed to the petitioner.
You are for respondent number 7.
Respondent number 7.
Yeah, respondent number 7.
He is elected candidate. To the DCCI bank. And whatever the elections which was taken place in pursuant to the annexures which is challenged on the part of the petitioner.
Who has to consider all these things?
It is also addressed to this respondent.
No, whether a meeting was held, whether he was appointed as a delegate or not.
In view of no authorization, the petition itself is not maintainable.
No, according to him, he is the delegate who is capable of representing the society in election matters.
Now,
a delegate can represent the society.
But however, no, only delegate cannot.
In the election matters.
He can cast the vote.
No, that there is no provision. What was submitted by the learned senior counsel that the delegate can represent the society is not proper.
Only
Delegate
to-
is an authorized representative of the society in a particular federal society for a particular election. If he has to represent his society for a particular grievance, it was only under section 29, which was pointed out to my lords. Until unless the society authorizes him that you represent the society for this particular case, for this grievance. And that annexure A, which is now produced before my lord, saying that this is my authorization from the society to represent the society, is what is being said that there is no such resolution. It's contrary to his pleadings, and they have not answered to the same. The answer cannot be that he is a delegate. Allah, let me argue. They cannot argue that he is a delegate and he is entitled to represent the society in all the matters. Even in this matter, there is a judgment of this honorable court that he should be specifically authorized to represent the society. It defeats the very judgment of Daman Singh of Supreme Court, which says individual rights cannot be society's rights. Society has to be represented. Today, A person has a grievance against this bylaw. B person in the society may not have a grievance. That is the reason the society is always represented by a CEO. Once you become a member, your rights, individual rights is concretized by the society. He cannot have an individual grievance. And when there is a specific allegation that it's a concocted document and my lords are being misled by that document, the burden is on the petitioners to prove that he is authorized and that document is an authentic document. Otherwise, it defeats the very
So
section
according
20.
to this letter, no such meeting was held.
No such meeting, no such authorization. And he cannot have such a,
He was
this,
not appointed.
not
as a delegate.
appointed to represent the society. Delegation is only to the federal society, not for the courts to conduct cases. There's a definition of delegate also. So they'll have to answer that. They have to come out clean to my lords. They cannot approach the court with unclean hands. Delegate is defined under section 2E1A. It's a limited scope. Delegate means, my lords will get it, section 2 small e 1 small a. Delegate means,
1 minute,
please.
2
E, alphabet E, my lords, and number 1 and alphabet A, E1A.
Yes.
Delegate means a director of a cooperative society appointed by the board to represent the cooperative society in other cooperative society with power to participate and vote in the general meeting and to contest or propose or second in the election of the cooperative society to which he is appointed as a delegate. This is all the right he has. Not what he is before this court for. And 29G also, my lords, may kindly. Section 29. Alphabet G, capital G, clause 4J.
Section 20.
Section 29, G, my lords, alphabet G, capital G. 29G, clause 4J. It is the 29 speaks of chief executive officer. Only he can sue or be sued on behalf of the cooperative society. The judgment of this honorable court, I'll pass it on, where the 29(1)G was discussed, and only when a member or anybody can represent a society. And if the annexure A, which is being relied upon by the petitioner, is not in existence, my lord should take a serious view on the same. And my lords, the judgment, if the learned counsel has finished, I'll just reply to the judgments referred to by the senior counsel. May I, my lords? My lords, I had passed on synopsis and written submissions on 24/11/25. I have produced few judgments. I'll refer to that to answer the arguments of the respondents. It is dated 24/11/25. States synopsis, respondent state. My lords, the first judgment is pertaining to Daman Singh, where the right of members of a society and the society was discussed. Starts from page 12. Page 12, the judgment starts, my lords. Relevant provision, page 23, para 11. My lords will come to line 7, my lords. Once a person, para 11, page 23. In that, my lords, 8th line, once a person, capital, once a person, my lords will get.
Yes.
Once a person becomes a member of a cooperative society, he loses his individuality qua the society, and he has no independent rights except those given to him by the statute and the bylaws. My lords may kindly mark it.
Yes.
He must act and speak through the society, or rather, the society alone can act and speak for him qua rights or duties of the society as a body. So, if the statute which authorizes compulsory amalgamation of cooperative societies provides for notice to the societies concerned, the requirements of natural justice is fully satisfied. Once the notices are issued to the society is what was considered. Now, my lords may kindly turn to the next judgment. Vipul Bhai Chaudhary. Starts at page 26.
Yes.
Pertaining to elections and representation. Last time, ಕೊಟ್ಟಿದ್ವಿ synopsis. My lords, page 44, para 16. Page 44, my lords, para 16. The principles of representative democracy.
Yes.
Is the election of representatives by the people, otherwise eligible to cast their vote, or the people thus elected, constituting the body for management of the institution. Thus, in the case of cooperative societies, after the amendment of constitution, there has to be a board of elected representatives, which may be called board of directors, governing the board, body or managing committee, to which the members entrust the direction or controlment of management of affairs of the society. That representative body selects one among the elected representatives as its chairman or any office bearers, as the case may be. Selection is the act of carefully choosing someone to the most suitable to be the leader of the office bearer. Thus, there is a lot of difference between the election of delegates, representatives to the constitute of a body, and selection of a person amongst elected members to be a leader. It is to be borne in mind that the management and control of society is entrusted to the representative body, namely the board of directors. The chairperson elected by the board of chairperson is not the board of the directors. My lords, the next judgment starts. It's Gangana's judgment. My lords, we have referred page 61. These are also the cases where the elections were subject to the result of the writ petitions and elections were held. My lords may kindly turn to in page 94, para 47, my lords.
Yes.
The petitioners have placed reliance on the judgment of the Ashok Kumar's case supra. Referring to the para 32 of the judgment, it is urged that any step taken by filing a petition should not be construed as a petition calling an election if the step taken subserves the progress of the election and facilitates the completion of election. It is also urged that the decisions taken by the Election Commission are open to judicial review on a well-settled parameters which enable judicial review of decisions in statutory bodies, such as on a case of a malified or arbitrary exercise of powers being made out or statutory body being shown to have acted in breach of law. In this petition, no case is made out to hold that the process has suffered on account of malifieds or arbitrary exercise of powers. Intervention in election process, in fact, and circumstances presented before the court certainly does not enable the smooth progress of election. Moreover, has already held statutory remedies available to the petitioners to challenge the electoral roll. So, my lords, the direction my lords will get. Page 97. Page 98, my lords. The returning officer shall count the votes so on. So the liberty is reserved, my lords gets. The liberty is reserved to the petitioner or any aggrieved person to raise objection to the validity of the electoral roll by way of election petition. If such dispute is raised, authority under section 70 of the Act shall examine all the questions of the validity. Nothing expressed is about the merits. The next judgment, my lords. Samaj Seva Sahakara Bank. Page 101. Second paragraph. The impugned orders, the challenge, are passed under section 12 of the Karnataka Cooperative Act. The impugned passed under 12.5 and 12.6 of the Act is replacing the word so on. So any order passed under section 12 of the Act would be an appealable order. 106B of the Act, the statute provides for an appeal against an order passed under section 12 of the Act. So I decline to entertain. My lords, there are two judgments which I am passing on now. Union of India. And though this pertains to service law, my lords, there is a ratio which is laid down. Para 26, my lords will get. I'll just read and pass it on. Para 26, approbate and reprobate.
Yes.
These phrases are borrowed by Scots law. They would only mean that no party can be allowed to accept and reject the same thing, and thus one cannot blow hot and cold. The principle behind the doctrine of elections is inbuilt in the concept of approbate and reprobate. Once again, it's a principle of equity coming under the contours of common law. Therefore, he who knows that if he objects to an instrument, he will not get the benefit he wants, cannot be allowed to do so while enjoying the fruits. One cannot take advantage of one part while rejecting the rest. The person cannot be allowed to take benefit of the instrument while questioning the same. Such a party either has to affirm or disaffirm the transaction. The principle has to be applied with more vigor as a common law principle. If such party actually enjoys the one part fully and on near completion of the said enjoyment thereafter questions the other part, an element of fair play is inbuilt in this principle. It is also a species of estoppel dealing with the conduct of party. We have already dealt with the provisions of Contract Act. My lords, this I'm referring it because here is a petitioner before my lords who participates in the election,
Yes.
knowing this is the allocation. He loses the election. If he would have won, he would not have had any difficulty. If he had difficulty, he should not have participated in the election and then come to the court saying that this election is wrong. The next judgment, my lords, Tajveer Singh Supreme Court judgment pertaining to the similar point where the courts say about my lords may kindly take para 38.2. 38.2, my lords. The Honorable Supreme Court 38.2, page 177.
Yes.
My lords will get 38.2, Adrali explanation 24. In view of the proposition, second paragraph, 38. In view of the propositions laid down in the above noted judgments, it must be held that having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, The respondent had waived their right to question the advertisement or the methodology adopted by the board for making the selection of the learned single judge. And the division bench of the High Court committed a grave error by entertaining the grievance made by the petition respondents. My lords may now kindly turn to the next page. Continuation of para 38. My lords will get the second paragraph. The law on the subject. The law on the subject has been crystallized in several decisions. The court laid down the principle that when a candidate appears at an examination without objections and is subsequently found to be not successful, my lords may kindly mark it, a challenge to the process is precluded. The question of entertaining a petition, challenging an examination, or she cannot subsequently turn around and contend that the process was unfair or that there was a lacuna therein merely because the results is not palatable. It is also well settled that those candidates who had taken part in the selection process, knowing fully well the procedure laid down therein, were not entitled to question the same. It is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful. The candidates cannot approbate or reprobate at the same time. In other words, simply because the result of the selection process is not palatable to a candidate, he cannot allege that the process of interview was unfair and there was some lacuna. Therefore, we find that the writ petitioners in this case could not have questioned before the court of law the rationale behind recasting the selection criteria, as they willingly took part in the selection process even after the criteria has been so recast. Their candidature was not withdrawn in light of the amended criteria. A challenge was thrown against the same only after they have been declared unsuccessful in the selection process, at which stage the challenge ought not to have been entertained in light of the principle of waiver and acquiescence. My lords, the two judgments now relied upon by learned senior counsel, my lords, Vikas Rao Gowli, Poonam and Seema Sarkar. My lords may kindly consider what is it that the petitioner is praying before, my lords. They have argued before, my lords, that there is an interim order and the elections are subject to outcome of this writ petition. What is their case, even if my lords want to give them an order? What is the prayer before, my lords? They have not questioned the declaration of elections. They have not questioned the elections. There is no prayer, even the main prayer or the interim prayers. And they are arguing before my court, before my lords, that I don't have to even make parties, the necessary parties who have won in these elections, and there is no right accrued in their favor. The only right is in favor of the petitioners. That is not the settled position of law. If there is a subject to outcome, the subject to outcome is to the final relief before my lords. What is the final relief? The elections are not challenged. It is not even an interim prayer. Even today, the results are not questioned before my lords. And only Manchenalli, Chelur is also part of the bylaw. Chelur is not part of the writ. Chelur person who has won is not before my lords. They want all the orders before under 226 without having even prayed for before my lords. The interim order should always be in aid of the final order. And my lords, the judgments which are now relied upon by the learned counsels for petitioner. My lords, two judgments are relied upon. One is Poonam versus State of Uttar Pradesh. The second is Seema Sarkar versus Executive Officer. Poonam versus Uttar Pradesh is an allotment of site. It is not a democratic process. If my lords turn, yes, it's a license. It is not a democratically elected body to a society. And who is questioning? A person who is not authorized. And my lords, respectfully, only para 49 and 59 was read out. My lords, I'll read para 50 of the judgment. Yes, para 50 of the judgment given by the petitioners, Poonam versus State of Uttar Pradesh. Page 810, my lords. Poonam versus State of Uttar Pradesh 2016 to Supreme Court 779. Kindly see what is the grievance. There is a shop, allotment of a shop. Here it is a case of a bylaw of a federal society where there are hundreds of societies who are a party. Para 50, my lords.
Yes.
My lords, may kindly come to the last 5 lines. I'll start from the 3rd line, my lords. The decision which we have referred to herein before directly pertains to concept of necessary party. In the case of so-and-so, it makes it absolutely clear. We have explained the authority in so-and-so and opined that it has to rest on its own facts, keeping in view that the declaratory relief made therein and further what has been stated therein cannot be regarded as a binding precedent for the proposition that in a case of removal or dismissal or termination, a subsequently appointed employee is a necessary party. The said principle shall apply on all 4 to a fair-paced shop owner. My lords, it's a fact specific, whose license is cancelled. We may hasten to add this concept will stand in contradiction to a case where a land after having vested under a statute in the state has been distributed and possession handed over to different landless persons. It is because of such allotment and delivery of possession in their favor that it is required under the statute rights are created in favor of such allottees, and therefore they are necessary parties as it has been held in so and so. Here, they are necessary and proper parties. The persons who have won the election, where they want the election to be set aside, where there is no prayer, they don't want to make the elected representatives as parties. The subtle distinction has to be understood. It does not relate to a post or a position which one holds in a fortuitous circumstances. It has nothing to do with a vacancy, the land of which possession is given and the landless person who have received the pattas and have remained in possession. They have a right to retain possession. It will be an anarchical situation if they are not impleaded as parties. Whereas in a case which relates to the post of position or vacancy, where he or she who holds the post because of the vacancy having arisen is allowed to be treated as necessary party or allowed to assail the order, whereby the earlier post holder or allottee succeeds, it will only usher in the reverse situation. It is an anarchy in law. So it defeats the very proposition of law of proper and necessary parties. And the second judgment which was referred to, my lords, pertaining to a no confidence motion. My lords, no confidence motion, my lords are aware, is an indirect election where elections are already held and the elected members elect their president or vice president.
Yes.
In those proceedings. And here is a case in para 1 and 22 and 23, my lords will see in this judgment of Seema Sarkar. It pertains to lack of quorum. And section 14, Rule 14 KK specifically speaks of no confidence in our act. If there is any grievance, it takes care of it.
Yes, that's all.
Please. And my lords, I'll just now get back to the only one paragraph in Daman Singh, for my lords' consideration in our synopsis. Page 25, my lords, midterm. I wanted to say it in the end. This is a constitution bench which considered the Cooperative Act in length. The last paragraph, my lords, page 25, my lords will get. Internal page 683, our ink page 25. My lords gets it.
1. Paragraph number.
Para sub 14, my lords, it starts from 24. Next page, my lords. 25.
Page number?
Page 24, my lords, Daman Singh versus State of Punjab.
Before in your compilation.
Please, my lords. Adralli page 14, next page, para 14, my lords, I'll read from the next page. The basic structure of the constitution as they affected the dignity of human being and were therefore void. We find ourselves, my lords may kindly mark this, we find ourselves unable to appreciate how a dignity of human being can even be remotely be said to have been affected by amalgamation of cooperative society, of which an individual is a member with another cooperative society. We expect the counsels appearing in this court, particularly when they appear before a constitutional bench, to avoid advancing such totally unsustainable propositions. The time of the court is a public time, as the mountainous arrears of show. The time is becoming increasingly dear and precious. We only appeal that counsels to carefully examine it. His right is not curtailed. He has participated. He has lost the election. He doesn't pray that the election has to be set aside. He places reliance on an interim order of this honorable court, which was a protective interim order. It should be accompanied by a main relief. He comes before the honorable court without a resolution, without authority, doesn't justify his document. And the judgment of this honorable court, which clearly says it's either the CEO or, if any member, only if there is a authorization. Otherwise, he has nothing to lose, and he has not made the necessary parties in this case who will be directly affected by this order. And 106 is a statutory remedy. My lords may kindly see, the courts have time and again held, when there is an alternative statutory remedy, invoking 226 and saying I will not get justice in a statutory remedy would be an incorrect argument before my lords. They will have to exhaust it. There is a provision, and their rights are also concretized by the act. It's a statutory right. It has to be dealt with under the statute. That's all, my lords. Grateful.
First answer this petition was filed on 14/5/2025. Immediately on passing the order election A, altering the final list of voters. On 13/5, election A, page 288.
Yes.
On 13/5/2025, published final voter list was altered. Immediately on 14/5/2025, I had not participated by that time in the election. Before participation, I approached this court and wanted that election to be stayed. The court said no, let the election go on, whether the bylaw is properly registered, improperly registered. Then the question of I being sent out on the ground that we have participated in the election. Court itself directed, let the election go on subject to the result of the election.
Election is not questioned. Election is not questioned, my lord. That is not their interim prayer.
First argument. On that, they relied upon the judgment in Karnataka's case and the other two cases. That court dismissed the writ petitions. Therefore, it said there is nothing that I can do with regard to subject to result of the petition. Yes, the writ petition is dismissed. Subject to result will lose its significance. Yes, I succeed. Then necessarily the options will have to consider what is the effect.
Yes.
Kindly see, the order passed in WP 21/5/21. I don't know why this is being contended by the learned additional page 276.
No statement of objection.
Other writ petition. Writ petition.
Writ petition number
14/454.
454.
Previous judgment, page 276.
We have answered this argument. It was argued at length. The same proposition.
If you want to say something more than what it is, I would rather say it was not fair on the part of the learned additional advocate general to have made this submission in the light of this observation. Kindly see 39.2. Of course, we fight cases, there is nothing wrong about fighting the cases, but on facts, we should not do something which is avoided.
12.5, I have argued, I have submitted. They have not answered what we argued.
39.2.
Yes.
The registrar is directed to give effect to the modification proposed under section 5 of section 12 by registering the said modification amendment to the bylaws and 26. Continue with the holding of election at the earliest in terms thereof. The direction for holding the election precondition is register this bylaw, and there is already a direction in the previous petition binding on all of us. On registering the bylaw as stated therein, election should be held in terms thereof. For this, there may not be several prayers again and again. That prayer on registering the bylaw, what should happen, is already provided for in the mandamus issued by the Honorable Court. As regards filing of appeal under section 12.5 against the order under section 12.5 or 12.6, my respectful submission is, this is a matter that has arisen as a consequence of an order in the petition. Question of this being sent to someone for interpretation, and let us say I succeed in an appeal under 12.6. And that authority, that appellate authority, is in a position to grant the complete relief, the consequential relief of holding election afresh after registering the bylaw, even if I succeed. That authority has no such power. Either I get the relief here or I don't get the relief. Question of alternate remedy in this case will not arise as the matter is in respect of implementation of an order of this Honorable Court in the midway. Third aspect of it is with regard to the memo filed by respondent number 7. My first argument is respondent number 7 has no locus standi to present any case here. Therefore, his objection is not one of the objections to be considered at all. In case, even after that, if your lordship is proposed to consider that objection, give me 2 days time to file a response, not argument, to that man. Because in the cooperative society, there can be several times groups can happen, and this time it appears the present chairman of the society has individually written that letter. Chairman of the society. Therefore, that is not something which would be considered by this Honorable Court. But in case it is to be considered, I will be permitted to file my response in a day or two. The hearing is completed. I am not. My first submission is it does not deserve to be considered at the instance of respondent number 7. Please.
The respondent number 7 is a party. He has every right to object. And it is the letter which is issued by the petitioner. Yes. And the contents of letter also discloses that no such annexure was issued, and it is a created document on the part of the person who has approached court. Paragraph 2 is very clear in respect of that letter issued by them, and it is also addressed to the person who has approached the court. Yes. By the society.
Third learned senior advocate for the petitioner and the AG. In counsel for respondent number 7. Also the reply. These two will get into. These two separate. Yes. ಇರ್ಲಿ ಹಾಗೆ ಅವರು ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಇದು ಹಾಕ್ಬೇಕಲ್ಲ. ಅಷ್ಟೇ ಅಷ್ಟೇ.
There's the 29J one judgment that he cannot represent, that my colleague will pass it on. Great.
You have to mark the relevant.
The relevant paras will be marked. Please, we'll do
referring
that.
to the judgment.
We'll do that.
Yes.
Great.
Serial number 9, David Prasad Shetty.
For respondent.
ಇವತ್ತಿಂದಷ್ಟು ಬೇರೆ ಸೆಪರೇಟ್ ಕಟ್ಟಿ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಪಿಟಿಷನ್ ಕಾಪಿ ಇದೆ ಸಲುವಾಗಿ
ಸರಿ.
ಕವರ್ಡ್ ಡಿಸಿಷನ್
ಕೊಡಿ ಅದೇನು
ಮೇಡಮ್.
ಏನು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
Regarding my lord, they say that not to approve anta kelidare idralli. Those my lord societies is there. The honorable court already taken decision my lord to
What is your prayer in this?
not to approve the membership of the
Not to.
Statement.
In this, how it is connected, in this there is a direction to consider the representation.
two regarding my lord. There my lord some application pending before the my lord DCC bank that they have not considered anything my lord. That is the reason my lord now the petitioner come before the court say that application cannot be considered my lord. He is given negative relief my lord against the private respondents.
I am for the respondent number 4, my lord. In my detailed statement of objection, the 6, 7 and 8, they have cleared their loan. Actually, respondent number 4.
No, 1 minute. There is a prayer number 2, similar prayer. To issue the writ in the nature of mandamus directing respondent number 3 to consider the representation and accept D.
Two regarding this petition is concerned.
In this petition.
Please. To my submission is my lord, the DCC the application which was new society lordship aware of that my lord, the DCC bank my lord to Chikmagalur case is concerned.
Yes.
The so many society has been my lord given application to the DCC bank. The application still my lord pending. The election lordship pass an order to regarding set aside and go for the elections. If my lord they become a member of the society my lord, they are eligible for the voting. Now the petitioner say that my lord they will not participate in the election. That is the reason my lord this kind of the petition filed. Once application is given my lord, they will pass an order, whether right or wrong, my lord, they pass an order to give an endorsement to the society. This,
Yes, how we are entitled for prayer number 1? No, if they comply with all the requirements, they are entitled.
and also, my lord, the petitioner, one minute. Petitioner is not a bank, my lord. Kindly see who is the petitioner.
Individuals.
The bank should say, my lord, whether they.
No, whether an individual can maintain. What is the stand of your bank? Yaudu, you are the member of which bank?
DCC Bank, Chikmagaluru.
Respond number.
That is respondent number 3. No, you are the member of which bank, sir? Society.
Now, person from respondent number 5 has come forward to the respondent number 4 society by virtue of the bylaw, where the area population of village is included. Has produced for without discharge to the loan of their loan to the respondent number 5. They become a director of respondent number 4 society.
No, why your society is not aggrieved? Why your society is not aggrieved? Only 3 members are aggrieved. Why? The chief executive could have been.
My lord, I am for respondent number 4 society. Kindly state, go through.
You are for the society,
the respondent
of which they are the members.
Yes, yes. I am appearing for respondent number 4. We have filed statement of objection detail. Kindly go to the page number 6. Annexure R1, my lord.
1 minute.
Page number 6 of my statement of objection. They cannot become a member of 2 societies. Unless they clear the views of the respondent of 5 society. It has been clear, my lord.
Sir, that is their responsibility to see that it is done. It will be in accordance with law. How can they go?
It has been cleared.
Yellidev.
Page 6 of my statement of objection, my lord.
R1.
R1. R1, page 6.
Yes.
It is insofar as respondent number 6 is concerned.
Who issued this?
This is issued by the CEO, Kaduralli, respondent number 5 society. I am clear. The respondent number 6 has cleared his dues and withdraw his share certificate, share amount.
Clearing the dues to?
Respondent 5 society. Earlier, the respondent number 4 society was bifurcated from respondent number 5, my lord.
Originally, respondent number 4 was the society.
So originally 5 was the society.
5 was the society.
After in the year 2023, respondent 4 was created separately when government has issued an order to create separate VSSN for each panchayat. ಇದೊಂದು ಸಪರೇಟ್ ಪಂಚಾಯತ್ ಇತ್ತು, ಇದರಿಂದ ಬೈಫರ್ಗೇಟ್ ಬಂದ್ರು. ಬಂದಾಗ ಏನಾಯ್ತು, ಕೆಲವರು ರೈತರು ಸಾಲ ತಗೊಂಡಿದ್ರು, ಸಾಲಗಾರರು ತೀರ್ಸಿದಿಲ್ಲ. ಆಮೇಲೆ ಮೋರೋವರು ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರಲಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ it came to the knowledge of the respondents that we have cleared that dues. ವಾಪಸ್ ಹಾಕಿದ್ರು.
Next
loan also cleared. My lord, 7 page No, no.
Have some patience.
Come to page number
Next
seven.
R2 is that to
My
that
lord,
effect.
come to page number 7 of my statement of objection. ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಕಡೂರಹಳ್ಳಿ ಇದರ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ನಾನು ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುವುದೇನೆಂದ್ರೆ ಕಡೂರು ತಾಲೂಕು ಬಳ್ಳೇಕೆರೆ ಗ್ರಾಮದ ವಾಸಿ BH ವಿಶ್ವನಾಥ್ ಹನುಮಂತಪ್ಪ ಇವರು ನಮ್ಮ ಸಂಘದಲ್ಲಿ ಬಳ್ಳೇಕೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 59/2ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಇದರ ಮೇಲೆ ಯಾವುದೇ ಸಾಲ ಬಾಕಿ ಇರುವುದಿಲ್ಲ ಎಂದು ದೃಢೀಕರಿಸಿದೆ. It is regarding respondent number 6. In regarding respondent number 7 and 8, regarding respondent number 7 and 8, my lord, page 8 of my statement of objection.
Yes.
ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ನಿಗಮ ಬಳ್ಳೇಕೆರೆ ಇದರ ಸದಸ್ಯರಾದ BN ಭಾಗ್ಯಲಿಂಗಪ್ಪ ಸಣ್ಣ ನಂಜಪ್ಪ ಇವರು ದಿನಾಂಕ 37/2025ರಂದು 1,000 ರೂಪಾಯಿ ಷೇರು ವಾಪಸಾತಿ ಪಡೆದು ಸದಸ್ಯತ್ವವನ್ನು ಹಿಂಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. He has withdrawn his share from the Ballekere society and continued in respondent number 5 society. Same also is respondent number.
Continued in
Respondent number 5 society.
society.
And respondent number 8 also continued in respondent number 5 society. They have not raised any loan in Ballekere society. So they have continued it. They have withdrawn this society. The membership has been withdrawn.
That is the submission made and the letters are produced by the
Yes, ma'am.
society itself. Why it is to be,
7, 6, 7 and 8. 6 is continued in respondent number 4 society. 7 and 8 is continued in respondent number 5 society. Respondent number 6 and 7, 7 and 8 have not raised any loan in respondent number 4 society. Their loan is in respondent 5 society. Yes. 6 has cleared his loan.
it has cleared.
He has cleared his loan.
He has even produced the letter also. Sir, do you mean to say his submission before the court has no value? Then I don't think any apprehension, why you
But
are having
ಯಾವುದೇ
that
ಬಾಕಿ ಇರುವುದಿಲ್ಲ.
apprehension?
There is no loan.
I'll dispose of the petition. according its
Actually, writ petition is not maintainable, my lord. In view of the direction issued by the 18311 of 25.
Third, the petitioners being the members of respondent number 4 society or CP, issuance of writ in the nature of mandamus, directing respondent number 3 not to approve the membership of the newly formed respondent number 4 society, till the assets and liabilities of respondent number 5 society is distributed amongst the respondent number 4 and 5. And also issue the writ in the nature of mandamus, directing respondent number 3 to consider the representation dated 13/5/2025, reduced as per annexure D. Heard, sir. The counsel for the petition, heard, sir. Here is the materials, point for consideration. I answer to the above point in the negative for the following reasons. The counsel for the petitioner contended that without settling the dues from the members, they cannot be allowed to be the members of the newly formed respondent number 4 society. And therefore, he seeks to allow the petition. Per contra, respondent number 4, the society of which the petitioners are the members, made the candid submission that Respondent number 6 has cleared all the loans and withdrawn the membership.
Serial number 30.
Cleared all the loans
36497.
and continue to be the member of respondent number 4 society. He also submitted that respondent number 7 and 8 have withdrawn their membership from respondent number 4 society by clearing all the dues and continue to be the members of respondent number 5 society. Learned counsel for respondent number 4, while filing the statement of objections, produced various letters as R1, R2, and R3, and R3 and R4 in support of his contention. Since such a submission, since the learned counsel for respondent number 4 society, of which the petitioners are members, had made such candid submission before the court by producing the documents, I do not find any justification for the petitioner to maintain the petition. Accordingly, I answer the point in the negative and proceed to pass the file. Petition is dismissed. Yes. In view of dismissal of the petition, I have one of the matter also stands dismissed. Next.
Serial number 10, A.S. Raghavendra, K. Ravishankar.
And my lord, the election already held on 2311. Election had
Learned AGA takes notice for respondent numbers 1 and 2.
my lord, the already notice is order, my lord.
Agida.
Infructus ಆಗುತ್ತೆ ಇದು 2311.
ಒಂದು ನಿಮಿಷ. Quash any resolution, circular, internal decision of respondent that restricts the
Please,
voting
Madam.
rights. Mandamus directing the returning officer to permit petitioner society and similarly hold valid photo ID. ಆಗೋಗಿದೆ.
And also, my lord,
When it was held? Election?
2311.
Ah. ಆಯ್ತಲ್ಲ ಈಗ it has become infructuous now in view of conducting of election.
ತಂದಿದ್ದೀರಿ ನೀವು ಬುಕ್ಕು.
Yes.
Lord, this is a multi-state society, my lord. To regarding last occasion, respondent number 3 argue before His Honorable Court say that, my lord, there is a specific provision 29(6) of the Multi-State Property Act is very clearly say that once they are not attending the GBM, my lord, they are not entitled for the cast vote.
For the respondent number 3, my lord. It's an infructuous matter.
Yeah. Then what will happen? See, they have not attended the general body.
The prayer
In spite of that, they are eligible according to you.
my lord.
Why?
Thank. Lord, this is not
Why
prayer.
only the petitioner is aggrieved? Out of so many persons, only petitioner is aggrieved. Why? Petitioners ಇಲ್ಲ, only one petitioner. Why he is aggrieved? ಅಷ್ಟು lakhs of members ಇದ್ದಾಗ.
Please, my lord.
Why only one petitioner is aggrieved?
And also, not kindly see prayer, my lord, they are not challenging that. They admittedly, my lord, they say that not attending the annual body meeting. They admittedly say that, my lord, they are not attending this. GBM.
So you mean to say, irrespective of the fact that they attend the meeting or not, they must be allowed to cast their vote. Hmm. What is meant by active? Active where? No, this is also one of the condition. Attending the general body is also one of the condition. Ah. So how you are concerned? How we are concerned with the Camco?
Camco is, my lord, the society to multi-state society.
Central or Karnataka?
Please, central, please.
Okay. Hmm.
There is not a prayer, my lord, here.
Whether such a resolution or circular was issued, resolution was passed. See, sir, please see your prayer. You see, you are not sure. Pass any resolution, any circular, any internal decision. ಯಾವ ರೀತಿ ಆರ್ಡರ್ ಮಾಡಬೇಕು ಇದಕ್ಕೆ? No, no. We are putting the cart before the horse ಈಗ. First petition ಹಾಕಿ ಆಮೇಲೆ we will search for document. No, no, that cannot be. ತಗೊಳ್ಳಿ. ಇಲ್ಲ ಸರ್, ಇದು ಏನಿಲ್ಲ, ಸುಮ್ಮನೆ ಲಕ್ಸುರಿಯಸ್ ದಿ ಪಿಟಿಷನರ್. ನೀವು ಯಾರು? ಮೆಂಬರ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ನಾ?
I'm for the respondent.
ಅಲ್ಲ, he is the member of respondent number 3 society.
Please.
The petitioner has approached this court seeking issuance of writ in the nature of mandamus. Certiorari a right to pass any resolution, circular or internal decision of respondent society that restricts the voting rights of the members based on non-attendance at the annual general body meeting, and to issue writ of mandamus directing the returning officer or the cooperative election authority to permit the petitioner and all similarly situated C-class members holding valid photo ID cards to exercise their franchise in the election that is scheduled to be held on 23/11/2025. Tell you, one for consideration, negative for the following reason. The petitioner is one of the member of respondent number 3 society. It is stated that the petitioner and others who have not attended the required number of annual general body meetings were disqualified from exercising their right of voting.
Not disqualified, ineligible for the voting.
They were treated as ineligible to cast their vote in the election that was scheduled to be held on 23/11/2025. The contention of the learned counsel for the petitioner that even though the petitioner has not attended the general body meeting as required, he was the active member of the society, and therefore issuance of any resolution, circular or internal decision restricting his voting right is not fair and proper. He is not sure as to whether such a resolution, circular or internal decision was taken by respondent number 3 society. And council prays for time to search for such documents. Next, interestingly, the petitioner is seeking a direction to the returning officer or the cooperative election authority to permit him to cast his vote in the election. Admittedly, the election is already held on 23/11/2025. Under such circumstances, the petition does not survive for consideration as the same is rendered infructuous. Accordingly, I answer the above point in the negative and proceed to personal and petition dismissal as the same is shown. Yes.
11, came for Shekhar.
Then AGA takes notice for respondent number 1.
Number 1 month.
Yes. Issue notice to respondent number 2. You are challenging the award here. Award passed under?
Next year email.
Who is the petitioner? Primary
Society.
Society and the president. Reinstatement was ordered.
Please.
ಯಾವುದು annexure email. It is passed by the JRCS.
Please.
Yes.
Yes.
What is the remedy? KT also.
Please. Annexure Gmail. G.
The second response, second petition is not a authority to communicate the dismissal order. The board has taken a resolution or the resolution based on the inquiry report. The board has taken a decision on the basis of the inquiry report and it gave you a
This respondent number 2 was working as?
president.
What is the
Employer.
allegation?
Employer.
Allegation is
Ma'am, sir.
and also the no due certificate was issued without the authority in favor of one loan holder.
The factual aspect, my lord, page number 56, para number 2, my lord, the KT has discussed.
Page number?
56, my lord, para number 2, my lord. The appellant. Modri. The appellant.
There are 3 charges, one of which one is dropped by inquiry officer since it is true. Whereas 1 and 2 are not action came not categorically reported as finding. The second response, first respondent ARCS will not accept the findings of the inquiry officer on the ground that the witness was not examined. That is not fine. While there is a complaint lodged by account holder, Randaswamy, was an examination in presence of second respondent. It was not cross-examined.
No, in page number 57, para 5.
Hold on.
Order of dismissal passed by the appellate society was set aside by respondent number 1 solely on the ground dismissal order passed by second appellant is not in terms of rule 14A of KCS rules and
Please.
also on the ground without issuing show cause notice, second show cause notice.
Notice was issued on 2/2006. That was not issued by the second respondent. After expiry of 7 days, she sought for time on 10/2016.
What is rule 14A?
14A, the CEO is authorized to
Give a letter.
give the 14A.
Here in this case, president has issued.
Please.
Two technical grounds alla.
Lord. Regarding, my lord, once the report has been passed, my lord, the society's CO is, my lord, is a competent authority. But anyhow, my lord, the second show,
So, irregularity that can be
Please.
cured alwa.
my lord, the respond number 2 should say, my lord.
I'll stay in detail. In the meantime, there shall be stay.
Please.
There shall be stay of operation of the impugned award dated 21/2020, asked by respondent number 1, produced as per annexure E, in next date of hearing. Yes. List after subject.
Serial number 12, A.M. Maheshwarappa.
But notice ಆಗಿಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ.
ಇಲ್ಲ ಆಗಿಲ್ಲ. My lord, respond number 1, 2, 3, and my lord, 5.
GE takes notice for respondent number 1, 2,
3 and 5, my lord. 4, my lord. They are considered by the 4 only here, my lord.
ಎಲ್ಲಿದ್ದಾರೆ? Counsel for the petitioner submits that Shri Rudresh, learned counsel, is representing respondent number 4. Hence, counsel for the petitioner is permitted to serve Shri so and so. Serve the copy of the petition. So ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ನೋಡಿ. ಇದನ್ನು ವಾಪಸ್ ಕೊಡಿ ಅವರಿಗೆ. ಅವತ್ತು ಕೊಡಿ, ಇವತ್ತೇ ಬೇಡ. When will you complete the service? ಯಾವಾಗ? Next month, next week. Friday ಆಗಲ್ಲ ಸರ್, Monday or Tuesday. Next.
Serial number 13, Anil Kumar R. Muhammad Tahir, C. Shankar Reddy.
Yesterday matter, my lord.
Field provision before the CAT.
Let's,
1 minute.
this is,
1 minute, sir.
could you?
Section 46 of.
Section 46 provides for an appeal. Lord's Lordship may kindly take paragraph number 10 of my writ petition. If this is convinces, then I'll, before your Lordships, otherwise I'll have to go back.
ಸೌಹಾರ್ದ ಸಹಕಾರಿ ಆಕ್ಟ್.
ಏನು ನೋಡೋದಿಲ್ಲ ಮಾಡೋದಿಲ್ಲ. Our jurisdiction area entertain ಮಾಡಕ್ಕೆ. They could not have entertained the dispute at all.
Well, then that can be the ground for challenge.
I understand, my lord, that can be a ground,
Yes.
but I don't want to subject myself to the jurisdiction of the authorities under the Savarda Act.
Nothing like that. An appeal against the decision or award made under.
There is an award under section 41. I am not disputing it.
Yes.
Lords may kindly see para 10, my lords, of my writ petition. That is essentially where it lies. Under the provisions of 39(1)(c) of the Act, the dispute which may be referred to the first respondent for decision or dispute in the cooperative society, federal cooperative society or its board or the past board, any other office bearer, agent or employee or any past office bearer or past agent or past employee, or the nominee, heirs or legal representatives of the deceased office bearer, agent, employee or the cooperative or federal society. 39(1) is to be read with 39(2) of the Act. 39(2) of the Act, there is no provision in which a dispute can be filed by a third party or a non-member to initiate proceedings against a society and its office bearers. Only a society can raise a dispute against its office bearers or employees and none else in view of the same. So the dispute is raised by a third party who could not have invoked the jurisdiction under the Act. Your Lordship feels, me not that I should avail the remedy under section 46. There is an interim order pending. Lordship may extend it by 4 weeks, me not, so I'll go before the appellate tribunal. And I will file the appeal within 2 weeks, my lords. Lords may direct the tribunal to consider the matter on merits, because if your lords were to see, the writ petition was filed challenging the orders dated 7/8/2023 by filing this on 5th of January 24, my lords. We were well within the, please.
Senior advocate. ಅದು ಮಾಡಿ ಒಂದು ನಿಮಿಷ. Senior advocate for the petitioner submits that in view of the ground urged in para 10 of the petition, he has filed the petition before this court without subjecting to the jurisdiction to section 46 of Karnataka Soharda Sakari Act. Next. As per para 10 of the petition, it is the contention of the petitioner that the dispute can be filed by the dispute that was filed by a third party or a non-member. It is not permitted under section 39(2) of the Act. If the petitioner is aggrieved by the order impugned, passed under section 39 of Karnataka Soharda Sakari Act, the statutory remedy is available under section 46 of the Act to prefer an appeal. Simply because the petitioner has made out a ground contending that a non-member has raised the dispute, the same cannot be a ground to invoke this court under Article 226 of Constitution of India. Next, learned senior advocate would contend that with reserving liberty to the petitioner to invoke section 46 of so-and-so Act, the petition may be disposed of. He also prays for extending the interim order ಎಲ್ಲಿದೆ ಇರಲಿಲ್ಲ ಇಲ್ಲ. That was never continued. ಇಲ್ಲ 28/10 ಇಲ್ಲ. In view of the above, I proceed to first of all. Petition is disposed of. Reserving liberty with the petitioner to approach to invoke section 46 of the Karnataka Soharda Sakari Act 1997 in accordance with law, if he is advised to do so. Here, what was the interim order?
The interim order was stay of the impugned order. Money award.
Counsel for the petitioner submits that petitioner will approach the appropriate authority within 2 weeks from today. Till that date, there shall be stay of the impugned order. Impugned order, yes.
Serial number 14.
Okay. You take that contention. You can raise the dispute contention before the appropriate authority. Yes.
Serial number 14. Devi Prasad Shetty, Shilpa Rani.
This matter is, my lord, yesterday matter, my lord, posted on next Monday, my lord. To regarding, my lord, society is concerned. They say that, my lord, it is not as a society. But
And file objection, my lord, that article taken by this.
Yesterday's matter.
please.
Why it is listed today?
Lord, it is urgent to the Monday, my lord, actually.
Next Monday.
Please.
ಏನು ಕೇಳುವಾಗ ನಾವು ಅಲ್ವಾ?
That, and also the challenging virus of the act, my lord.
Counsel for responding, please. Yes, list.
Serial number 15
Yes,
urgent,
no,
16.
Monday or Tuesday.
Uttam Basuraju.
My lordship, on the last hearing, I have told that there is a bylaw and amended bylaw. As per amended bylaw, that now, that date. Counsel for the petitioner filed a memo seeking permission to withdraw the petition as the same is rendered infructuous. Memo is placed on record, petition is.
17, Anil Kumar D. Anil Kumar D.
This is a case where your lordship R3 has no role to play. R1 against R1 and R2, the petition is dismissed. It does not survive. Relief is sought for against R1 and R2, your lordship. As against R2, R1 and R2, petition is dismissed.
No steps was taken?
No, it dismissed, your lordship. There is order 9/1/2025.
The conditional order, sir. Week's time is granted.
ಹೌದು ಏನ್ ಮಾಡಿಲ್ಲ.
ತಗೊಳ್ಳಿಲ್ವಾ steps ತಗೊಂಡಿಲ್ಲ R1 and 2 ಗೆ. ಅದಕ್ಕೊಂದು flag ಹಾಕಿ. ಇಲ್ಲ. Counsel for the petitioner is absent, no representation. ಕೊಡಿ. It is noticed that steps not taken to serve respondent number 1 and 2. Order sheet dated 9/1/2025 reads as under. Next, Learned AGA for respondent number 3 submits that respondent number 3 is only a formal party. But the
Relief is sought for against R1 and R2.
Sought against respondent number 1 and 2. 1 and 2, and therefore the petition does not survive for consideration. In view of the above, petition is dismissed as the same does not survive for consideration. Next.
Serial number 18, P.A. Kulkarni, Ayesh Kiran Shetty.
Yes. You are for which respondent? Which respondent?
Respond number 2, madam.
Respondent number 2. Then counsel for respondent number 2 filed as a statement of objections. Proceed. Yes. Yes. R2 allotted a site in your favor. Allotment when? Allotment, date of an allotment idea. ಆಯ್ತು ರೆಡಿಲಿ ಇದ್ರೆ ಹೇಳಿ ಇಲ್ಲ ಅಂದ್ರೆ 8/11/2006. Huh? Okay. The 8/11 is the cancellation. Yes. Then. Say-
After launch of the site in 1999, your last one can you construct a house there and she lives there. Then it's a key in the house, page 36. In 2006, NHLF page 37. They seem to cancel the allotment. By then, site was not there, by then house was there.
Annexure F.
NHLF, page 37. F number 2006, they seem to cancel. NDC page 37, the subject what is it?
Yes.
Just for the user previous civilian, number, what they say is the older members frequency was ignored, and the new members were the site was claimed.
Yes.
Your document I can note that at no point of time, allotment of site in my favor, until construction of the house was challenged by anybody.
When you constructed the house? When you constructed the house?
After 1990,
You obtained the license?
yes, sir.
You have the document.
That's your document, I have produced that document. NHLB is the Bangalore Mahanagar Parishe Khata certificate, page 29. And I pay the taxes also page 31, NHLC. Up to date taxes are paid and 2024, 2025 tax is protected to the NHLC. Then I cleared the society loan also for construction of this building, NHLC. Clearance of the society. E is the house property, page 36. Until 2006, passing of the order 8 November 2006, cancelling my allotment. My allotment was never challenged by any.
Yes.
Nonetheless, by respondent number 4.
Yes.
They were. What the society has done is, by 2 orders, passed on the same day, and 8 November 2006. First order, NHLF case 37, they cancelled my allotment. Society. And second order, NHLG case 39, passed on the same day. They allotted to respondent number 4. Cancellation of my allotment, pending to that case. A dispute came to be raised by me. Page 53, NHLK, your allotment. Dispute number 92 of 2006, 2007.
Page number?
Likewise, this respondent number 4 gets included in this dispute. came to be allowed, and it is held in favor of the petitioner. Your document can see page 21, page 17 is there. Your document is page 23. ವಾದಿಯ ದಾವೆಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ನಿವೇಶನ ಸಂಖ್ಯೆ 240ಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಸಚಿವಾಲಯ ಸರ್ಕಾರಿ ಸಚಿವ ಹೊರಡಿಸಿರುವ ದಿನಾಂಕ 6/11/2008 ಆದೇಶ ಕಾನೂನುಬದ್ಧವಾಗಿರುವುದರಿಂದ ಆ ಪ್ರತಿನಿಧಿ ಆದೇಶವನ್ನು ವಜಾಗೊಳಿಸಲಾಗಿದೆ. The order is passed on 9/9/2010.
Yes.
You are the party. Respondent number 4 was the party to it. You got 50 days.
Yes.
Then you are also pending to pay 74 the next level. Respondent number 4 also raises a dispute. 55 of 2007 to 2008 after my raising the dispute. When he looked into case 74, what he sought there? I will read that 154 are there. ವಾದಿಯವರು ಈ ದಾವೆಯಲ್ಲಿ ವ್ಯಾಕರಣ ಪರಿಹಾರಗಳನ್ನು ಕೋರಿರುತ್ತಾರೆ. ದಾವಾಸ್ವಾಮಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಸಲು ಕೈಗೊಂಡ ಲಸಿಕೆ ಮತ್ತು ಮೂರು ಹಂಚಿಕೆ ಕ್ರಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲಾತಿಗಳನ್ನು ತರಿಸುವಂತಿದೆ. ದಾವಾಸ್ವಾಮಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಸಲು ಮಾಡಿದ ದಿನಾಂಕ 8/9/2006 ರದ್ದತಿ ಮತ್ತು ಮೂರು ಹಂಚಿಕೆ ಆದೇಶವು ಕಾನೂನುಬದ್ಧತೆಗೆ ಸರಿಯಾಗಿದೆ ಎಂದು ತೀರ್ಮಾನಿಸುವಂತೆ. ಇದು ಡಾಕ್ಯುಮೆಂಟ್ ಸೆಕೆಂಡ್ ಮಿನಿಟ್ಸ್ ಆಗಿದೆ. ದಾವಾಸ್ವಾಮಿಗೆ ಸಂಬಂಧಿಸಿದ ಮೂಲ ಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವಂತೆ ಒಂದೇ ಪ್ರತಿವಾದಿಗೆ ನಿರ್ದೇಶಿಸುವಂತೆ ಮತ್ತು ಅದನ್ನು ಕಾನೂನುಬದ್ಧವಾಗಿ ಘೋಷಿಸುವಂತೆ. ದಾವಾಸ್ವತ್ತನ್ನು ವಾದಿಯವರ ಹೆಸರಿಗೆ ನೋಂದಾಯಿಸಿಕೊಂಡು ಒಂದೇ ಪ್ರತಿವಾದಿಗೆ ನಿರ್ದೇಶಿಸುವಂತೆ ತಪ್ಪಿದಲ್ಲಿ ಒಬ್ಬ ಅಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡಿ ವಾದಿಯವರ ಹೆಸರಿನಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಉಪನೋಂದಣಿಕಾರರ ಮುಂದೆ ಕೈಪತ್ರವನ್ನು ವಾದಿಯವರ ಹೆಸರಿಗೆ ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ಆದೇಶಿಸಿದರು. Your document identity just came to be dismissed. Page 80. In 2009 September, this 55 filed by the raised by the Department of Police is dismissed. The reason your document identity page 79. Page 79.
Yes.
The authority refers to a judgment of the Allahabad High Court. Your document identity page 79 down 0%.
Yes.
AS 2002. So Allahabad 400 district paragraph 14. I will read that. In your approximate schedule legal section provide the suit for cancellation of while states are concerned. It has repeatedly held that in such cases the suit as filed before the civil court is legally maintainable, specifically in view of section 31 of the Act, which declares that petition for cancellation of sales can be granted by the civil court only. Relying on that, the authority dismisses the relief sought for by the respondent number 4.
Yes.
In 55. Your document identity 2 formative appeals arise before the tribunal.
Yes.
Karnataka 583 of 2010. Your document identity page 81. It this election.
Hmm.
Respondent number 4 challenges the upwarding of my allotment by the authority in district 92. In cooperative appeal 568 of 2011, government did this. It is filed by the respondent of the society, agreed by the outcome of 92 issue. Both are probably heard together, and by 30th May 2024 hour, your allotment I will see. Page 106, third portion. Page 106. The appeal filed by the appellant and the appellant society, both 583 and 568, under section 105 of the Karnataka Constitution and they are allowed. Consequently, the improved order of first respondent dated 29/9/2010 in dispute 92 is thereby assigned. The matter is demanded back to the first respondent right petitioner for the society with the direction to be binding on the following issues. You understand that?
Yes.
This is now pending before the respondent number 1 right petitioner. Date after date is given there without any progress. And this the respondent number 4 Devra also challenges cancellation of, dismissal of this dispute in 55 by a separate court order in 746 of 2009. Page 111.
No, in 568, what is the appeal? What was challenged?
568. 568 was filed by respondent number 2.
Respondent number?
To society. Challenging upholding of the dispute 92 as in my favor. Likewise, 583 is filed by respondent number 4. Challenging upholding the 92 order.
That is in 746. 746.
No, 746 is altogether a different dispute filed by one of the.
746 page 111 initial M. This dispute raised in 55, respondent number 4.
He is challenging which order?
They separate this thing.
No, which order he is challenging?
55 order. I continue to the 55 order. Annexure K. Dispute 55 order.
Annexure L, my lord.
Annexure L, my lord.
ಹೌದು ಸರ್, ದಟ್ ಈಸ್ ಅಗೇನೆಸ್ಟ್ ದಿ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಹಿಸ್ ಡಿಸ್ಪ್ಯೂಟ್. ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಆಯ್ತು.
Separate cooperative appeal, this connection L, page 111.
Yes.
The cooperative, the appellate party allows this 746 also. And reminds the matter back to the right petitioner. And we see page 129.
Yes.
The matter is remanded back to the first respondent with the direction to give a finding of the following issues. Whether the allotment of site made by the previous candidate of the society in favor of the respondent number 2 show that is myself into the process. Is by overlooking the seniority of the project of law as configured upon, by taking into consideration the seniority which has been prepared, as per the direction of this tribunal, the order dated so and so, which has been affirmed by the Honorable High Court of Karnataka, Bangalore in request number 2489/2015 dated so and so. My number submission to Lordship in these requisitions, I was not a party. Whether the site allotted allegedly in favor of respondent number 2 by the previous management of the society was without any board resolution or proper authorization. Whether the appellant has applied for site belonging to the third respondent society and had paid the entire cycle value prior to the payment of cycle value by the respondent number 2. Whether the site in question still remains as a vacant site or any construction has been performed. After remand, both the cases, NHL Young cooperative appeal order and NHL M cooperative appeal order, after remand, they both are pending before the respondent one so far. At this stage, I am before your process. In respect of the relief law, in this request.
Yes.
My number submission to your lordship is that no challenge was there to my allotment until I construct a house. And only in 2006, the cancellation takes place. Only because the senior members, means the senior members, commonly fighting the litigation before different forums, that their seniority is ignored in allotting the site to their junior members.
Yes.
I was not involved in any of these cases. My allotment was not challenged.
Yes.
In 2006, whether there is a scope for cancellation of that after safety was executed, my submission to the lordship is safety the rightness of the right can only be gone into the civil court. Take the way the civil court should they have filed a challenge plan. So this litigation pending and so far pending from 2006 until this day.
Yes.
Will be disadvantageous to me in every manner. Therefore, I pray your justice that whether the request can be heard and disposed of on final basis, or your justice would be pleased to stay any further proceedings before the joint registrar with reference to the amendment until the request is decided.
1 minute. To the civil court to have the jurisdiction to set aside the sale deed, whether there is a prerequisite, there must be a finding by the appropriate authority, or this will be considered by the civil court. There need not be any finding by the JRCS.
That is unconcerned civil court. Civil court will take legal evidence and everything will be done. But this going up and down is uncontrolled in this case.
Yes. What do you think? You are for respondent number 4.
Society,
3.
In this matters, what has happened is, what has been projected before your lordships is not the correct thing which my learned friend has submitted. About nearly 150 disputes are pending before the joint registrar. The petitioner is similarly placed. If your lordships could kindly appreciate, the impugned order that is challenged before your lordships is the order passed by the KAT in a 105 appeal.
Yes.
My lord, there also nearly 150 appeals were pending. All the appeals were heard together. In all the appeals, my lord, what tribunal felt it was that, my lord, there should be a answer to certain issues and certain questions were framed and it was sent back to the joint registrar for fresh adjudication only on 4 issues. My lord, the petitioner, after having participated in those disputes from nearly 1 year, now comes and files this writ petition. My lord, to that aspect, I'll come at a later stage. Now, what has happened in this particular society is, my lord, the previous committee of management that was functioning prior to 2001 are involved in several irregularities, misappropriation of funds, and certain fraudulent activities, wherein, my lord, the cital deposits were collected way back in the year 1975 from various members for the purchase of property in Chandra layout, that is the Bapuji layout. My lord, amount was collected, lands were purchased from the erstwhile landowners, and thereafter, my lord, BDA makes the bulk allotment in favor of the society. 1996, my lord, there is a work order. As on that date, he is not even a member and he is not even paid any amount. My lord, it is more members have paid the amount out of their funds, this property was purchased.
Yes.
Now, what happens is, my lord, 1996, when work order is issued and layout is formed, this previous president and vice president, my lord, they, without taking the approval from the board, in their individual capacity, my lord, they create certain sale deeds, they issue some fraudulent allotment and possession certificates. Based on that complaint, my lord, there are complaints against the previous president and secretary, which resulted in, my lord, a suo motu inspection by the joint registrar. The joint registrar said, yes, there are fraudulent activities that has taken place in the society. He ordered for a suo motu inspection under section 65 of the Karnataka Cooperative Societies Act. If my lords, may I persuade your lordships to kindly look into my statement of objections, my lords?
Under section?
65 of the Karnataka, 65 of the Karnataka Cooperative Societies Act. Books of accounts were inspected
Yes.
by an officer of the Corporation Department. May I request your lordships to kindly take to my statement of objection, which is now filed before your lordships. Page 64, annexure R3. Well, at the page 63, 65 onwards, 65 onwards is the report. Well, in this report, the inspector who has inspected the books of accounts of the society has clearly given a findings. My lord, the previous committee has misappropriated the funds of the society to the extent of 4,59,69,000. Senior members who had deposited the entire money to the society were ignored. And the petitioners as well as others were not even included as members and they were straight away registered with the site. Now, my lord, all the way my learned friend was stressing upon the sale deed, which is not a sale deed that is executed by the society. That is the first aspect, my lord, I want to canvass on that point. Now, the inspection report's findings is clear indicative that, my lord, there was no board resolution in the society either to include him as the member, either to make an allotment to the petitioner, or either to execute the sale deed in favor of the petitioner. That is a clear findings. Apart from that, what is the findings is, until 1998, all these members, including the fourth respondent who had paid the entire cital value to the society, were ignored. They were not allotted with the site, nor they were registered with the...
So in the inspection report, there is reference to the petitioner also.
Well, because if he claims that he is a member, then it applies to him also.
Yes.
And if he claims that, my lord, he is not a member, then, my lord, his sale deed has to go. Now, my lord, the interesting point is, my learned friend has framed two issues, 2 points in the writ petition. One point is whether a section 70 dispute is maintainable or not. And he says that section 70 dispute is not maintainable. It is he who has raised the dispute before the joint registrar under section 70. If my lords could kindly see. Up to that point, my lord, with regard to maintainability, I will come at a later stage. Now, may I request your lordships to kindly take to my lord, page 74 of my statement of objections. Page 74, or internal page 12 of the inspection report. My lord, in this particular case, what has happened is once BDA makes a bulk allotment, my lord, BDA issues certain conditions. One of the condition is that my lord, the site allotment of site as well as registration of the documents should be as per BDA rules. Because Karnataka Cooperative Societies Act or the Karnataka Cooperative Societies rules does not provide for allotment rules.
Yes.
It is the BDA rules which has to be followed. And my lords are well aware if it is BDA rules are to be followed. My lord, he should have been a domicile of Karnataka. He should have given an affidavit to the effect that, my lord, he doesn't own any site in the entire Bangalore or Karnataka. That apart, the document that is executed should be a lease for a period of 10 years, because at that point of time, my lord, the execution of a lease deed was prevailing at that point of time. The society could not have executed any sale deed at all. That is one aspect. Now, may I request your lordships to kindly look into page 74 of my statement of objections.
But there is a registered sale deed.
No, my lord, it is not a it is a registered document executed by Rajkumar and Rudrachar in their individual capacity.
No.
Because inspection report says.
Is a sale deed.
No, it is not a sale deed. May I request your lordships to kindly look into this document.
What else it is?
Annexure A, my lord, page number 8. In writ petition.
In writ petition,
Sale
page
deed.
18.
Annexure A is the sale deed.
No, my lord, the nomenclature that is given is sale deed, but the contents, the covenants are not that of a sale deed. May I request your lordships to kindly.
To you, what is this document?
My lords,
What is this document?
this is a lease deed. Page 20 may kindly be looked into, my lord. Page 2 of that. No, kindly 21. 21. The covenants may be kindly looked into. In consideration of the above sum of 1,85,000, my lord, this amount is not received by the society. I will make it very clear. 1,85,000 is not paid to the society. That is my first submission. Paid to the vendor, conveys and transfers to the vendee. Site number 241, more fully and specifically described in the schedule hereto, and he is hereby put in possession of the property as full owner, subject to the condition that the vendee shall not in any manner alienate the property to any person for a period of 5 years from this date. In case of vendee interested to sell the property within 5 years of lease period, your lordship, this is very important. Within 5 years of lease period, the no objection society from the vendor has to be executed. First of all, if your lordships could kindly look into this document, there is no reference to a board resolution which authorizes the president and secretary to execute a document. There is no reference even to an allotment. There is no reference even to a possession certificate. And there is no reference to the payment details as well. But this is not the way anybody can execute a sale deed. And inspection report clearly indicates that, my lord, there is no resolution from the society at all to execute any sale deed or make any allotment. If that is the case, my lord, it cannot be treated as a sale deed at all. For that reason, my lord, this honorable court permitted us to cancel the allotment. My lord, based on this inspection report, if your lordships could kindly, I request your lordships to kindly take my statement of objections. My lord, the statement of the inspection report has given the clear picture what transpired in the society, how, my lord, the previous president and secretary manipulated things,
Yes.
and for which he is also party.
Yes.
May I request your lordships to kindly take to 70.
There is a report in your favor.
Yes, report in our favor. Based on this report, my lord, 68 order was passed, directing the then committee to comply. My lord, 68 order also indicates that, my lord, all these sites are illegal. And they were directed to, my lord, allot the sites in favor of the senior members and genuine members who have deposited the amount. They doesn't do that. My lord, section 69 order is passed. Their properties are attached. The previous president and secretary's properties are attached. Board was superseded in the year 2001. Section 30 direction is given. In the direction also, my lord, all these irregularities which is committed in the matter of allotment of sites and registration of these documents are concerned, the society was directed to rectify the mistake. When the board was superseded, my lord, there was an administrator who was appointed. Administrator has verified all the list, seniority list, etc. And thereafter, my lord, in the year 2004, the new committee was formed. That was, and while, my lord, new committee was formed, this honorable court has given a clear direction in the writ petition that whatever the mistakes that has been committed by the previous board, that has to be rectified by the present board. That is, at that point of time, my lord, we have issued the show cause notice to the petitioner and along with all other illegal allottees as to show why these allotments should not be cancelled, because the society documents does not indicate any reference with regard to the payments made. The society documents did not indicate any membership details.
Yes,
And when such is the case, why these sites should not be cancelled is the show cause notice contents.
yes.
Thereafter, my lord, they approach this honorable court. This honorable court, my lord, if at all my show cause notice is illegal or if I am not authorized to cancel the allotments, society, the writ petition would have been straight away allowed. This honorable court has not done so.
A petitioner has approached this court.
Yes,
WP
even
number?
petition, my lord, it is a common order. If your lordships could kindly.
Next year.
My lord, annexure J, page 45. Of the writ petition, my lord. May I request your lordships to kindly turn to page 50, my lord, 50, paragraph 7 onwards. Paragraph 7. In the light of the submissions made by the learned counsel appearing for the parties, as stated above and having regard to the facts and circumstances of the case, without going into the merits or demerits of the petitioner's case, these petitions filed by the petitioner stand disposed of with the directions, in the following directions. The Bapuji Cooperative Society is hereby directed to issue show cause notices to these petitioners within 4 weeks from the date of receipt of this order. All the petitioners herein are permitted to file objections, reply to the show cause notices to be issued by them within 4 weeks from the date of receipt of the show cause notices from the society. The Bapuji Cooperative Society is directed to consider the reply objections to be filed by these petitioners pursuant to the show cause notices to be issued by it and take appropriate decision in the matter in accordance with law after affording an opportunity to these petitioners. Further, the society is directed to issue show cause notices to the impleading applicants also. Further, it is made clear that the society shall take independent decision in the matter without being influenced by the impugned communication dated 23/6/2005 issued bearing number so and so issued by the additional registrar of cooperative societies. My lord, this order is based on all these inspection report, which is, my lord, the order which is referred by this honorable court is, my lord, the additional registrar has clearly directed the society to cancel all these allotments. So that order then along with the communication was challenged before this honorable court. This honorable court said, all right, if there is a report, you keep it aside, you take an independent decision. But when we were taking the independent decision, my lord, if he claims to be the member of the society, if he claims to be the allottee, if he claims to be the holder of a sale deed, he should have produced the document before the society along with the reply.
So these in view of these directions, the notice was issued.
Yes, it is the 8/11/2006 notice. Cancelling the allotment was made by the society pursuant to these directions. And thereafter, my lord, they once again approached this honorable court, challenging that 8/11/2006 communication. This honorable court said, yes, society has done this. You raise a dispute under section 70. My lord, they raise a dispute under section 70.
Which was that petition?
My lord, that number, my lord, I can provide that. My lord, it's a simple order stating that there is an alternative and efficacious remedy. My lord, my learned friend's contention that they ought to have approached civil court. My lord, this honorable court has nullified that, stating that no alternative remedy is under section 70 and not before the competent civil court, because that was not a sale deed at all. My lord, during the period of lease, society is the owner of the property. My lord, I can make allotment, I can cancel allotment, I can re-allot it. That is the prerogative of the society, and they cannot contend that it is a sale deed. So for all these reasons, my lord, if at all sale deed, if it all it was a sale deed and I ought to have approached the civil court, my lord, he would not have kept quiet for 20 years. It is 8/11/2006. It is 20 years now. Now, thereafter what has happened is, my lord, in section 70 dispute, their contention was the same contention, stating that there is a sale deed, it cannot be cancelled. So this fourth respondent, who is a member, even though society has not raised any dispute, they said, all right, if they say that there is a registered document, cancel it. They raised another dispute. Those two disputes were clubbed. my lord, orders were passed. That is the subject matter of before the Karnataka Appellate Tribunal in various appeals. My lord, may I make one submission at this stage? My lord, if any order is passed in this particular matter, my lord, it will affect nearly 150 disputes. That is one aspect. Petitioner having participated along with them before the joint registrar. My lord, yesterday, day before yesterday, also the case was there on Saturday. He participated. The petitioner participated in the proceedings. The joint registrar is taking up the matter on day-to-day basis because he has to comply the directions of the KAT. So what KAT did is, my lord, we argued during the course of argument, my lord, a fresh seniority list was brought into picture, and that too, that seniority list was prepared on the basis of the directions of this honorable court, which is approved by this honorable court.
Yes.
My lord, what KAT said is whether the name of the petitioner finds place in that list or not. And based on that, you just reconsider it, framing 4 issues. My lord, the 4 issues has to be now answered by the joint registrar. And based on that, my lord, KAT will take appropriate directions. If that is, my lord, if he is agreed by that, that too after 1 year he comes and says, now my lord, I can understand if at all he raises he comes and says that dispute is pending from last 1 year, kindly issue a direction to dispose it off expeditiously, I can understand. My lord, he challenges the order of 8/11/2006, that communication, the orders various passed from that particular date. And now he challenges this KAT order after 1 year.
No, KAT order, remanding the matter?
Remanding 2004 order, my lord. Now he is coming and challenging it. Your lordships would kindly see. 2024 20th September 2024. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, not only this matter, my lord, in respect of all the members similarly placed, KAT has passed the similar order. ಇದರಲ್ಲಿ ಏನಾದರೂ disturb ಆದರೆ all matters, my lord, will be affected. If my learned friend is aggrieved, let there be a direction to the joint registrar to expeditiously dispose of the dispute.
Yes, yes.
ಅದನ್ನ ಮಾಡಬಹುದು. ಅಲ್ಲ ಮೇಡಮ್ ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು, ಆರ್ಡರ್ ಆನ್ ಮೆರಿಟ್. ಈಗ ನಾವು ಆಲ್ರೆಡಿ ಅವ್ರದ್ದು ಮುಗೀತು, ನಿಮ್ದು ಹೇಳಿ.
ಅಲ್ಲ ನಂದಿನ್ನೂ ಮುಗ್ದಿಲ್ಲ. ಐ ಹ್ಯಾವ್.
ಎಸ್.
It's not a sales data. The after countries need to take actually.
Yes. Yes.
Second paragraph, you are looking at see. The first and second paragraph.
Why there is reference to the 5 years lease? Why there is reference to 5 years lease?
Page 21.
It's for only purpose of selling, not selling.
No, why?
Not lease.
When it was leased in your favor, was there any lease deed? Whether earlier it was leased in your favor?
No.
Then why the word 5-year lease?
Kindly see that the case what has happened in litigation.
Yes, yes.
In consideration of the above sum of 1,25,000 paid to vendor, again transfers the vendor. The site to follow more police also, and he gave a 14% of the property as full owner, subject to condition that the vendor shall not in any manner allocate the property to any person by the fine.
Lease.
ಅಲ್ಲ ಮುಂದೆ ಓದಿ. 5 years lease period.
Within 5 years of lease period, there is no offense certificate from the vendor.
Why lease period? Why lease period in a sealed deed?
Only refers to, kindly look into the sentence you will get. He should not sell the property to any person within a period of 5 years. In case the vendor intended to sell the property within 5 years of this period, the no objection certificate from the vendor shall be required. Means that period refers to.
Whether you have paid rupees 1,85,000?
Yes, sir.
How you paid it?
I paid by cash.
Cash?
Yes.
And that too, there is not, the society's books of account doesn't indicate his payment as well.
I paid by cash. I will tell you that. I will not my solicitor. I will answer.
Why there is no reference to allotment of site why there is no reference to the resolution?
No, I agree with it. What I submit to the assistant question is, this stated may be not to the requirements of legal scrutiny. That may be another thing. There exists a registered certificate is my submission, first submission.
I,
And that registered certificate is executed not by XYZ.
see, all these days you participated in the proceedings before the JRCS. Yes, he will take a decision according to him about 150 such disputes.
Before the government was happy,
Hmm.
you have to kindly see. I have read it before your 92, 99,
Yes.
92. That dispute raised is very smart. Against cancellation of site in my favor.
Correct.
Not that this thing, but saving, what about saving favor?
Why you kept quiet for more than 1 year after KAT passing the order? See, after KAT passed an order, you continue to participate in the proceedings before JRCS.
And he has,
After 1 year,
and he has led further evidence as well.
Allah, you participated, no merit.
My submission to Rashid is kindly hear.
I
have, as far as saving is concerned, the language employed therein refers to the non-alienation clause of 5 years,
Yes.
not that lease period. Word language employed lease was mentioned is only non-alienation clause 5 years. It should be understood in that way.
Yes.
And it is executed by two persons who were then holding the affairs of the society and they have executed it not on in their own behalf,
Yes.
on behalf of the society only.
Hmm.
That language employed is very clear in that way. That the society,
Hmm.
I will read that. Please so and so, so and so. They are not to call the vendor.
I have looked into.
It includes the society.
Yes.
Therefore, not that the two individuals execute
Yes.
the saving by
Yes.
the one.
Yes.
It is the society executing the saving.
Yes.
So that first person is not a saving at all in the law. He is not correct submission in my submission.
Yes.
Next is maintenance of dispute issue. What my recommendation is, after having submitted to the jurisdiction of the cooperative authority,
Yes.
raising the dispute of entity.
Yes.
Now he can't make this in a repression is my argument's second question.
Yes.
My submission to your lawsuit is that I have raised a 92 dispute. Correctly, I have raised because my cancellation of site was taken place.
Yes.
And that is the dispute only.
Hmm.
The legality and correctness of the saving is not the question involved there.
Yes. Now also it is only remanded back. It is the continuation.
My submission to your lawsuit is in presence of the saving and in presence of my concern.
See, the order passed in the dispute was questioned before KAT. KAT remanded the matter before.
Only for a limited purpose of answering 4 issues.
Yes, 4 issues were framed and asked to answer that. It is continuation of the dispute. It is nothing new there.
And my other third point raised is annexure J, the order of this court. My other friend is referring to. In that, you are also kindly look into what is stated there by this court. It is not that my saving was in question before the lawsuit.
Yes.
Kindly look into that. Annexure J, the order question. For a second. Paragraph 7, page 30. Page 59.
Yes.
All that is stated there is, I will read that paragraph 7.
Hmm.
So, this honorable court has not gone into the question of legality of a saving or anything.
Yes.
It is a general order. In the light of the submission made by London Council appealing from the party, as stated above, and having regard to the fact of the case, without going into the merits or demerits of the petitioner's case, these sections filed by the petitioner stand dispose of the common match.
I,
Only directions are issued, so and so is done.
yes.
Therefore, my submission to Rashid is, the question before your office in the instant represent is, in presence of a mandate saving, whether cooperative authority has any jurisdiction to deal with the matter.
Sir, when you have already submitted to the jurisdiction of the authority, no, nothing. Sorry. Or, yes, writ petition dismissed. Reasons to follow. Policy work. It is pinning on policy. Huh?
ಇದನ್ನು ಕೊಟ್ಬಿಡಿ ರವಿ ಒಳಗೆ. ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಫೈಲ್ಡ್ ಇನ್ ದ ಕೋರ್ಟ್ ಅಂತ ಬರ್ತಿದ್ದೀವಿ. ರವಿ ಇದನ್ನು ಕೊಡಿ. ಇದೆ. ನಾವು ಬಿಡ್ತೀವಾ? ಬರ್ತಾ ಇದ್ದಾರೆ. ಒಬ್ರು ಬರ್ಬೇಕು ಅನ್ಸುತ್ತೆ. ಸೌಮ್ಯ ಇವ್ರು ಬಂತು ಗಣಪತಿ ಇನ್ನೊಬ್ಬರೇ ಬರ್ಬೇಕು. ಯಾರು ಇವತ್ತು ಇವಾಗ ಇದೆ ನೋಡಿ ಸೈಲೆನ್ಸ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಹೋಗೋರನ್ನ ಮೊನ್ನೆದು ನೀವು ನಿಮ್ಮ MK ನಿಮ್ಮ ಅಣ್ಣನೇ ಸುಮ್ಮನೆ ಬೇಡ ಅದಕ್ಕೆ ನನಗೇನ ಕೊಲ್ಲಿಂಗ್ ಮಾಡಲ
Continue.
This one serial number 19, Lokesha DS.
There is something called as legislative council Kaga Patragala Samiti. They have at various instances notices issued by the registrar saying that I have to give the details of the properties which are required, payments received at the sites allotted payment for 20 years.
Who is the petitioner?
But the petition to society, it's a cooperative society. But there is no statutory basis. Under the scheme of the statute, they are regulated. They are not answerable, otherwise they are by the statute. Not that all and sundry can ask us to send the details or the requirements. There are statutory provisions which they can invoke and they can push. But as I submitted, the powers of the registrar is
No,
very
what is sought in this?
First, can you have a look at page number 15?
My lord, before going to matter, my lord, this is Society Registration Act, my lord. Kindly see, my lord, page 5 of the petition.
Not cooperative society?
No, my lord. The petitioner admits that, my lord, is registered under society.
No, annexure A was issued by?
Page 5, my lord, fact of the case ಅಂತ ಹೇಳಿದ್ದಾರೆ. First line ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ.
No, the annexure A was also issued by?
Society, my lord, but the designation is same.
ಸಹಕಾರ ಸಂಘಗಳು.
Please. To regarding, my lord, the facts say that Society Registration Act ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು. Whether, my lord, they will
correct ಮಾಡಿ ಅದನ್ನ. Lords, may kindly have a look at page 15. What is that they have asked? Karnataka Dura Samparka Naukara Sangha Niyamita ಗೃಹ ಪತ್ತಿನ ಬೆಂಗಳೂರು ವತಿಯಿಂದ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಂಡಿರುವ ನಿವೇಶನಗಳನ್ನು ಕೋರಿ 2006ನೇ ಸಾಲಿನಿಂದ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ನಿವೇಶನದಾರರ ವಿಳಾಸವಾರು ಸಂಪರ್ಕ ಮಾಹಿತಿ ನೀಡುವುದು. ಕರ್ನಾಟಕ ದೂರ ಸಂಪರ್ಕ ಇಲಾಖೆ ನೌಕರ ಸಹಕಾರ ಸಂಘ ಸೋ ಬೆಂಗಳೂರು ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ 2006ನೇ ಸಾಲಿನಿಂದ ಸಹಕಾರ ಸಂಘದ ಕಾಲಕ್ಕೆ ನಿಗದಿಪಡಿಸಿದ ಶುಲ್ಕ ನಿಗದಿಪಡಿಸಿದ ಕಾಲಮಿತಿಯಲ್ಲಿ ಪಾವತಿಸಿ ಸುಮಾರು 20 ವರ್ಷಗಳ ಕಳೆದರೂ ಇದುವರೆಗೂ ನಿವೇಶನ ನೋಂದಣಿ ಮಾಡದಿರುವ ಪ್ರಕರಣಗಳೆಷ್ಟು? ಈ ರೀತಿ ನೋಂದಣಿ ಮಾಡಿಕೊಡಲು ಇರಲು ಕಾರಣಗಳನ್ನು ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ಒದಗಿಸುವುದು. ಈ ರೀತಿ ಪಾವತಿಸಿರುವ ಸುಮಾರು 20 ವರ್ಷಗಳಾದರೂ ನಿವೇಶನಗಳನ್ನು ನೋಂದಣಿ ಮಾಡಿ ಸಾರ್ವಜನಿಕರಿಗೆ ತೊಂದರೆ ನೀಡುತ್ತಿರುವ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಕೈಗೊಂಡ ಕ್ರಮಗಳೇನು? ವಿಳಾಸವಾರ ಸಂಪೂರ್ಣ ಮಾಹಿತಿಯನ್ನು ನೀಡುವುದು. Where do they get all these powers from? There should be a statutory basis for me to answer because I am regulated under the scheme of the act. There is no provision mentioned in the entire act, and this is an information if they want. There are other provisions which they can invoke. Even to invoke those provisions, the principle of reasonable time applies. They cannot say for 100 years you give me the information. For 20 years.
AG takes notice for respondent.
Notice
1 to 3. 1 to 4.
Please.
Agida. Under what provision we are?
Regarding, my lord, this is, I think, my lord, I will take instructions on tomorrow itself, my lord. The similar matter, this honorable court disposed matter to regarding the paper-led committee has not.
Leonard AG takes for respondent number 1 to 4 place for a day's time. This tomorrow.
Please.
Serial number 20,
Vijay Kumar, P. Anand, Anusuya Devi.
Krishna, on the last occasion, my learned friend have produced a resolution passed by the bank, Lord, with regard to Lord, the recovery. Lord, the petitioner, Lord, is Lord one of wife and son of the deceased employee of the PLD bank. Lord, during his service period, Lord, there
Now,
was
what
some
is your instructions now?
my instructions, Lord, so they have
You are not ready for 7,50,000.
some sort, Lord, because
Argue on
only
merits.
only one submission.
Argue on merits.
Only one submission. This honorable court, coordinate bench of this honorable court, my lord, suggested for settling the matter.
Yes,
Six
they are
lakh
not
rupees.
ready for that.
I leave it to your lordships. I'm
cannot
not, my lord, saying, because, my lord, only submission is, my lord, the son, my lord, who is serving in the bank now, on the
Here-
compassion
here when
appointment,
the
he has
court-
been,
Here, when the court sits, we can only adjudicate. It is not conciliation, it is not
correct, my
mediation,
lord,
it is
correct.
not.
I bow down to your lordship's observation.
You are right. Somewhere we sit as a conciliators.
Yes, my lord.
Or as a mediators. We
Please.
can pursue them. Please consider that. Even in spite of that,
May I-
last date,
may
I
may
asked
make-
them.
May I make a request? Ma'am? Matter may be referred for some
No,
conciliation or mediation where, but he is all, ultimately, my lord, he is serving the bank itself.
Sir,
Lord,
only if both the parties agree, not otherwise.
I'll
Then
request my learned friend,
Alternative dispute resolution is with the consent of both parties.
please, my lord.
Not
please.
at the instance
I
of the
understand,
court.
I understand. I'm just requesting my learned friend, it can be
You have to request
referred.
earlier, sir, not before this court.
No, my lord.
ಇಲ್ಲಿ ಬಂದಾಗ drama ಮಾಡಿ
ಇಲ್ಲ, ಇಲ್ಲ,
requesting.
ಹಾಗೇನಿಲ್ಲ.
Why should
I heard
create
Mr.
party?
Anand is not here today.
ನಿಮಗೇನು strangers ಅವರಿಬ್ರು?
ಇಲ್ಲ, ಇಲ್ಲ, Anand I regularly meet him.
station.
He is not in station, therefore.
ಹೌದು. What prevented you? ಮೊದಲೇ ಒಂದು ಫೋನ್ ಮಾಡಿ ಏನೋ ಕೇಳ್ಬೋದಲ್ಲ ಅವರಿಗೆ? ಅದಿಲ್ಲ, ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ್ಲೇ ಇವೆಲ್ಲ. ಏನೋ ನಾವೇನೋ ಮಾಡಿದೀವಿ ಅಂತ. No progress.
No progress, I understand. ಅಲ್ಲ, ಏನೋ ಒಂದು
ಏನೂ ಇಲ್ಲ.
ಸೆಟಲ್ಮೆಂಟ್ ಹೆಂಗೂ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಬಟ್ ಇಟ್ಸ್ ಆನ್ ದ ಹೈಯರ್ ಸೈಡ್. ಸ್ವಲ್ಪ ಏನಾದ್ರು ಕಡಿಮೆ ಮಾಡಿ ಮಾಡಕ್ಕಾದ್ರೆ ಅಂತ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್
Please go ahead. Argue on merits. 2018 matter. ಇನ್ನು ಎಷ್ಟು ದಿನ ಇಟ್ಕೊಳ್ಳೋದಿದೆ? ನೀವು ಒಂದೇನು ಹೇಳೋದು, ಅವ್ರೊಂದೇನು ಹೇಳೋದು, I'll consider ಅನ್ನೋದು, I'll
ಇಲ್ಲ,
take
ಇಲ್ಲ.
instructions ಅನ್ನೋದು.
I'll leave it to your lordship.
Ultimately, the petition will be pending. For what purpose?
I'll consult my learned
No.
friend and maybe call tomorrow only.
What prevented you from consulting?
Lord,
I'm asking you. See, the submissions of both sides.
I understand.
Heard it.
I understand.
ಇವತ್ತು ಬಂದು ಇಲ್ಲಿ ಏನ್ ಮತ್ತೆ ಅದನ್ನ ಹೇಳೋದು?
One last chance tomorrow ಅಂತ ಕೇಳ್ಕೊತಾ ಇದ್ದೀನಿ.
ಏನ್ ಸ್ಟ್ರೇಂಜರ್ಸ್ ಇದ್ರು ಈ ರೀತಿ ಮಾಡಲ್ಲ.
I understand, my lord. ನಾಳೆ ಹಾಕೊಂಡ್ರೆ
As if ಏನೋ ತಾವು ಕೋರ್ಟಿಗೇನೋ ಫೇವರ್ ಮಾಡಿದಿರಿ ಅನ್ನೋ ರೀತಿನಲ್ಲಿ ಬಂದು ಇದು ಹೇಳಿದ್ರೆ what is to be done?
kindly have it tomorrow.
I'm here to adjudicate, not to advise anybody.
Please, my lord, I
Yes.
understand, Lord. I'm not.
If you want, you argue the matter. Otherwise, petition will be dismissed. Just the only two options are.
ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರೆ
ನಾಳೆ ಹಾಕಲ್ಲ ಸರ್, ನಾಳೆ petition day ಅಲ್ಲ. It will not be posted tomorrow.
any convenient day, my lord, so that I can, Lord, my client says, my lord, he is ready for settling the matter, but my lord, the only thing is, my lord, it's on the higher side. That is the reason, my lord, we are just requesting the bank to look into it once again, and if anything is possible, Lord.
Counsel for the petitioner, again please for time. Even though he is not agreeable for settling the dispute for rupees 7,50,000 as suggested.
I'm only requesting, Lord.
Counsel for respondent number 1. Under such circumstances, do not find any reason to adjourn the matter, which is of the year 2018. However, to afford one more opportunity, list finally as a last chance. Next.
List 2, serial number 1, C.B. Sandesh, H.N. Basuraj, K. Anand.
I have just now received the pleading application, my lords.
That the cast title in the petition may kindly be seen.
I pray for,
Respondent number 7 and respondent 11 both are one and the same. I don't know why they have added twice, I don't know. I filed the wakalat for R7 and objection also. By inadvertence, my lord, it is somehow mistake have taken place, 7 and 11 like that. Therefore, I am filing a memo. ನಾನು appear ಆಗ್ತಾ ಇದ್ದೀನಿ. 7 and 11 both are one and the same.
The memo of your file.
Memo, my lord. Seeking leave of your lordship to treat that objection filed on behalf of respondent number 7. Both are one and the same.
Counsel to the petition, respondent number 7 filed a memo stating that respondent number 7 and 11 are one and the same. Statement of objection filed by respondent number 7.
ಯಾರಿಗಾಗಬೇಕೀಗ?
Statement of objection on behalf of respondent number 11 as well. Memo is placed on the
Since they arrived twice, my lord, notice to R7 had to be valid for R11 also. Both are one and the same. Await notice.
In view of the above, notice to respondent number 11 is held as sufficient. And so and so represents respondent number 11. Yes, impleading yaar application.
I appear for the impleading application.
Where is the application?
Really, I am connected to one of the content.
Objection.
I have received.
Applicant has filed A1 of 2025 seeking impleadment as one of the respondents. Counsel for the petitioner prays for time to file statement objections to the said application. List down. Yes.
One submission. I moved the matter yesterday. Not in view of the interim order granted in this honorable court, the election was held on 26/6/2025. The petitioner is with the permission of this honorable court, he cast his vote. It is kept in separate box. Therefore, my lord, the respondent number 5 may be permitted to declare the result. Then already the petitioner hearing filed a dispute petitions before the joint registrar.
ಇಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಾರೆ. ಐ ಪ್ರೇ ಫಾರ್ ಟೈಮ್ ಆರ್ ಪಾಸ್ ಇಲ್ಲ ಹಾಗಲ್ಲ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ದೇ ಹ್ಯಾವ್ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಡೆಲಿಗೇಷನ್ ಆಫ್ ದಿ ಮೀಟಿಂಗ್ ರೆಸೊಲ್ಯೂಷನ್ ಆಫ್ ದಿ ಡೆಲಿಗೇಷನ್. ಹಾಗಾಗಿ ಅಲ್ಲ ಇದರಲ್ಲಿ ನಾವು ಪಿಟಿ.
What is this impugned order 29/4/25?
In the section 70, they have passed an order restraining not to vote in the election. My lord.
Interim order challenge, my lord. Kindly see annexure.
Pending dispute, interim order granted 30.
Initially, the petitioner society is in eligible voter list, my lords. In view of the.
Now the election is itself is already complete.
Senior counsel.
Pursue the matter.
Pass or minutes. Pass or minutes. Pass.
In a similar matter, this honorable court disposed the matter with the direction to the.
Paso. Noted.
Serial number 2, Satisha DJ.
Not sapient. Not the impugned order under challenge. Not the first response. The at page number 65, the impugned order passed by the Deputy Registrar of Cooperative Society. Page number 65. 65. But the facts is where the petitioners paying the borrowers to the amount from the first respondent way back in the year 2012. Well, in the 2014, the one-time settlement offer has been given by the first respondent. Thereafter, in the year 2014 itself, there are 9,50,000 is already filed, already paid to the full and final settlement. And thereafter, the dispute has been raised before the Joint Register of Cooperative Society filed by the first respondent way back in the year 2020-21. And in the observation made in the Joint Register, absolutely there is not any reasoning. There is no opportunities given to before passing the order in the impugned. Will you kindly see page number 66. That is only referring the exhibits which was marked, and thereafter only one sentence may permitted to read. That kindly last bottom second paragraph. ಪೇಜ್ ನಂಬರ್ 66 ಅಲ್ಲಿ. ಪ್ರತಿವಾದಿಗಳಿಗೆ ವಾದ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು, ಪ್ರತಿವಾದಿ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು ಮತ್ತು ವಾದವನ್ನು ಮಂಡಿಸಲು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದು, ಪ್ರತಿವಾದಿಗಳು ಸಾಕಷ್ಟು ವಾದಿ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು, ಪ್ರತಿವಾದಿ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು ವಾದವನ್ನು ಮಂಡಿಸಲು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ವಾದಿ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು, ಪ್ರತಿವಾದಿ ಸಾಕ್ಷ್ಯ ಪಾರ್ಟಿ ಸವಾಲು ವಿವಾದಾಂಶ ಇರುವುದಿಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ವಾದಿಯವರು ತಮ್ಮ ವಾದಿ ಸಾಕ್ಷ್ಯವನ್ನು ವಾದವನ್ನಾಗಿ ಪರಿಗಣಿಸಿ ಕೋರಿರುತ್ತಾರೆ. ಇದರೊಂದಿಗೆ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿ ಆದೇಶಕ್ಕೆ 19/5/2022 ಅನ್ನು ನಿಗದಿಪಡಿಸಲಾಯಿತು. ಈ ಮೇಲೆ ಎಲ್ಲಾ ಅಂಶಗಳ ಗಮನಿಸಲಾಗಿ ದಾವ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಲು ಯೋಗ್ಯವೆಂದು ಸೋನ್ಸು. Absolutely there is not at all any reasoning given and also
ರೀಸನಿಂಗ್ ಏನ್ ಸರ್ ಮೇಲೆ ಹೇಳಿದಾರಲ್ಲ ಕಂಟೆನ್ಷನ್ಸ್ ಏನು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
In the said dispute, I filed a statement of objection and thereafter is not given any opportunity to lead the evidence and cross-examination.
Not led any evidence.
ಅಲ್ಲ ನಾನ್ ಮಾಡಿಲ್ಲ, ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಯಾಕೆ ಮಾಡಿಲ್ಲ? ಅವ್ರು ಮಾಡಿದ್ದಾರೆ. Exhibit P1 to 12 or mark.
Please.
Then
there is no opportunity is given before passing the order, and also the KT, the appeal preferred by the Karnataka Appellate Tribunal is also confirmed by the
ಮಂಡಿಸಲು ವಿಫಲರಾಗಿದ್ದಾರೆ. Even you have not addressed your argument. ಇಲ್ಲಿ ಬಂದು ಇದು ಮಾಡ್ತಿದ್ರಲ್ಲ.
In the section 13(9), dispute has been raised before the registrar only. His impugned order came to be passed by the deputy registrar. Deputy registrar is only for supervision and authority to
you have paid the amount in under one time settlement.
My statement, friends.
ಅದನ್ನ ಯಾಕೆ ಎವಿಡೆನ್ಸ್ ಯಾಕೆ ಮಾಡಿಸಲಿಲ್ಲ?
ಅದು is not given, not the documents has been. Kindly see for a moment, kindly paragraph number 2, page number 48 and 48. My statement.
ಯಾಕೆ ಎವಿಡೆನ್ಸ್ ಯಾಕೆ ಮಾಡಿಸಲಿಲ್ಲ? If that is the case, if you have already paid under one time settlement, what prevented you from producing and leading evidence?
On that day,
on that day ವಿಫಲರಾಗಿದ್ದಾರೆ. Even ವಾದ ಮಂಡಿಸಲು ವಿಫಲರಾಗಿದ್ದಾರೆ.
Then only for 2 occasions, my lord, the quoting to the.
ನೀವು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ, fresh matter.
Respondent number 2 only.
AGA takes notice for respondent number 2. Issue notice to respondent number 1
and 3.
1 and 3.
3
ಯಾರು?
3 my lord.
2 ಇಲ್ಲ, only 2.
2 ಇದ್ದಾರೆ.
Please.
Deputy registrar.
Issue notice to number 1. Yes, next.
Cell number 3.
List after service of notice.
Narasimha Rajesh, DP Shetty.
For the petitioner, my lord. What is this annexure D and E? Why certificate copy is not produced?
D and E. E is the writ petition, my lords. We are not challenging that. We are not challenging that, my lord. We are challenging the annexure F, my lords.
No, what is annexure D? What is annexure E?
Annexure D is the IA orders on IA, my lords. Those are the orders. In this, my lords, the tribunal has passed IA on orders on IA number 3, which is contrary to the orders on.
What is the impugned order?
Impugned order, my lords. It is in page number 79, my lords. They have rejected the IA, my lords.
Okay.
Earlier, my lords, on IA number 1, which is in page 47, my lords. IA number 1, which is allowed.
Yes.
Earlier, my lords, in IA number 1, we seek for the stay of the resolution meeting dated 23/8/22, my lords, and it was allowed, my lords. The observation made are noted in page number 47. May kindly see. May, my lords. We have examined the documents on record. The merits of the appeal can be decided only after securing the trial court records as the issue if the appeal involve both the provisions of the law and veracity of facts. However, at this stage, since the society may take steps to fill up the vacancy of the appellant's post of directorship in the society, it is only just and proper that relief by way of staying further action in this regard is given to the appellant. Otherwise, if the said vacancy is filled before the adjudication of the appeal, the purpose of filing the appeal will be defeated, my lords. This is the observation made on IA number 1, my lords. And then, my lords, on the order was passed on 21/2, my lords. The arguments was heard on 19/2, my lords. On the same day, the society has passed the resolution by co-opting the third respondent in the place of petitioner, my lords. Arguments on IA was heard on 19/2, my lords.
Now you are impugning F.
Please.
What is the order?
My lords, Annexure F.
Interim application filed by the applicant under 13.
Earlier, my lords, Annexure F, my lords, IN orders on IA number 3, my lords.
Who filed this application? You filed that.
Yes, my lords.
Why?
My lords, we are seeking the stay of the
Resolution and my lord, the co-opt member, my lord.
Seeking the stay of the co-opting, which is in Annexure C, my lords. Earlier, my
That application?
my lords.
Have you produced that application?
Yes, my lords. In
Your
Annexure,
application was rejected by KAT.
yes, my lords.
What
Before, my lords, it was allowed, my lords. Before it was allowed, and
No, what is the prayer? Where is the application? Copy of application.
It's in Annexure D1, my lords, page 48.
48.
So, order sheet.
This application, I think.
Application.
This is the order sheet, alva.
Application is not filed.
And the orders on IA number 3 is in page number 52, my lords.
Right, sir. Here, this is the order on your application.
Yes, ma'am.
What was the prayer in your application?
Prayer, my lords, it can be seen in page 52, my lords. Seeking.
The application is not produced.
Yes, my lords. The application was for seeking the stay, my lords, of co-opting the resolution passed on 19/2/25.
They sought to stay the operation and implementation of resolution number 3 passed by respondent number 1.
Yes, my lords. It was also stayed, my lords. And you can see the observations made in page number 50, my lords, last para. My lords.
Page number?
50, my lords.
15.
Observation while allowing this application, my lord.
Then why again application was?
Again, my lords, they have the third respondent challenged this order before this honorable court, my lords. And before this honorable court, it can be seen in page 58, my lords, the reasons. Para 18, page 58, my lords. The respondent number 3 had challenged the order passed by the respondent number 1 in so and so under section 39 of the Act 1997 before the tribunal in appeal 35 of 25. Respondent number 2 herein the society was represented before the tribunal when IA number 1 was taken up for consideration. Even after that, they have passed the resolution dated 19/2/25 by co-opting the third respondent. And then, my lords, the fact that the application was heard and the matter was reserved for the orders on IA number 1 was known to the respondent number 2 cannot be disputed, my lords.
Yes.
And my lords, if that be so, the action of the respondent number 2 in co-opting the petitioner as director in the place of the respondent number 3 had to be examined by the tribunal. The tribunal was therefore right in allowing the petitioner to be impleaded by allowing IA number 2 insofar as staying the resolution number 3 dated 19/2/25 passed by the respondent number 2 society, whereby the petitioner herein was co-opted as director in the place of respondent number 3 herein. The tribunal must be granted for giving them the opportunity. It was remanded back to the tribunal, my lord. And then, my lords, they have passed orders on IA number 3, which is in Annexure F, stating that it can be seen in page 78, my lords, para 28.
Read para 9. Petition is allowed in part. What is the direction?
Accordingly, the petition is allowed in part. The impugned order dated 11/7/2025 passed by the Karnataka Appellate Tribunal on IA number 3 filed by the respondent number 3 herein in appeal 35 of 25 is set aside. The tribunal is directed to provide the opportunity to the petitioner herein to file objections to IA number 3 and after hearing him and the respondent number 3 herein may pass the appropriate orders. And the tribunal,
Thereafter, your application IA3 was rejected.
yes, my lords. And then, my lords, in annexure F, my lords, page 78, they have made their observation, my lords. They are stating that there is no prima facie case.
Kindly see, my lord, page number 77, page para 26. Apart from that, the appellant has not questioned the co-option of the respondent number 3 by saying said appointment is illegal. In appeal memo, appellant has questioned in the impugned order passed by the respondent number 2 with regard to resolution dated 23/8/2002 and impugned order dated 6/1/2025. The impugned resolution passed on respondent number 1 is questioned in this interim application when respondent number 3 has been cooperated to the respondent number 1 society as per the resolution 19/2025 does not find place the main appeal. No doubt it is true that resolution dated 19/2/2025 is subsequent development after filing the appeal, but nothing prevented to the appellant to filing amendment application. Therefore, in the count itself, the interim application is still not maintained. Regarding, my lord, the main application has not been modified. This is.
But, my lords, here, my lords, the observation made in IN.
He filed an application for impleading.
Please, to challenging that, my lord, co-option. The resolution passed in the year of in the month of February, my lord. The cooperative member, my lord. Subsequent that resolution.
No, he wanted to come on record as one of the respondent.
Please.
ಅದು ಎಲ್ಲಿದೆ IA ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಇದು ಏನು ಗೊತ್ತಾಗಲ್ಲ. Produce the copy of the application. What was your prayer? Why that order was passed?
My lords,
You have to produce that.
Okay. But, my lords, the observation made in IA number 1 and the later orders passed on IA number 3 are contrary to each other, my lords. At first they say the matter should be heard and all, and the next they say there is no prime.
Said by this court.
Please, please.
Thereafter it was.
IA number 1 was
set
not,
back with the direction.
this court didn't set aside the IA number 1, my lords. Only IA number 3 was set aside. IA number 1 was never set aside.
ಏನು IA1 ಏನು?
My lords, it is staying the resolution dated 23/8/22, my lords. Staying that, my lords.
That stay is in operation.
Yes, my lords. IA number 1 was never set aside.
The order of stay was granted.
Yes, my lords.
By?
In IA number 1 it is granted, my lords.
By
appellate tribunal, my lords.
KT.
Yes, my lords.
Then why again you are seeking interim prayer?
My lords, now they have rejected the IA, my lords, which I have asked for the stay of
IA3 is
subsequent action.
rejected. Even according to you, IA number 1 was not rejected.
Please.
IA1 is allowed already.
Yes, my lords.
Stay is granted.
Stay is granted for order dated 23/8/20, and subsequent to that they have co-opted the third respondent, my lords. After stay granted for 23/8 and 22, after that they have co-opted the third respondent, my lords. On the same day, they have co-opted, my lords.
Who is the petitioner? Petitioner ಯಾರು ಇದರಲ್ಲಿ?
Petitioner, my lords, he is a director, my lords.
One of the
Babu Reddy.
One of the director.
Director of?
Respondent number.
Respondent number 1.
Society.
One society.
One society.
ಏನು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನನಗೆ.
Yeah, my lords. IA number 3 was remanded back just to give the opportunity for the third respondent, my lords.
Correct, sir. That does not mean to say that again the application is to be allowed.
But, my lords, the orders passed on IA number 1 and the observations made, and now the observation made in IA number 3 both are contrary to each other.
ಏನು ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. Members may be ಬೇರೆ.
And the earlier order passed on IA number 3 was also in our favor, my lords.
ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನನಗೆ.
Lords,
What is your grievance ಅಂತಾನೆ ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
my lords, they have co-opted third respondent in my place, my lords, and I have seek for stay for that, my lords. And my lords, kindly
Third
see
respondent was co-opted
in my place, my lords.
in place. Okay.
At IA number 1, IA number 3 co-opting was stayed, my lords. Earlier it was stayed, and then the third respondent approached this honorable court and it remanded back, my lords.
Yes.
And then to give the opportunity to file objections and hear on that, and now it has been allowed, my lords. the observation made in IA number 1 and the earlier order passed on IA number 3 and now the order passed on IA number 3, they are contrary to each other.
Regarding my lord, first they challenging the resolution before the my lord 80. And subsequently, my lord, based on the resolution, my lord, co-option as member has been appointed in his place. Subsequently, another application filed, my lord, to regarding stay that appointment, which was, my lord, made. Thereafter, my lord, the third respondent placed before this honorable court say that, my lord, they are not given any opportunity. This honorable court, my lord, stay application, appointment of stay has been set aside.
Kindly see page 50, my lords. You can see the observation made on IA number 3. Page 50, my lords. Last para. We have examined the documents on record. We are on the agreement that the contention of the appellant in this stay application that since the stay has been granted by the tribunal on 21/2/25, staying all further actions on the decision of the first respondent society dated 23/8/22, this order of stay granted by the tribunal would operate retrospectively with regard to any decisions or further actions taken in connection of the decision made in issue number 12 of the first respondent society on 23/8/22, my lords. Consequently, it has to be seen that the resolution dated 19/2/25 taken up and decided by the board of the first respondent society to co-opt the Ashwath Narayan Reddy be in place of the appellant herein, that is Sri Babu Reddy, can be clearly construed as further action on the decision made by the first respondent society on issue number 12 on 23/8/22. The resolution dated 19/2/25 passed by the first respondent society to co-opt Sri Ashwath Narayan Reddy director as director in place of the appellant Sri Babu Reddy needs to be stayed. If not, the earlier stay order granted by this tribunal on 21/2/25 staying all further actions on the decision of the first respondent society dated 23/8/22 becomes infructuous. Moreover, it has to be seen that the appellant's directorship, if the first respondent society which is under challenge in the dispute in question, if the appeal was the directorship got by the appellant through election, whereas Ashwath Narayan Reddy, the third respondent V, is bestowed with directorship of the first respondent society via selection or co-option process, which is not through election. And as such, the selection through co-option has to be seen as being doing at pleasure of the first respondent society. Hence, the balance of convenience is clearly in favor of the appellant in consideration of the stay application. My lord, if stay is not granted, my lords, the appeal will become infructuous, and this writ petition will also become infructuous.
Virtually, my lord, the interim order, my lord, kindly see page number 47. IA number 1, ma'am.
ಅದಾಯ್ತು ಪ್ರಿವಿಯಸ್ ಆಯ್ತು ಇವಾಗ
ಈಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಷ್ಟೇ ಬರೋದು. ಫರ್ದರ್ ಸೀಕ್ವೆನ್ಸಸ್ ಆಲ್ ಮೈ ಲಾರ್ಡ್ ಸ್ಟೇಡ್.
ಫರ್ದರ್ ಸೀಕ್ವೆನ್ಸಸ್ ಎಲ್ಲ ಸ್ಟೇ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ 23/8.
Is there case, my lord, to even though my lord appointment, my lord, subject to appeal, my lord.
If the stay is not granted, my lord, the appeal before the KIT and this writ petition will become infructuous, my lord.
You produce that application, sir. Nanage, I am not.
I'll produce, my lord.
Conversant with that.
But my lord, stay, my lord.
Appellant also sought to stay the operation implementation resolution passed by respondent number 1.
Lord, if stay is
wherein respondent number 3, that is, has been appointed as. Now that application is filed seeking stay of operation and implementation of resolution number 3.
Yes, my lord. 19/2/20.
Opting respondent number 3.
Yes, my lord.
Issue number, my lord.
Yes, my lord.
Issue number 12. 20.
That is the application in A number 3, my lord. That's it, my lord.
Third limit counsel for the petitioner.
Lord, stay, my lord.
ಅದಕ್ಕಿಂತ ಮೊದಲು AGA takes notice for respondent number 1 and 2. Issue notice to respondent number 3.
1 and 3, my lord. 1 and 3.
Okay. Our AGA for 2.
2, please.
Issue notice to
One
respondent
and
number 1 and 3. In the meantime, there shall be a stay of operation of resolution dated 11/2/2025 passed by respondent number 1 resolution number 3, resolution number 3, Roman 3, dated 11/2/2025, passed by respondent number 1, co-opting respondent number 3 as director in the place of the petitioner, produced as per Annexure C till next date of hearing. Yes. Next. Agide, notice 1 and 3 notice. Yes. Security there. Respondent number 3 has filed a caveat.
Lord.
Have you served the notice? Agida. One and two allow, two do not. Respondent number 3, caveat petitioner is absent. Okay. 3 na caveat petitioner. You have served him. Counsel for the petitioner submits that he has served a copy of the petition on respondent number 3, the caveat. Counsel for the petition, respondent number 3 is absent. Yes. Yes, stay granted. Next.
Serial number 4, is Saravanan Raj Babu.
Why annexure D and E are not, certificate copy are not produced?
Annexures
D and E.
D and E, my lords.
An application is filed to seeking dispensation.
Dispensation, my lords. Annexure D is a government order under section 121, and Annexure E is calendar of events. I'm not seeking any relief with reference to Annexure E. Annexure D, of course.
Counsel for the petitioner on IA 1 of 2025. Counsel for the petitioner submits that the petitioner is not seeking any relief in respect of Annexure D and E, and therefore IA 1 of 2025 is to be allowed for the reasons stated in instruction. IA is allowed. Production of certificate copy of Annexure D and E is dispensable. Yes, are you? Notice agida? Illa. Yes, you are for respondent number
1, 3.
Respondent, government can take notice for respondent 1, 3, 4 and 5.
For respondent.
4 and 5.
2 is A. Devraj.
7 idare, Nataraj avaru idare.
That takes notice for respondent number 2.
I appear for 6.
Our respondent number 6. ಮತ್ತೆ ಯಾರು ಉಳಿದು?
ಅಷ್ಟೇ ಮುಗಿದೋಯ್ತು.
5
2 is Devraj.
ದೇವರಾಜ್ ಆಯ್ತಲ್ಲ ಇಲ್ಲ 1 to 7 ಆಯ್ತಾ 7 ನಟರಾಜ್ 7 ಆಯ್ತಲ್ಲ
ಯಾರು?
Yes.
Lords, kindly pardon me, my lords, that I have to go beyond what is there in this. Of course, on legal issue only. Lords, elections are to be conducted on the basis of the eligible electorate. Lords, electorate will have to ultimately decide who is going to win the elections. This is for the board of directors to BDCC Bank. In BDCC Bank, there are various constituencies based on talukas. Not so far as Chenpatta constituency is concerned, there are total 18 members. Out of 18 members, in respect of 3 societies, ಅಂದ್ರೆ 18 society ಇದೆ, 18 society ನಲ್ಲಿ 3 society ನಲ್ಲಿ board of directors ಇಲ್ಲ, ಹಾಗಾಗಿ ಅವರು ಡೆಲಿಗೇಟ್ ಕಳ್ಸಕ್ ಬರೋದಿಲ್ಲ. Now, out of these 15, 8 petitioners came before the court in the earlier round, where your lords has passed an order. 2 ವಾರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಡಬೇಕು, ಆಮೇಲೆ 3 ವಾರ ಅವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ಟು ಆಮೇಲೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. ನಾವು ಇನ್ನೊಂದು ಸೆಕೆಂಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು ನಾವು ಮತ್ತೆ ಬಂದಿದ್ದೀವಿ. ಸೊ 8 ಜನ ಒಂದ್ ಕಡೆ ಇದ್ದಾರೆ.
ಉಳಿಕಿದ್ದು 7. ಈಗ 7 ಆಯ್ತು, 15 ಜನ ಇರೋದು. 15ರಲ್ಲಿ 8 ಜನನ್ನ ಟಾರ್ಗೆಟ್ ಮಾಡಿ, ಯಾಕೆಂದ್ರೆ ದೇ ಆರ್ ಸಪೋರ್ಟಿಂಗ್ ದ ಕ್ಯಾಂಡಿಡೇಚರ್ ಆಫ್ ದಿ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. ಸೊ ದೇ ಟಾರ್ಗೆಟೆಡ್ ದೆಮ್ ಸೋ ದಟ್ ಹಿ ವಿಲ್ ನೆವರ್ ವಿನ್ ದ ಎಲೆಕ್ಷನ್ಸ್. ಇಲ್ಲೇ ಎಲೆಕ್ಷನ್ ಗೆದ್ಬಿಡ್ಬೇಕು ಅವ್ರು, ಎಲೆಕ್ಟ್ರೇಟ್ ಆಗೋದೇ ಬೇಕಾಗಿಲ್ಲ. They will manipulate everything, lords, while exercising the statutory power, and they want to do this. Despite that, because of your lordship's indulgence, what has happened? 8, they were protected then, but not today. They were protected then. Now, after this, it is turned out to be 8 versus 7. ಯಾಕಂದ್ರೆ 15 ಎಲಿಜಿಬಲ್ ವೋಟರ್ಸ್ ಇರೋದು, 3 ಬೋರ್ಡ್ ಆಫ್ ಡೈರೆಕ್ಟರ್ಸ್ ಇಲ್ಲ. ಇನ್ನೊಬ್ರು ಬೇಕಲ್ಲ, ಈಕ್ವಲ್ ಮಾಡಕ್ಕಾದ್ರೂ ಒಬ್ರು ಬೇಕಲ್ಲ, ಯಾಕಂದ್ರೆ ಇನ್ನು ಒಂದೇ ಸೊಸೈಟಿ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು. ಯಾರವರು ಅಂತಂದ್ರೆ ಈ 6ನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ R6. They have been registered on 36/2025. Lords, may kindly have a look at Annexure B, page number 14, 14. At page number 14, 15, bottom of the page, Adesha. ಕರ್ನಾಟಕ ಸಹಕಾರ 36/25 ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 1959 ಪ್ರಕರಣ 7 ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋರಲ್ಲಿ ದತ್ತವಾದ ಅಧಿಕಾರದೊಂದಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು ರಾಮನಗರ ಉಪವಿಭಾಗ ರಾಮನಗರ ನಾನು ನಿಯೋಜಿತವಾದ ಚಿಕ್ಕೆರೆ ವಿವಿಧೋದ್ದೇಶ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಮುಳೂರು ಹೋಬಳಿ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ರಾಮನಗರ ಜಿಲ್ಲೆ ಸಹಕಾರ ಸಂಘವನ್ನು ನೋಂದಣಿ ಮಾಡಿರುತ್ತೇನೆ. ದ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ದಿಸ್ ಸೊಸೈಟಿ ಈಸ್ ಆನ್ 36/2025. Notes, we don't have the details when they became the member of the BDCC, but it should be only after, because BDCC is a federal bank. Federal bank, there is a difference between federal bank and secondary, federal society and secondary society. Secondary societies nalli individuals members irbodu, societies members irbodu. Adre federal society nalli only societies will be members. So this society came into existence on 36/2025. So presumably after that they have been enrolled as the member of the BDCC bank. Now, under section 20, Lords may kindly see that what happens to such members. Section 20 of the Cooperative Societies Act. Section 20, subsection 2, A3. Section 20, subsection 2, I will read. The following shall not have the right to vote at a general meeting or an election of the members of the board of the cooperative society in which they are members, namely, a person who has become a member of a society, A3, A3, a person who has become a member of a society not later than 12 months prior to the date of such meeting or election. That means a member who is enrolled less than 12 months from the date of the election is not entitled to vote. As simple as that. Minimum period should have lapsed from the date of his enrollment from membership till the date of voting is 12 months. This is the mandate under section 20. Section 20 also gives other mandates. It may be one who is covered under A4, A5 and the like. There is a significance to this, because these are the disqualifications from the voting. Now, what the government does, they issue the calendar of events on 18/11/2025.
Yes.
Once the calendar of events comes, there is some significance to the calendar of events. Can I request your lords may kindly have a look at Rule 13D, capital D.
What is that? Which is the provision?
Rule 13, capital D. Lords, in that, may I request your lords may kindly have a look at 13D 2A 6. The final list of ineligible voters shall be published on or before 15 clear days prior to the date of election. Lordship gets it, Lords.
13D.
13D
2A.
ಅದರಲ್ಲಿ ಸಬ್ ರೂಲ್ 2A, ಅದರಲ್ಲಿ ರೋಮನ್ 6.
Yes.
The final list of ineligible voters shall be published on or before 15 clear days prior to the date of election. Next, sub rule 3. ಅದರಲ್ಲಿ clause D. For publication of final eligible voters list before 15 clear days prior to the date of the election. Andre, election prakriya, notice the view taken is that preparation of an electoral roll is an integral part of the election under the scheme of the Cooperative Societies Act. So the final list of electoral roll is prepared 15 clear days from when the election is required to take place. 7th of December is the date of the election. ಅದಕ್ಕೆ 15 clear days ಅಂದ್ರೆ 21st of November 2025. 21st of November 2025.
Yes.
Or I will take it, even giving an exemption, I will take it as 22nd of November 2025. So at any rate, the list of voters which is prepared in terms of 13D, 2A, 6 or 3D is the final sacrosanct list on the basis of which the society will go for the election. That is the final list. No provision is there which permits the tinkering of this list. Except by the orders of the court, this list is never tinkered. This is the final list.
Yes.
Now on 24/11/2025, after calendar of events, after 15 clear days is also over, on 24/11/2025, government exercises its powers under section 121, exempting section 20 subsection 2A3 only for the purposes of enabling the 6th respondent to vote in the 7/12 elections. So it boosts the voters list. It meddles with the voters list. Government is actually nobody. The reason why the entire exercise is now vested with these cooperative election authority is to ensure that the government should not have much say in the matter. Now, Lords may kindly see Annexure D at page number 18. ಇದನ್ನೇನಾದ್ರೂ ಅವರು ಸಕ್ಸಸ್ ಆದ್ರೆ 8 ಆಗತ್ತೆ. ಆ 8 ಆಗಕ್ ಬಿಡೋದಿಲ್ಲ, ನಾನು ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೀನಿ. ಇಲ್ಲೇ ಗೆದ್ದು ಬಿಡ್ಬೇಕು ಅವ್ರ ಎಲೆಕ್ಷನ್ಸ್ ನ. But such matters comes before the court. None of the officers goes punished with all these things. So they will merrily pass such kind of orders under the dictates of the people who are in power or who hold the guard. Page number 18. ಅದರಲ್ಲಿ ಓದಲಾಗಿದೆ ವಿಷಯ. ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಜಿಲ್ಲೆ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಚಿಕ್ಕಿಕೆರೆ ವಿವಿಧೋದ್ದೇಶ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘವು ಬೆಂಗಳೂರು ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನ ಚುನಾವಣೆಯಲ್ಲಿ ಮತದಾನ ಹಕ್ಕನ್ನು ಪಡೆಯಲು ಅನುವಾಗುವಂತೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 22(a)(3) ನಿಬಂಧನೆ ವಿನಾಯಿತಿ ನೀಡುವ ಬಗ್ಗೆ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ 29/5/25 ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್. ಮಾನ್ಯ ಶಾಸಕರು ಚನ್ನಪಟ್ಟಣ ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರ ಇವರ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರಿಗೆ ಭದ್ರ ಪರದೋ ದಿನಾಂಕ 11/11/25. No wonder the additional advocate. I was expecting even the Advocate General to come in. Now losses will kindly see the contents of the letter. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರ ಸರ್ಕಾರ ಆದೇಶದ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ ಪ್ರಕರಣ 121 ಅಡಿ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ದಿನಾಂಕ 30/4/25 ಅಂತ್ಯಕ್ಕೆ ಹೊಸದಾಗಿ ನೋಂದಣಿಗೊಂಡ ಫೆಡರಲ್ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕ್ಗಳು, ಜಿಲ್ಲಾ ಸಹಕಾರ ಹಾಲು ಒಕ್ಕೂಟಗಳು, ಜಿಲ್ಲಾ ಸಹಕಾರ ಯೂನಿಯನ್ಗಳು ಹಾಗೂ ಇತರ ಫೆಡರಲ್ ಸಹಕಾರ ಸಂಘಗಳಲ್ಲಿ ಸದಸ್ಯತ್ವವನ್ನು ಪಡೆದ ಪ್ರಾಥಮಿಕ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಅಧಿನಿಯಮ 1959 ಪ್ರಕರಣ 22(a)(3) ನಿಬಂಧನೆಗೆ ವಿನಾಯಿತಿ ನೀಡಿ ಫೆಡರಲ್ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆಯಲ್ಲಿ ಭಾಗವಹಿಸಲು ಅವಕಾಶ ನೀಡಿ ಆದೇಶಿಸಿದೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 2 ಮಾನ್ಯ ಶಾಸಕರ ಪತ್ರದಲ್ಲಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಜಿಲ್ಲಾ ಚನ್ನಪಟ್ಟಣ ಚಿಕ್ಕೆರೆ ವಿವಿಧೋದ್ದೇಶ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘವು ಬೆಂಗಳೂರು ಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಖಾತೆಯನ್ನು ತೆರೆದು ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದು ದಿನಾಂಕ 30/9/25ಕ್ಕೆ ಪ್ರಮಾಣ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ರಂತೆ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಎ ವರ್ಗದ ಸದಸ್ಯತ್ವವನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. Your lordships may kindly mark this. 30/9/2023 is the date on which they are enrolled as members.
Yes.
ಬೆಂಗಳೂರು ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕಿಗೆ ದಿನಾಂಕ 7/12/25 ಚುನಾವಣೆ ನಿಗದಿಯಾಗಿದ್ದು, ಸಂಘವು ಸದಸ್ಯತ್ವವನ್ನು ಪಡೆದ 12 ತಿಂಗಳು ಪೂರೈಸಿಲ್ಲವೆಂದು ಸದರಿ ಸಂಘಕ್ಕೆ ಮತದಾನ ಹಕ್ಕನ್ನು ನೀಡುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸಂಘವು ನಿಯಮಾನುಸಾರ ಬಿಡಿಸಿಸಿ ಬ್ಯಾಂಕಿನ ಸದಸ್ಯತ್ವವನ್ನು ಹೊಂದಿರುವುದರಿಂದ ಸಹಕಾರ ಸಂಘ ಅಧಿನಿಯಮ ಪ್ರಕರಣ ಸೋನ್ಸೋ ನಿಬಂಧನೆ ವಿನಾಯಿತಿ ನೀಡಿ ಮತದಾನ ಹಕ್ಕನ್ನು ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಅವ್ರು ಕೋರಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್, ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 1959 ಪ್ರಕರಣ 121 ರಡಿ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಜಿಲ್ಲಾ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಚಿಕ್ಕೆರೆ ವಿವಿಧೋದ್ದೇಶ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘವು ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಹಾಗೂ ರಾಮನಗರ ಜಿಲ್ಲೆ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕಿಗೆ ದಿನಾಂಕ 7/12/25 ಜರುಗಲಿರುವ ಚುನಾವಣೆಯನ್ನು ಭಾಗವಹಿಸಿ ಅನುವಾಗುವಂತೆ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘದ ಅಧಿನಿಯಮ ಸೋನ್ಸೋ ಪ್ರಕರಣ ಇದರ ನಿಬಂಧನೆಗೆ ವಿನಾಯಿತಿ ಆದೇಶಿಸಿ. 8 ಮಾಡಿದ್ರೆ ಈಗ ಹೆಂಗೆ ಎಲೆಕ್ಷನ್ಸ್ ನಲ್ಲಿ ಡೈನಾಮಿಕ್ಸ್ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡೋದು ಅಂತ ಈ ಆಫೀಸರ್ಸ್ಗಳನ್ನ ಇಟ್ಕೊಂಡು, ಇದರಲ್ಲಿ ಬಿಡಿಸಿಸಿ ಬ್ಯಾಂಕ್ನವ್ರು ಕೇವಿಯಟ್ ಬೇರೆ. Now your lordships may kindly take section 121 of the Cooperative Societies Act. Section 121. The state government may, by general or special order published in the official gazette, exempt any cooperative society or any class of societies from any provisions of this act, or may direct such provisions shall apply to such society or class of societies with such modifications as may be specified in the order. We come within the first part. The state government may, by general or special order published in the official gazette, exempt any cooperative society or any class of societies from any of the provisions of this act. So this is the power which they have exercised. Now, if your lordships were to recollect, section 20 is essentially what is exempted. Section 20 is exempted. So far as this society is concerned, that is the sixth respondent is concerned, section 20 is exempted. Notice when section 121 was sought to be invoked at an earlier point of time, the constitutional validity or the vires of section 121 was called in question. (92)3 Karnataka Law Journal, page 462.
What was challenged?
Notice,
Of section
two things were challenged. Again, by exercising section 121, the government exempted section 20 in respect of class of societies. Here was a case it exempted for a class of societies. They said that whoever are the defaulters, we are exempting section 20 and they are all entitled to vote. So it is in this context, the vires of section 121 as also the notices came to be challenged. Notice in this paragraph number 2 of the order, can I just read few lines in paragraph number 1 and then go to paragraph number 2. Note the first paragraph. I have before me a clutch of petitions numbering about a dozen, but point to note is all of them have their target a notification of the state purported to have been issued in the exercise of powers under section 121 of the Cooperative Societies Act. Government having power under the aforesaid section proceeded to exempt a large number of individual members of cooperative societies, as also the societies themselves, from operation of subclause A1(V4) of subclause 2 of section 20 of the Act, stating that the exemption so ordered shall remain in force up to and inclusive of 30th of December 1991, and upon its expiry, the provisions of the said section shall stand revived. I must mention that the said order is dated 23rd September 1990. Earlier to the passing of the order afresh, government has passed 2 other orders, one on the first occasion on 28 May 1990, another on the second occasion on 27th of September 91. The only difference being that the earlier 2 orders refer to the above limited themselves to agricultural credit societies and primary agricultural societies, to individual members of the society. The 3 notifications appears very innocuous in nature, issued in a routine fashion,
But the petitioners claim they have a far-reaching effect and could lead to a total denigration in the quality of the administrators ushered in to occupy pivotal positions in a cooperative society through elections that were already in the offing. There it was not yet done. Now I'll skip to paragraph number 2. What came about for consideration before the court? The facts mentioned supra hold good for all the petitions, but however, for the purpose of convenience, I would, in the course of this judgment, refer to the facts enumerated in WP number so and so. The petitioner herein is one of the directors of the Karnataka State Cooperative Agricultural Rural Development Bank. He has taken up cudgels against the impugned notifications because he says he is anxious to ensure that only qualified persons will vote and contest the elections to usher in the new committee of management of the bank in question. He wants to make sure that the persons who have defaulted in payment of their dues are not allowed to either vote in the or contest in the elections. He points out, notwithstanding the bar imposed by Section 20 of the Act, 90% of the taluk level bank who are defaulted in making the payments due from them and therefore eligible to either vote or contest in the elections are now free to do both in virtue of the suspension of the operation of Section 20 under the impugned notification. This, according to the petitioner, is a case of misguided sympathy, or if it was not, that it is a case of undue anxiety to pack these positions of power with the votaries of the government in power. Let's just make kindly mark this is essentially what is being happening, milords, with the management of the provisions in this manner by the people in power. This is essentially what came about. Then he therefore says that this was clearly a case of government conferring a largesse on the people who are not merely undeserving, but were thoroughly unqualified to receive the benefaction showered on them by unmerited though magnanimous act of the government in suspending the operation of Section 20 of the Act. But then the contentions of the Advocate General is noted at para 3 and the points for consideration is at paragraph number, I'll just take your lords to para 5. Para 4, my lords, because that's an observation by the court. But at the time of hearing arguments, I found the learned Advocate General in some kind of a quandary in sustaining the notifications, at least on one aspect, which completely coursed outside the four corners of 121 of the Act. I am referring to the exemption of individuals from operation of Section 20 of the Act. When confronted with this lacuna in the notifications, the learned Advocate General came out with an adroit reply saying that is none of these writ petitions the tenability of exempting individuals from purview of 20 of the Act at being at issue. Even if it is held that the impugned notifications are vitiated for aforesaid reason, it is held that the impugned notifications are, the notifications would since be valid so far as institutions are concerned. I shall revert back to this argument a little later, and in the meanwhile, go on to set out the relevant provisions of the Act, which is a bearing on the question in issue. Section 20, then the omnibus power to regulate the working of a cooperative societies by exempting them from any of the provisions of the Act obtains under the very wide and almost dimensionless powers under Section 121, which reads as under, which I have already read to your lordships. Admittedly, and in view of the foregoing provision, government has passed the orders impugned in these writ petitions, and I might as well set out the latest of the orders passed by the government, speaking out the role model from WP number so and so, which exempts not merely the society, all societies, but even individual members for the purpose of Section 20, which reads as under, then Section 20 is attracted. Then paragraph number 6. The position obtaining under Section 20 therefore is that an individual member is eligible for voting if he is not a defaulter within the meaning of the explanation to Section 20 referred to earlier, where a society itself is a member of another society. Former is entitled to vote in the election of the latter, but is precluded from participating in such election if rendered ineligible under clause 4 of subsection 2 of Section 20. Similarly, an agricultural so and so. I will not trouble your lordships on this. Then points for consideration. I formulate the following brace of points as arising. Is Section 121 of the Act is constitutionally invalid? If the section is valid, are the notifications issued by the government referred to supra are tenable in law? Let's in this, the point number 1 is answered, my lords, positively by saying that it is constitutionally valid. But what I request your lordships may kindly have a look at the last 2 lines. Long years ago, A bench of Mysore High Court had in Venkata Naidu's case had repelled the challenge to the constitutional validity in the light of the two decisions referred to, one of the Supreme Court and other by the precursor court of this court. There is hardly any room for anyone to contend that section 121 of the Act is constitutionally invalid. But as their lordships have pointed out, the power is undoubtedly there. The question that looms large in such cases is whether the power has been exercised in a manner subserving the object of the Act. The test is to identify the benefactions, if any, that would result from the exercise of power. I would deal with this aspect of the matter while I consider point 2. On point number 1, it is to be held that 121 is constitutionally valid. Then point number 2. The only point which now remains to be considered is on the validity of the spate of the government orders taking power under section 121 of granting exemption to the individuals and societies alike from the operation of section 20 of the Act. To start with, I must recall that the argument led on behalf of the petitioner suggesting section 121 is limited only to a cooperative societies and certain class of societies. According to the petitioner, it does not take within its ambits individual members of the cooperative societies. I have accepted section 121 here before, my lords. I'll skip this. The relevant portion, my lords, which I would request your lords to kindly have a look at, is paragraph number 15. I must now add, your lordship gets it, I must now add the final epitaph over these orders by pointing out that the state had no reason, much less any good reason, for passing the orders impugned herein. Government orders as they stand now have rendered themselves wholly unsupportable ex facie. To emphasize this aspect, I shall reproduce section 121. Again, section 121 is actually the section which I have reproduced as aforesaid militates against my endeavor that that can be made at sustaining the impugned GOs. Section does not provide for mothballing societies by passing a blanket order 121, making all the sundry eligible for all types of exemption under the Act. Section, it may be noted, provides only for selective operation by choosing for its attention any cooperative society or any class of societies as pointed out earlier. The notification dated 23rd September 1991 is very widespread, covering all societies, ignoring the criteria that remedial action under section 121 can only be done on a selective basis. The state has sought to justify the need to extend the absolute cover to all societies by making the following statement. Now, I'll skip this and come to the next page. From this third line, there is no gainsay. Third line. There is no gainsay in denying the object of the Act is to ensure that cooperative movement conceived on the basis of mutual help and voluntary service to help the small farmers, artisans, agriculturists to get the best of the bargains, eliminating parasitical middlemen. If to help these small people, cooperative societies or farm loans are given, their turn are expected to display a bit of promptitude in discharging obligations under by them. To any default in that regard should necessarily invite a sound reproach, wrath in good measure. 20 is enacted precisely for the said purpose, and I'm sorry, enacted for the said purpose, and the contemplated display of denigration takes the form of denial of franchise to defaulters, whoever it may be, an individual member or an institution. True, as pointed out by the Supreme Court in Registrar versus Kujambu, that in extraordinary situations to save institutions, recourse could be taken to some extraordinary measures to bring about normalcy in a cooperative institution suit. This is done by taking power from a fountain source under section 121 made operative by granting suitable exemptions and modifications. If this remedy available under the Act for sustaining the object of the Act is availed in a manner destructive to the very fabric of the Act, this is very important. Such an overt act would mutilate and render the waste a salutary provision like section 20, as has happened in this case, serving as a general cover to protect all truants, whether they are individuals or institutions. And in such situation, I am afraid it is different even to imagine, much less to expect, the remedial measure under section 121 could be availed of by the state in the manner in which it is done. I am afraid that the impugned order of the government passed on 23rd September is totally indefensible and cannot be sustained on any ground whatsoever. Now, having said this, at paragraph number 18, just above paragraph number 18, Lords, page 247 ಇದೆ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಐದು ಲೈನ್. It is granting a minor the right to vote. This is what it says. It is like granting a minor the right to vote, although in law he does not possess such a right. It is as fallacious as that. Can it then be said that the blanket reprieve granted by the government in exercise of its powers under 120 of the Act is legal and was intended to further the objects of the Act? Nay, it only leads to the defeating the several salutary objects of the Act. In attempting to exempt individuals or institutions alike from operation of Section 20 of the Act, it must be said without clear that government has taken false step in the name of law. I do not wish to say more. I conclude by summing up as follows. Lords, I can assure that every time such matters comes before the court, the courts have gone very smooth on the government. The courts have exercised restraint in expressing what the government is doing is nothing short of a mischief, which is in fact called as fraud on law. The caption used by the courts is fraud on law. This is essentially what the government has been doing from time to time. Now, I have given the statistics, my lords. What is that the government wants to do? A society which becomes a member in the month of September, that is on end of September, 30th of September 2025, would become eligible to vote on September 20. That's probably not even in September. It will be in the month of October. October 2026, it will become eligible to vote. This 121 is to favor the purpose or object of the Act. That's the purpose. If your lordships were to again see what section 121 says, which I have read to your lordships multiple times, it says the government may by general or special order published in the official gazette exempt any cooperative society or class of societies from any provisions of the Act, or direct so and so, has to be read in conjunction with what the principles which has been laid down while upholding the validity of this Act, saying that this is a power which is to be exercised to favor the objects of the Act, not to defeat the very scheme of the Act. No, there are certain provisions which are very fundamental to the cooperative movement. How does the cooperative movement start? It starts with the society having been brought into existence with its members. Then there is a school of electorate, which will be identified in terms of the scheme of the Act. And then it goes to an electorate which is required to be conducted as a free and fair election. In order to ensure that there is a minimal governmental impact on this electoral process, by means of of course, there was a constitutional amendment which was brought about. The constitutional amendment was struck down, in Rahul Shah's case. But the state amendments remained, which was essentially to ensure that there is no governmental impact on the election process in a cooperative society. The cooperative election authority is constituted. If your lordships were to see, this becomes necessary because under 121, a very critical question, my lords, which I am posing to myself is this. If your lordships were to see, 39 capital AA. ಇದೊಂಥರ ಕೋಡ್ ಆಫ್ ಕಂಡಕ್ಟ್ ಇದ್ದಂಗೆ. ಇವ್ರು ಏನು ಮೆಡಲ್ ಮಾಡಂಗಿಲ್ಲ. ಅದು ಇನ್ನೊಂದು ಆಲ್ಟರ್ನೇಟಿವ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ, ನಾನು ಹೇಳ್ತೀನಿ. 39 capital AA. The state government shall, by notification in the official gazette, constitute a cooperative election authority consisting of the cooperative election commissioner and the secretary. Lordships may kindly mark the next sentence. Superintendence, direction, control of the preparation of the electoral rolls and the conduct of all elections of the cooperative societies in the state shall vest with the cooperative election authority. The state gets completely denuded of its powers to exercise any power under 121 which would conflict with 39AA2. This phrase has come up for consideration, in any number of judgments of the Supreme Court while dealing with the provisions of the Representation of People's Act.
Yes.
This is essentially what is actually the code of conduct. it denudes every authority under the Cooperative Societies Act to exercise any power which conflicts with the exercise of powers by the Cooperative Election Authority under subsection 2 of section 39AA. Then the second part is that the process of election in a cooperative society commences from the stage of preparation of the electoral roll. Unlike in every other election, if it is a general election, it does not commence from the preparation of an electoral roll, because under the Representation of People's Act, it is a continuous process. But under the Cooperative Societies Act, this itself is the process. This is the commencement of process. That is the reason why conspicuously under 39AA2 it says preparation of the electoral rolls is only by the Cooperation Authority. Now, once this happens, what is the consequence? Every authority acts in the aid of exercise of powers by the state election authority. That's the Cooperative Election Authority. Similar to there may be a deputy commissioner, assistant commissioner, but they become election officers. There will be a chief executive officer of a cooperative society. He is actually the paid employee. But when it comes to the question of preparation of an electoral roll under the scheme of this act, because of 13D, Rule 13D, he becomes an election officer. He becomes an officer discharging the functions which are required to be discharged by the state election authority. This is similar to what happens in the general election. Now, if this is the scheme of the act, where is the state in 121? Meddle with the preparation of the electoral rolls. This is the first part of my argument. Now, exemption what is given is only to section 20. Notes, I have read to your lordships Rule 13D, 2A, 6 and 3D. Notes, once the voters list is final, there is no provision under the entire scheme of the act under which this list can be meddled with. This is the final list. If no exemption is given to these two provisions, assuming, then this is the only list on the basis of which the election should be conducted. It's an incomplete exemption. You can't exempt part of it, because the voters list was already come in existence or deemed to have come in existence 15 clear days prior to the date on which the elections are due to be held, that is on 23rd of November 2025. So therefore, my lord, so far as this first matter is concerned, that is serial number 4, is purely an act of mischief. It's a fraud on power by the government. Every time we come before the court, at the time of elections, and the government does the same mischief every time, and the courts are going a little smooth on the government. The government knows by its conscience that this is what the government is. The court knows by its conscience this is what the government is doing.
Yes. What do you say?
My lords, my post it fresh matter, I will with the provided information. Lords, primarily the petitioner has to establish his locus before my lords. My lord sees the
contestant.
House title.
Yes.
Jairamu K, Director, Malluru Patna Vividodesha Prathamika Gramina Sangha Krishi Sahakara Sangha. Whether he can represent the society in the writ under 29GH, my lords may have to verify. And what is his right, which has been defeated as a member of a society, for which he is seeking this relief before my lords? What right of his is curtailed? Under what is the constitutional provision which is violated, for which he has invoked 226? And whether he has at all any authority under law to represent the society and question these orders. And what is that he is aggrieved of? That he may lose an election because the other person is coming. What under law is it that he is aggrieved of? We should be within the purview of the Constitution. That would be my first submission. Secondly, my lords, this Annexure D is questioned before my lords. In Annexure D, if my lord sees in the Prastavane, there is a reference to the government order dated 29/25. ಉಲ್ಲೇಖ ಒಂದು ಓದಲಾಗಿದೆ ಪೇಜ್ 18 ಅಲ್ಲಿ.
Yes.
The same 121 order was questioned by some petitioners before this honorable court in WP number 1788, and same stay was pressed upon, my lords. This is the order of the honorable court. Madam.
What was challenged in that?
In that, my lords, the section 121 Ullekha Vandu, where similar exemptions were granted to section 20, the daily order. My lords may take the daily order dated 25/6/25. Next page, my lords. I'll just read some paragraphs. Learned senior counsel appearing for the petitioner. My lords, the second page, 25/6/25 is the order. Print out of first page khali bandide, second page in
25.
Item number 4, my lords. First page al 4 anta ಇದೆ. Daily order. May I read, my lords?
Yes.
Learned senior counsel appearing for the petitioner while reiterating the grounds urged in the writ petition submits that respondents 7 to 39 are newly formed societies registered with the sole objective of securing membership to the respondent 5 Federal Cooperative Bank in anticipating of the upcoming election, referring to section 22A3 of the Societies Act 19, same exemption, my lord. Year also, same year. Learned senior counsel so and so was content. My lords may kindly come to the last paragraph, para 8. Same arguments were put forth, my lords. Para 8. Per contra, learned advocate general has vehemently opposed the submission made by the learned senior counsel of the petitioner and contends that the orders passed by the division bench in writ appeal and contempt proceedings do not preclude the newly formed societies from participating in the electoral process. He submits that the state government, in exercise of powers under section 121 of the Karnataka Cooperative Society Act, has issued a notification granting exemption, thereby permitting the newly constituted societies to nominate delegates to respondent number 5 bank. He argues that the exemption which remains in force pending adjudication act is a positive legislation intent to confer voting rights on the newly formed societies and not to restrict them. He further concerns that over 975 such societies have been admitted across the state under similar circumstances, and an administrator by virtue of power conferred under section 28A5 was competent to admit new members. Referring to Annexure H, Rule 3D4 of the Karnataka Cooperative Societies Act, Learned Advocate General points out the provisional voters list was published on 10/6/25. No objections were raised. My lords, in the end, para 13, the Honorable Court refers to various judgments, and there is a question framed. The following points would arise for consideration while deciding this petition on merits. Whether the exemption granted by the state government under section 121 of the Cooperative Societies Act is valid and applicable to the newly formed societies for the purpose of participating in the elections of respondent 5 bank. So this question was framed and they were all permitted to participate. Section 121, there was no stay. This order, my lords, there is an extension of the same to a specific society. That is what is questioned before, my lords. Under 121, my lords, it's a vast power. As it was also pointed out, 121 has already been upheld by this honorable court. Section 121, my lords, may I just read for my lords' consideration again?
No, power is there, no doubt. But when any unbridled power is given to the state government without any assigning any reason, then why is
the only reason would be to give
at the
voting
pleasure of
representative.
the government? Can such an order be passed?
My lords, I would,
without assigning any reason?
My lords, the reason is, my lords, the second paragraph.
Reason is only to enable the newly registered society to.
Yes. That is the only reason, my lords. Societies, there should be a representation who are registered under that particular
why all those
federal
exemptions?
societies.
Any society which is registered as on the date of issuance of calendar event, then exercise right.
That may be have to consider, but at this point of time, there is an exemption.
Why section 121?
My lords, this exemption has been given. There was an earlier cutoff date of 30/4/25, for which 975 society. What has happened is central government, my lords, has directed under every Gram Panchayat, there has to be a primary society and representation has to be given in all this federal level. So considering also that this earlier order came to be issued, my lords, where 975 Gram Panchayats were included in various other federal societies. This is one which is a single order, my lords, which has been now exempted. The only reason what I can point out to my lords is giving the representation in a federal structure. That's all. Beyond that, nothing else. And my lords, petitioner, my lords, locus. That's the only argument I can make. We are given a representation to a society by giving exemption. Beyond that, my lords, it's his personal thing and he cannot represent his society is my respectful submission. Please.
Just one sentence, of course, if my paragraph number 1 of my writ petition, I am the contestant. I am the person who is contesting in Chanpadna constituency.
He is representing his society, not
There is,
individually.
I think,
He's a
the
delegate.
moment I am a delegate,
He's just a delegate.
the moment I am a delegate, it is me who will contest. Society will not contest.
He's a delegate of a society.
Aladena concept now dispute ಮಾಡ್ತಿದಾರ ಅಂತ. Are they disputing the concept that delegate will contest the elections, not the society? The moment I am delegated, individually I am going to contest. The delegation is an authorization to go and contest. Society will not become the president.
Society should have been before my lords seeking for the said relief, not the petitioner.
Delegation itself will contain all the powers to contest, to vote, to participate in the meetings.
For the sixth respondent, please see, the petitioner, my lord, is from a different society.
Yes.
Petitioner is from a different society.
Yes.
Sixth respondent is a different society. No, my lord, by this, my lord, as the learned additional advocate general said, the emphasis is to give, my lord, more representation to more areas.
And why section 20 and 121?
Lord, what happened?
Those restrictions.
Yes, my lord, those restrictions, my lord, are.
It is better to scrap
So, my lord,
any society which is
they are
constituted
probably
and
acting
registered
at the
can exercise vote. Why
directions
all
of-
these exercise?
directions of, my lord, the central government, which says, my lord, every person should be given an entitled to participate in the election process.
What is the use of this section 20 and 121?
I think that eventually, my lord, it will go, my lord. Eventually, it will
Already
go.
it has gone.
Already it has gone.
Yes.
Now, my lord, more than 975, my lord, societies have been permitted to vote. Now, my lord, the petitioner, who is a delegate from, my lord, one particular
It is
society.
only undoing the statutory provisions. That's all.
There is an exemption, my lord, which is given. My lord,
There must be some basis, sir.
My lord, basis is
giving
this.
such
My
exemption.
lord, basis is this, my lord. Basis is, my lord, more and more people, my lord, become a part of the cooperative movement. My lord, cooperative movement cannot be restricted. So, my lord,
Purpose that restriction was imposed.
Yes,
At least
ma'am.
1 year should be elapsed. With some purpose, without any purpose, that
Lord,
section
that-
was,
yes, my lord.
restriction was imposed.
Now, my lord, elections have been held. My lord, this notification
Or
has.
will become very active at the time once this
That is the
calendar
first
of event
aspect.
is.
Second aspect is, my lord, this number game which my learned friend, my lord, very conveniently pulls out of his bag every time. My lord, he will paint a picture as if, my lord, 8 is on that side, 7 is on this side, 1 vote. My lord, not a word in the petition, my lord. But all this is to only, my lord, engineer the minds, my lord. 8 on that side, 7 on this side. So this one society will make a difference, my lord. Not one word in the petition. He is entitled to raise it. I am not saying he is not entitled to raise it. But question is, my lord, has he raised it? Is there one word of that, my lord, in the entire petition? Does he allege malafides, my lord, as he argued before this court? But nothing is there in the petition. What the courts have been telling, my lord, is unless you make out a ground, but something which is not contained in the petition cannot be made as a ground. Well, nothing of this is there. What my learned friend argued, my lord, is not there in the petition at all. I will just place reliance on one judgment. Lord, why I have, my lord, placed reliance on this judgment, my lord, is it culls out various other judgments. Lord, please see.
You are
Para
for-
4.
you are for respondent number?
6, my lord. I am for the society. My lord, if there was somebody, my lord, challenging this notification from my society, my lord, the matter would have been different. My lord, this is another way, my lord, somebody else, my lord, I cannot, my lord, poke my nose into my neighbor's issues. My lord, I will keep my house in order. If there is something, my lord, my society members will come before this court. That is a different matter.
Now, he cannot come before this court and say prevent him from voting or don't allow him to participate, because my lord, staying of this would mean that my lord, certain persons are not entitled to participate in the election process. My lord, please see, my lord, para 6. On perusal of the pleadings available on record, it appears no material has been produced to substantiate the allegation made in the writ petition. Rather, the pleadings have been made in a general manner without producing any material to substantiate the allegations and substantiating the same. Here also, my lord, nothing is there. Not even a general allegation is there. Then, my lord, para 8, 9 and 10, my lord, various judgments of the apex court, my lord, are called out, which is why, my lord, I brought this because it covers all these judgments. In view of the aforesaid law laid on by the apex court, and from the perusal of the prayer in the writ petition mentioned above, it is clear prayers made in the writ petition are general in nature. It is submitted that the counsel for the petitioner that there is an apprehension of irregularities and malpractices that is in that petition. So therefore, my lord, all these, my lord, numbers which were given to this honorable court, saying that there are 8 on this side, there is 9 on the other side, or 7 on the other side, and therefore there is an imbalance. Now government is stepping in to fill this gap so that it becomes equal. No, nothing prevented him from putting it in black and white on paper. Then, my lord, there would have been some substance. My lord, all these things are made in air. And my lord, my respectful submission is that cannot be considered by this court at all. No opportunity is given to meet these allegations. At the last minute, my lord, he cannot come and say all these things. That is the first aspect. Second aspect, my lord, is locus. Of course, the learned additional advocate general, my lord, has argued on locus. My lord, what is the right that is going to get affected? My lord, if somebody is prevented from participating in an election, yes, my lord, his right gets affected. But if persons are permitted to vote, my lord, his right is not affected. It is only in his mind that there are 8 persons who are going to vote for him, 9 persons who are going to vote for the other side, everything in his mind, my lord. My lord, there are any number of cases where, my lord, just 1 or 2 days earlier to the election, my lord, people have come before this court, petitioners have come before this court saying that our names are included in the ineligible voters list. Therefore, it must be stayed and we must be permitted to vote. My lord, in each of those cases, my lord, court has found favor and permitted them to vote because, my lord, if there has to be a discretion that has to be exercised, it has to be exercised, my lord, in favor of persons participating in the election rather than curtailing it. Yes. No, my lord, power is there, section is upheld. This very same notification, my lord, coordinate bench has, my lord, upheld it, saying that on the basis that this is challenged at this point in time, election cannot be stopped. And, my lord, therefore, my lord, the same thing will apply in the present case as well. Nothing new has been, my lord, stated in the present petition. My lord, the delegate from the 6th respondent society, my lord, has already gone, my lord, registered. His name finds a place in the, my lord, voters list.
Not there. It's not there. In the voters list, it can't be there. Final voters list is already come out on 24/11.
But he is a delegate. Delegation.
Delegation might have gone. It is not there in the voters list as on 22/11. That's a wrong statement.
Respondent, my lord, delegation has gone. My lord, he will represent the society. His delegation form is lodged, and therefore, my lord, he will be permitted, my lord, to participate. But just like he would say, my lord, he is a delegate and he has got a right to participate. My lord, he cannot prevent the delegate from the 6th respondent from participating. That would, in fact, my lord, come in the way of fair elections. So therefore, my lord, no ground is made out as has been made in the earlier, my lord. All these things require consideration. At this stage, it cannot be interdicted.
Just 2 sentences which I wanted to add. Lords, the earlier writ petition which came about before this honorable court was a notification under which it was in respect of about 900, beneficiaries would have been 975, but it said that all the societies which are registered on or before a particular cutoff date, irrespective of the society as such, every society which is registered on or before 30/4/2025, they are eligible to vote in the federal society. Next, what happened? What is very critical, my lords, in that case was, after this notification was made, their names were included, my lords, in the eligible voters list. Let's kindly have a look at paragraph number 8 of that order. What is the difference between this case and that case? In that matter, I just read one sentence. Referring to Annexure H, Rule 13D4, of the Karnataka Cooperative Societies rules, the learned Advocate General points out that the provisional voters list was published on 10/6/25 and no objections were raised by incorporating those 975. So that was a case where the voters list was yet to be finalized. That's essentially, my lords, where it stood. This is number one. Of course, there is no answer to that. So far as locus is concerned, there is a vested right in a contesting candidate that he will face the electorate, not the unknown electorate, not the ineligible electorate. Only the known electorate in terms of the final electoral list prepared in terms of Rule 13D, 2A6 and 3D. There is no question of me being exposed to any other contest. I'm so grateful for the hearing, Milords. And one more contention is that case, Milords, the earlier bench did not consider the judgment in Channappa's case. That's already the expressed view.
See, already your main prayer is to declare that the sixth respondent society is disqualified from voting.
Yes. I'm only seeking stay of that, Milords. He cannot be permitted to vote.
Let him exercise the right of vote subject to the result of the writ
Can I
petition.
do this? Can I say this? Let him exercise the right of voting, because your lordships have consistently taken a view that he will be permitted to vote. But he has to, Milords, contest the proceedings for his vote to be counted. Now, hands down, his vote will be counted and then the entire electoral process gets dislodged, cannot be happen. So in such circumstances, what your lordships have consistently passed the orders is, his vote will be casted, it will be kept separately. Without his vote, the counting will take place, subject to the outcome of the writ petition. If eventually my writ petition is dismissed, then his vote will be counted. So that's how his interest can be safeguarded.
Yes.
Milords, call the election process, Milord. One vote cannot be identified and isolated.
Of course, now you.
That's how it is done in every case.
And Milord, main relief and interim relief, Milord, virtually is the same, Milord.
This way, I
Can
permit
be
respondent number six
Very
to
well.
vote.
Very well.
And initially, let it be kept separately. And
Subject to
let
the
us
outcome
see
of the writ petition, it will be decided.
See what happens.
Milord, then the results cannot be declared because, Milord.
Results has to be declared. Subject to outcome of the
voting,
writ petition, it will still be there.
You can come back.
That's it.
The counsel for the then senior counsel for the petitioner and an additional advocate general for respondent number then counsel for respondent number 6, 7 ಅವರನ್ನೆಲ್ಲರೂ ಹಾಕೊಳ್ಳಿ. Both the learned counsel for both the parties have addressed their arguments at length. According to the learned senior advocate for the petitioner, Annexure D is nothing but a political interference in permitting respondent number 6 society as 7 society. Respondent number 6 society to permit vote in the voters list of a 7th respondent is without any reason which is against the scheme of the act, the object with which the cooperative movement was placed. The petitioner, being the delegate of respondent number 6 society, is entitled to maintain the petition, and his right will be adversely affected if respondent number 7 society, if respondent number 6 society is permitted to cast its vote. When admittedly it was registered only on 13/9/2025 as a member of BDCC, that is respondent number 7. He refers to section 121, rule 13D, 2A, 4 of Cooperative Societies Act and rules to contend that it is the blatant violation of the provisions of law which were enacted with laudable objective. Per contra, Learned AGA, Additional Advocate General, for respondent number 1 and counsel for respondent number 6, opposing the petition submitted that the petitioner has no locus standi to file and maintain the petition. His right was never curtailed by issuing an XRD, but respondent number 6 society is permitted to vote. The name of respondent number 6 society is permitted to be included in the voters list so that it can exercise its right in the election that is to be held for respondent number 7 society on 7/12/2025. If the contentions of both the parties are to be traversed at this stage, it would be an order disposing the petition itself. Even though they have addressed their arguments for grant and opposing the interim prayer. Therefore, I am of the opinion that at this stage, respondent number 6 may be permitted to cast its vote in the election that is scheduled to be held on 7/12/2025. And his vote, the returning officer may be directed not to count the vote. The returning officer may be directed to declare the election subject to the result of this petition. Accordingly, I proceed to pass the following. Adanya Madi. Next, having said that, learned counsel for the petitioner and the respondents are required to address their arguments on merits on the next date of hearing. Since the result of the election is held to be subject to the result of this petition, as the right of the candidates would be jeopardized if the result is withheld for an indefinite time. Yes. Respondent number 6 is permitted to cast its vote subject to the result of the writ petition, but both the parties shall address their arguments on merits.
Your Lordship may direct that his vote should be kept in a separate sealed cover.
Yes, sealed cover.
And
but provided both the parties should address the arguments on merits on the next date.
Very well, my lords.
Indefinite.
No, your Lordship may fix a date in the next week itself, my lords.
Next week agala. Last. Nodi agala. Any date.
Other than this argument, I have got only 2 judgments to cite. Other than that, I have nothing else to say.
It is as good as disposal of the
That's true, my lords. Your Lordship's memory, it will be ripe in your Lordship's memory, my lords. If it is taken up next week, I will not take more than 10 minutes. I am having your Lordship's
date will be given.
Very well.
On that day, please address the argument.
Please.
Serial number 5. Yes, Saravana, Nataraj Baba.
Lord, same Chanpatna constituency, 8 petitioners came before this honorable court.
Wow.
Lord, your Lordship's passed same 8 persons.
As an order, my lord.
Same.
Annexure C series. Lords, now I am only saying, let them not pass any orders till 7th. After 7th, let them do anything.
What is the order passed yesterday?
Lord, yesterday, what my lord has said
Similar
is
petition.
3/6, my lord, triple two
3/6.
of 2025.
3/6/222 of 2025. Yesterday, my lord, 2 orders have been passed.
Yes.
Same orders can
Similar
be,
order.
say similar order can be.
Also, I'm really not aware as to what orders are passed. Can I just persuade your Lordships to have a look at?
You go through that order.
ಇಲ್ಲ ಇನ್ನೂ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅದು
Lords, there
Then
is
what
already
the
an,
order? You may be knowing.
Regarding, my lord, not to tinkering that, my lord, the senior council.
What my lords have said is, my lord, whatever is
except by
permissible,
operation of law.
except by operation of. There will be no
Lords, this is the
tinkering
reason,
except
Lords,
by operation of law.
I just wanted to say this. Those matters have come before this honorable court for the first time. We are now coming before this honorable court for the second time. Lords, your lordships had passed an order in the first instance. Your lordships may kindly have a look at the order passed at Annexure C series.
Similar matter, if an order is already
Lords,
passed.
there, that's the reason why I said, there they would have come before this honorable court challenging the 29C notice for the first time. We are already before this honorable court challenging that order.
Again, what is your apprehension?
ಅವರು ಅಪ್ರಹೆನ್ಷನ್ ಮೇಲೆ ಬಂದಿರೋದು ಈಗ 4ನೇ ತಾರೀಕಿಗೆ ಹಿಯರಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. 4ನೇ ತಾರೀಕು ಅವ್ರು ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ.
It is an apprehension, my lord.
No, it is not a question of, Milords, I will just indicate, Milords.
See, yesterday I passed an interim order.
Milords, I am only submitting, Milords, that let them not pass any orders till 7th. I am not saying anything else. Milords, I have already placed.
Let the order be uploaded first. Let me see. Adi enagutte. Next Monday.
Milords, elections will be over by then. 4th, I will be disqualified. Milords, it's a writing on the wall. I will be. Milords, Milords, they have already given the cause notice.
Tomorrow.
Serial number 6.
ಅದು ಇದನ್ನ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ.
Milords, serial number 6.
ಇದು 1 minute. 5 ತಾನೆ.
Lord, this again, Milords,
This is the order. It is not at.
Very well, Milords. I just quite quickly.
Just look at it. Notice. Finally, ಯಾರಿಗೆ?
The serial number 5 notice.
Please.
Serial number 5.
Milords, can I just, this matter, there is only an apprehension, Milords. In our cases, 29C notice was issued. We challenged it before this honorable court in the first round. Lordships may kindly take serial number 5, Milords. I'll just indicate as to what is the difference.
PGA takes notice for respondent number 1.
1, 3, 4, 5, and 7. 7 and 8.
7 and 8.
9 ಅಲ್ಲಿ.
6K, that's right.
9 ಅಲ್ಲಿ ನಾನೇ respondent ಗೆ ಬನ್ನಿ.
Then
6 Natraj.
6 Natraj takes notice for respondent number 6. ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ? ಅಷ್ಟೇ.
Please. Milords, may kindly have a look at Annexure C at page number 35.
In order.
Because it's a mere apprehension which that express that their names will be excluded from the eligible voters list. But here is a case where they have issued 29C notice. Kindly have a look at Annexure C1 at page number 35, your lordship's order.
Page number?
Page number 35, Annexure C1.
This is the earlier order.
Well, this is the earlier order which specifically said 2 weeks time is granted for the filing of the objections. And if any irregularities is found, 3 weeks time should be granted for us to comply with the irregularities. And thereafterwards to pass an order in accordance with law. That essentially goes beyond 7th. Now a notice is issued for us to appear on 4/12. Milords, I am making a statement, Milords, it is not an apprehension. Milords, kindly have a look at the documents which I have produced at Annexure D, page 45. This is not the first time they are doing this. Pertaining to Chanpatna, they have done it. Annexure D series. Same Chanpatna MPCS, they did it. Milords, overnight. For 18 societies, they disqualified them overnight.
Now 29C again issued.
29C is again issued to us, saying that you appear on 4/12.
Not issued. They have been given time.
Milords, we are filing this memo kottide. We are filing the memo, they have already issued once again. Karana keluva notice.
It's not 29C.
Not 29C.
It is not.
29C ಅಲ್ಲ ಅಂತ ಹೇಳಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬಿಟ್ರೆ ನಂದೇನು ತಕರಾರೇ ಇಲ್ಲ. This is not a proceedings under 29C ಅಂತ. ಅಲ್ಲಿ ವಿಷಯ ಇದೆ ಓದಿ.
It is only a show cause notice.
It is a show cause notice under 29C asking us to appear on 4/12.
There is specific order, my lord, regarding.
Not
based on
4/12.
In pursuance of the interim order, this notice is given.
I just wanted to say this, Milords. This is not the first time this has happened. Government, as I submitted earlier, my lords, the courts are not going strict on the government and are we unreasonable in asking that let us be lordships.
As per the order annexed C1,
Yes.
you are permitted to file your reply.
Please. We have submitted our reply. We have submitted our reply. They have to conduct an inquiry. Lords, now, why again on 4/12 they are calling us? Lords, let them have this hearing date after 7th. Lords, your lordships can only make this request, lords. I will seek for an adjournment. Let them adjourn it on 8th. I will go and participate in the proceedings. From 4th, let them adjourn it to 8th. Lords, my apprehension, it's not my apprehension, they will do it.
Regarding my lord, lordship kindly see them, my lord, interim order. Definitely say that, my lord, if such irregularities and defects are not cured within the reasonable time, my lord.
No, you read it from the top. Show cause notice dated 15/10/2025.
Please,
The petitioners are at liberty to give their reply.
please. 12,
Same by producing documents.
12/11 order, my lord, kindly see annexure C1, my lord.
Yes.
Same order.
35.
What I am
Please, my lord. My lord, last line, my lord, before that, my lord, if such irregularities or defects are not cured within the, my lord, reasonable time of 3 weeks.
So before that, some procedure is to be followed, sir. Here, the petitioner has to file their reply to the
Please.
show cause notice dated 15/10/2025.
On that regard, my lord, we say that in,
Use the document if necessary within 2 weeks
please,
from
Lord,
today,
Lord,
We have submitted.
12/11/2025.
please. On that is the reason, my lord, we have said
2 weeks time, the petitioners will have.
to, my lord, that they have already, my lord, that is the reason we say that other, my lord, defects are there, you will comply ಅಂತ ಹೇಳ್ಕೊಟ್ಟಿದ್ದು. Not like, my lord, kindly see, my lord, annexure, which was a memo, my lord, produced before this honorable court. 27/11,
Irregularities.
please, my lord.
What are the irregularities?
To regarding, my lord,
All, according to them, auditing irregularities. I had argued this matter in detail before lordships. All auditing irregularities is what they are pointing it out. It will never come under the scheme of section 29C. These are all the compliances to be done in terms of section 68. It will never come under 29C. Lords, it is purely an act of mischief. We even filed the affidavit saying that all right, we will comply with everything. Lords, we are saying, let them, I am not shying away from the inquiry. Lords, when these matters came before the first time, I said that I will not shy away from an inquiry. But I don't want to be disqualified by the mischief of the government.
In the show cause notice, there must be some reference to the irregularities.
Yes, my lord.
Yes, my lords.
What are those
Lord, financial irregularities, accounts are not audited.
Lords, kindly have a look at ಅದರೊಳಗೆ ಹೇಳಿದ್ದಾರೆ ಪೇಜ್ ನಂಬರ್ 1 ಈಗ ಹಾಕಿರೋ ಮೆಮೋನಲ್ಲಿ ನಿಮ್ಮ ಲಿಖಿತ ಹೇಳಿಕೆ ಹಾಗೂ ವಕಾಲತ್ತನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಅದರಂತೆ ಉಲ್ಲೇಖ 1ರ ಕಚೇರಿ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ನ್ಯೂನತೆ ಸಂಖ್ಯೆ 1ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಾಲ ವಸೂಲಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಾಲ ವಸೂಲಾತಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 70ರ ಅಡಿಯಲ್ಲಿ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ಕಾರಣ ವಸೂಲಾತಿ ಸಂದರ್ಭದಲ್ಲಿ ಕೆಲ ರೈತರ ಸದಸ್ಯರುಗಳು ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡ ಪ್ರಕರಣಗಳು ಕಂಡುಬಂದಿದ್ದರಿಂದ ವಸೂಲಾತಿಗೆ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಕಲಂ 70ರ ಅಡಿಯಲ್ಲಿ ದಾಖಲಿಸಲು ಕ್ರಮವಿಡಲಾಗುವುದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ನ್ಯೂನತೆ ಸಂಖ್ಯೆ 2ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಜಿಲ್ಲಾ ಸಹಕಾರ ಕೇಂದ್ರ ಬ್ಯಾಂಕಿನಿಂದ ಕೆಸಿಸಿ ಸಾಲ ಮತ್ತು ಚಿನ್ನಾಭರಣ ಸಾಲ ಹಾಗೂ ಪಡಿತರ ಆಹಾರ ಧಾನ್ಯಗಳ ನಿಯಮಿತ ವ್ಯವಹಾರಗಳನ್ನು ನಡೆಸುತ್ತಿದ್ದು ಸದಸ್ಯರುಗಳು ಮನವಿ ಅರ್ಜಿಗಳು ಮತ್ತು ಕೆಸಿಸಿ ಬೆಲೆ ಸಾಲ ನೀಡುವಿಕೆ ಹಾಗೂ ಚಿನ್ನಾಭರಣ ಸಾಲ ನೀಡುವಿಕೆ ವ್ಯವಹಾರಗಳನ್ನು ನಡೆಸಲಾಗುತ್ತಿದೆ. ಈ ಸಾಲ ವಿತರಣೆ ಸ್ವಯಂ ಪ್ರೇರಿತವಾಗಿರುವುದಿಲ್ಲ ಮತ್ತು ಬೈಲಾ ಉಲ್ಲಂಘನೆಯಾಗಿರುವುದಿಲ್ಲ ಎಂದು ಆದ್ದರಿಂದ ಈ ವಿಚಾರಣೆ ಕೈಬಿಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. On 8th, let them take it on 8th. That's it. Please.
Senior advocate for the petitioner, learned MBA person, so responding the same. My attention was drawn to the order dated 12/11/2025, which he reads as under. So idrille read madodu idrille, which permits the petitioner to give the reply to the show cause notice dated 15/10/2025 within 2 weeks, upon which the respondent shall hold an inquiry and communicate its finding to the petitioner. Thereafter, respondent, even thereafter, if respondent number 2 finds that the irregularities are not cured by the petitioners within a reasonable time, within 2 weeks monthly. As per order dated 12/11/2025, petitioner was permitted to give the reply to the show cause notice dated 15/10/2025 within 2 weeks, upon which the respondent was required to hold an inquiry and communicate its orders to the petitioners. It is further ordered that if it was confirmed by respondent number 2 that there are irregularities which are to be cured by the petitioners, it shall be provided reasonable opportunity to the petitioners to do the needful. Next part. It is stated that in the meantime, a second show cause notice is issued. It is dated 27/11/2025. Therefore, the petitioner is having the apprehension that fixing the date for inquiry on 4/12/2025, that is before the date of election, the respondents may play with the rights of the petitioner. Considering the substance by both the parties, I deem it appropriate to direct. Who issued the show cause notice? Respondent number?
It's issued by ERCS.
Respondent number.
Respondent
5.
Respondent number 5 is directed to fix the date
Captain Abeyance.
petitioners are permitted to submit the reply to the show cause notice dated 27/11/2025 within 8/12/2025.
Please, minutes.
Within 8/12/2025, you have to file your reply.
Please, minutes. We shall do that.
Serial number 6, S. Saravana.
Lords, this your lordships may pass similar orders as which your lordships read at annexure C1. May just pass on this judgment. Order, my lords. This is pertaining to Anikal constituency of the DCC Bank. Again, the same thing, my lords. All auditing issues. If your lordships were to take the chart which I have prepared at page number 7 of my writ petition, what are the charges? What is my contention which I have indicated, my lords?
When a DG takes notice for respondent number 1.
Respondent number
4, 5,
1, 3,
4 and 5.
4, please.
2 is A.
2 is A.
Takes notice for respondent number 2.
This is Natraj is there. Natraj takes
my lord.
notice.
For respondent number 6, sir.
Natraj will take notice for DCC Bank. They are appearing.
Natraj takes notice for respondent number.
If your lordships were to see annexure, page number 7 of my writ petition, my lords.
Similar notice was issued.
Exactly the same notice in order to indicate there is no serious allegation against us. Whatever they have stated, my lords, are all auditing discrepancies according to them. We have explained as to why this none of these allegations are correct in page number 7, para 5.
29 C notice, my lord.
So we may be given 2 weeks time, my lords, to file our objections. Similar orders.
Order, my lord, but there's a serious charges there, my lord. Point number 6, my lord, 22. Page number 22, my lord. ದಿನಾಂಕ 15/3/2025 BDCC ಬ್ಯಾಂಕ್ ಆನೇಕಲ್ ಶಾಖೆಗೆ ಬ್ಯಾಂಕಿನ ನಿಯಮಾವಳಿ ಷರತ್ತು 1,63,00,000 ಸಹಾಯಧನ ಪಡೆದು 24 ತಿಂಗಳ ಸಮಕಂತುಗಳಲ್ಲಿ ತಿರುವಳಿ ಮಾಡಬೇಕಾಗಿದ್ದು
Yes, proceed with the
Please.
with the matter.
Even that we have stated, I think my learned friend has read the writ petition, annexure E, page 25, that money is paid.
Yes, in a time bound manner, let them.
Please.
Fill the defect, no doubt. Yes, similar order.
Grateful, my lords.
Please.
Number 7, TB Sandesh.
Nine, ಆ ಕಡೆ ಹೋಗು.
Lords, this honorable court was
AG takes notice for respondent number 1, 3,
Please.
4, 6, and 6.
3, 4, 6, madam.
6. 2 is same. Devra takes notice for respondent number 2. Issue notice to respondent number 5. Yes.
My lords, kindly see the annexure C, my lords, on 3rd November, this honorable court directed the returning officer to declare the election result without counting the cast by the petitioner, my lords. Votes cast by the petitioner. My lords, since my lords, they have not declared the elections, even though my lords, we have given a representation on 18/11/25, my lords.
My lord, kindly see, my lord, there is an order passed by the coordinated bench of this honorable court, page number, my lord, 31C3. Coordinated bench of this honorable court, my lord, page number 31, annexure C3, my lord. Lord, kindly see, my lord, page number 36, my lord, para number 6.
1 minute.
It specifically contended that, my lord, given direction, after section 70 dispute resolved for that, my lord, then only you declare the results. Because here, my lord, all society, my lord, primary societies, they kept in separate ballot box, my lord. All votes which were, my lord, taken by this honorable court, my lord, they have been once na open madidre elladu madbekagutte. Kindly may I read, my lord, the thought.
My lords, the petitioner shall raise a dispute before within a 15 days, my lords.
Sir, coordinate bench has passed an order.
After
And
that,
also specific direction, my lord, not to announce the results
after
unless
that, my lord, this honorable court passed and similar matters, my lords, saying that
Yes, I have passed, but the coordinate bench has passed an order.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ ವಿತಿನ್ 15 ಡೇಸ್ ಒಳಗೆ ಎಲೆಕ್ಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಹಾಕಿ ಅಂತೇಳಿ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್, ಮೈ ಲಾರ್ಡ್.
dispute is filed, my lord. I will place before this honorable court. Kindly see,
In
my
15 days they have not filed.
the learned, my lord, may I read, my lord, last portion. This honorable court cannot exercise the jurisdiction of article 226 of the constitution of India. To my lord,
Lords, page 37, my lords.
Last fourth line.
Sixth line, my lords. The petitioner shall raise appropriate dispute before the concerned authority under section 70 within 15 days from today, challenging the inclusion in the ineligible voter list. The authority shall consider the petitioner in accordance with law and take appropriate decision in the matter within 3 months thereafter. The result of the election shall be thereafter declared in accordance.
My lord, please.
Who are the parties in this?
My lord,
In first petitioner,
Sole petitioner Ramegowda.
please, my lord. To regarding, my lord, this is all primary societies. The, my lord, interim order passed by the honorable court, my lord, at the time of interim order, my lord, we have kept the all votes in separate ballot. Once, my lord, we have opened, my lord, it is, my lord, then it should be declared as a vote ಯಾರಿಗೆ ಎಷ್ಟು ಇದೆ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. That is the reason, my lord. And also, my lord, kindly see, my lord, para number 30, page number 36.
When you raise the dispute,
My lord, my lord, dispute is within filed, my lord, within 15 days, my lord, as per my instructions. And my lord, the date 12th, my lord, the hearing date is, my lord, fixed.
3 months time is granted.
Please, after that, my lord. 2, my lord, 2 months ಅಷ್ಟೇ ಆಗಿರೋದು, 3 months ಆಗಿಲ್ಲ. Kindly see, my lord, order.
ಅಲ್ಲ ಇವಾಗ ಎಷ್ಟು ದಿನ ಆಯ್ತು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಿ how many days?
2 months ಆಗಿದೆ.
2 months.
Please.
Still 1 month.
Please.
Month. ಅಷ್ಟೇ wait for sir 1 month. I will record his submission.
Please,
The dispute
within
is
1
already
month
raised.
today, please.
Already raised. That is the third learned counsel for the petitioner and learned AGA for so and so. Counsel for the petitioner pays for passing the interim order as paid for, contending that deliberately the results are not declared in spite of specific direction.
Lords, one intelligence, my lords, annexure C, the Arunodaya Multipurpose Cooperative Society in the Annexure C, Adrallu Matte Annexure C2 Ibru Onde party idare. They are the same parties. Annexure C2, my lords.
My lord, is a delegation, my lord, is society same.
ಏನಾಯ್ತು
They are the same society, my lords. Annexure C2 ಅಲ್ಲಿ M. Asha, delegate of Arunodaya Multipurpose Cooperative Society, and kindly see the Annexure C page 31, my lords. The petitioner number 1 is Arunodaya Multipurpose.
ಆಯ್ತು sir, there is an order, annexure C3 is the order.
Please.
How can I say that violate that order and proceed?
ಅಲ್ಲ, even though my lords 3 month lapse ಆಗಿದೆ ಹಾಗೆ.
Well, 3 month ಆಗಿಲ್ಲ. Then I will file affidavit, my lord, I will file affidavit.
Per control and AG corresponding the so drawn the attention of the court to annexure C3. The order dated 26/9/2025 passed by the coordinate bench of this court, permitting the petitioners therein to raise the dispute before the appropriate authority under section 70 of the Act within 15 days from the date of order, challenging inclusion of the ineligible voters list, and also directed the authority concerned to consider the petition in accordance with law and to take appropriate decision within 3 months thereafter. Next, when a AVA submits on instructions that such a dispute is already raised about 2 months back, and the directions issued by the courts will be abided by in letter and spirit. Submission is placed on record. This round. Next.
Number 8.
May I appear for the petition? This is also the same matter, my lord, which your lordship passed the order on the other day. But here, yes, but here, one difference is that I have sought for stay of another section, which by oversight, which I
It
had
is
not
not,
sought in
it is not
earlier.
similar matter, my lord, it's different matter. To regarding, my lord, that petition, my lord, they're challenging 53A. My lord, in this case, my lord, they're challenging in different sections.
Madam, 53A also verbatim, my lord, is a copy of that petition. Madam, in the interim order, I have sought an additional prayer.
No, you are seeking,
Only in the interim order portion, my lord, which was left out. Kindly see, my lord.
you are challenging various provisions of.
Please, my lord.
Yes, yes. This is section 29F1A. That is the additional interim order which I have.
My lord, this honorable apex court,
Madam,
honorable, my lord.
Two,
repeatedly
both
says-
these sections are subsequently inserted now. Its validity will have to be tested before this constitutional court. On the face of it, my lord, they are so arbitrary and unreasonable.
No arbitrary, my lord. Two reasons, my lord, is recorded by the, my lord, legislator.
Say,
whatever, my lord, Gram Panchayat, my lord, having the roster, my lord, that has been adopted here also. And also, my lord, apex court say that, my lord, to regarding that when, my lord, validity is challenged, my lord.
See, in the interim prayer, you refer to this section 29F.
yes,
53A. of
yes,
Cooperative
53A, your lordship has said, my lord, already said. This 29F says, my lord, your lordship may kindly see that section which I have produced.
The various of that section you have not challenged.
I have challenged. Kindly see, my lords. Section 11 of the Amendment Act,
29F.
issue writ of mandamus.
29F.
Yes, that is section 11 of the Amendment Act, introduces section 29F. I have challenged. Only by mistake. But kindly see, my lord, issue a writ of mandamus prayer, my lord. Issue a writ of mandamus on any other appropriate writ, order or direction declaring amended section 21A1, 21A11, comma, section 6, section 7, section 10, section 11. This is section 11. Section 13, Section 17, 20, 23 of the Karnataka Cooperative Societies Amendment Act 2025. Act number 73 of 25. Now kindly see the section 11. At page 31, in page 31. Your Lordship gets it. Page 31. Annexure A. In page 31. Yes. In the Principal Act in section 29F, after subsection 1, the following subsection shall be inserted. So a new insertion, namely, subject to the order of the Registrar of Cooperative Societies, there shall be reserved such a number of President and Vice President of Primary Agricultural Cooperative Society, Milk Producers Cooperative Society, and other primary assisted society in the state for the scheduled castes and scheduled tribes, other backward class and women on rotation basis in the manner as we prescribed. So this provision is challenged.
29F, my lord, separate section.
One, nomination. Second, this rotation, rotation basis, they will reserve that post.
My lord. To regarding, my lord, the statement objections to regarding the act why, my lord, amended, my lord. May given, my lord, on that regard, my lord, I have filed a statement objections to
While in the meantime, the similar order.
regarding, my lord, this society is concerned, because, my lord, this repeatedly, my lord, this honorable apex court say that, my lord, when valid is challenged, my lord, interim order is concerned, my lord, lordship, my lord, to that it ought not to be given, my lord.
At the time it is decided, the damage will.
To regarding damage, my lord, rule is not framed in, only act is amended, my lord, rule agbekadre ಮೇಲೆ. How, my lord, we will given the rotation?
I am told for some society, they have already nominated. List is ready, everything is ready. All these
let them
things
give,
are
my lord,
only.
let them give, my lord, the document, my lord, I will take instruction on that point. Without rule, my lord, how can, my lord, we insert that, lord?
Then I will record his submission.
But no.
The rule is not framed.
And they let them say, my lord, that they will not nominate it till the rules are framed. Let them say so. And this is also not, this will not be brought to operation till the rules are framed. Rules are not necessary strictly. They will under this provision itself, they will nominate.
The petitioner and AGA for respondent members.
Instead of he taking a responsibility like that.
Order. Similar to the one passed in WP number so and so, dated 27/11/2025. However, Learned AGA opposing the submission made by the Learned Counsel for the petitioner submits that the rules under the amended provisions of the Act are not yet framed.
As on the.
Framed. Unless the rules are framed.
Can I?
Unless the rules are framed, there is no question of appointing, nominating any members.
It is not nominating, my lord. It is a reserve for that post for president and vice president, my lord.
Under election,
to please, my lord.
29F.
The election is concerned, my lord.
Yeah,
that post should be reserved for that, my lord, to those who are, my lord, backward caste.
Preparations
Regarding, my lord, preparation election
let the liberty be reserved for them to file objections and even an application for vacating the stay. For the present, my lord, when the provision is
pertaining to this society is concerned.
Framed. Unless the rules are framed, there is no question of reserving the post for the categories stated in the amended provision. He prays for time to file statement of objections. Mr.
Lord, regarding this society is concerned, my lord, and entire society, my lord, stays, my lord, ultimately this. Please.
In submission record.
Please.
Yes.
And that is worse because he can't appoint for any society. Still the rule is framed. And ask let this be connected with the WP 35549 of 25.
Counsel for the petitioner connected,
Please.
Counsel for the petitioner
Yes.
service that
I will give the number.
the number so and so is connected with the present petition. Office is directed to list put these cases together. Yes.
R. Subramania, Arun Kumar Vayyar.
This is a case where not, sir,
I mean,
the
he takes notice for respondent number 1, 2, 3, 5. 2, 3, 5. 4 and 6. Who is representing?
Please, ma'am.
4 and 6. Whom you are representing?
Lords, we are for the caveat.
DCC Bank. Lord, sir, there is
Which
no,
respondent? Respondent in law.
there is no respondent, my lord, as such. My lord, since, my lords, the office has
R6,
raised an
R6. R6.
R6. Shivanna.
Shivanna.
Respondent number 6.
Correct.
Petitioner. So and so. Then what about 4?
Nataraj, my lord.
ಅದು,
Nataraj, Land Council represents respondent number 4. Takes notice of that. Yes, sir.
Lords, this is a case where, lords, the order, lords, which is impugned at Annexure A, lords, is passed. Lords, may I just, lords, narrate few facts, lords, for the, lords, this petitioners, lords, are the members of, lords, the primary society, lords, which is a rural development bank. Lords, there was an election, lords, which was scheduled to be held, lords, on 16/1/2025, 16/2/2025, for the primary society. Lords, even before that, lords, they published, lords, the list of eligible voters, ineligible voters. Lords, in neither of, lords, those lists, my name, lords, was indicated. I approached this honorable court, lords, by filing writ petitions. Lords, this honorable court passed an interim order. Lords, may I just point out, lords, Annexure D, page 30, permitting us, lords, to vote and as well as contest, subject to, lords, outcome of the proceedings. Lords, subsequently, lords, the writ petitions
You are permitted to contest.
permitted
and vote.
to contest, lords, and also to vote. After that, my lords, the matter was finally disposed of. That is on 14/3/2025, my lords, in case of second respondent, and, my lords, on 20th of March 2025 in case of first petitioner.
So two separate writ
Two
petitions
separate
were
writ
filed.
petitions were filed. Lords, both the writ petitions were disposed of. Lords, confirming the interim order, and the parties were, lords, called upon. If anybody is aggrieved, they are at liberty to raise, lords, dispute under section 70. What happens, lords, is that the dispute, lords, under section 70 has been raised by, lords, the respondent number 6 herein, Shivanna. Kindly see, lords, the date on which, lords, the petition is filed, dispute is raised. That is, lords, on 2/5/2025. Lords, the only contention, lords, that is raised is that the share amount, my lords, I have paid 500 rupees, but not 1036, my lords, which is subsequently raised. Lords, initially it was 100 rupees, then later on, my lords, the share price was, my lords, increased to 250 rupees, then to 500 rupees. Now, my lords, it is 1036 rupees. The only, my lords, point is that this balance amount of 500 rupees was not made good, of 536 rupees was not made good. So far as, my lords, attending the meeting is concerned, availing the services is concerned, there is no dispute at all. But however, my lords, my name was not also reflected in the eligible voters list and as well as, my lords, ineligible voters list. That is how, my lords, I was constrained to approach this honorable court. Lords, later on, when this honorable court permitted me to contest and vote, my lords, then I was also elected from that primary society.
that is on Lords 16/2. The results were declared on 24th of April 2025.
Yes.
Lords, thereafter, the dispute is raised on 2/5. This dispute was kept, my lords, till now. Lords, so far as my lords BDCC Bank, that is Bangalore, my lords, District Central Cooperative Bank, is concerned, my lords, the election is notified, and I was notified, my lords, as the eligible candidate for contesting elections. Lords, kindly come to page
When the
83.
election, when the election.
Election, my lords, is on 7/12. Now the dispute, my lords, is disposed of, stating that, my lords, since I did not make good of, my lords, the 500 rupees of the share balance amount, that is why I am not eligible to. But this is, my lords, this entire process, my lords, was kept pending, but they did not pass any orders. Now, my lords, they pass an order. Kindly see on 27th. That is on, my lords, Thursday evening, my lords, the order is passed. I get it, my lords, on Friday. Saturday and Sunday, my lords, the courts are closed. Even I cannot, my lords, approach this honorable court. Yesterday, my lords, I filed the writ petition. I moved this honorable court, my lords, for taking up the matter.
You could have paid the deficit.
Lord, I have paid, my lords. Kindly see, my lords, even before the dispute is raised, I have paid the amount. My lords, that is at page number B, my lords, page Annexure C, page 29. This I have paid, my lords, on 20th of March 2025 itself. 600 rupees, my lords, I have paid.
Page number?
Page number, my lords, 29, Annexure C. This particular fact, my lords, was available in the file, my lords, in the records of the society. The registrar, my lords, does not look into these things, but he only considers the allegations or the averments made by the person, my lords, who has raised the dispute. And thereafter, my lords, this order is passed.
That is the only ground.
That is the only ground, my lords. Kindly see, my lords, page 23. Lords, Annexure A commences, my lords, from page 20. Lords, page 23, my lords, is the reference to it.
Yes, yes, what is it?
And, my lords, one more submission, my lords, is that I did not receive any notice, my lords, while preparing the electoral list. But they are required to publish who are the defaulters and who are, my lords, required to make good of, my lords, certain amounts due to the society. I did not receive any notice. That is, my lords, my categorical contention, my lords, that I have maintained even, my lords, before the registrar also. That particular aspect, my lords, has not been considered at all. He doesn't even, my lords, call for the records, look into the records. Two aspects, my lords. One is that I have made good, my lords, even before the dispute is raised. My lords, even otherwise also, my lords, there was no notice issued to me. I did not receive any notice. If at all, my lords, there is any notice, they should have, my lords, produced it before the court.
Lords, may kindly see the prayer. He is seeking for quashing of the award passed under section 71. It's an appealable order under section 105.
Yes.
So lordships have taken a consistent view. Appealable orders, they will have to file an appeal.
Right, but by the time he prefers an appeal.
I will just indicate, my lord, this is the first contention. Lords, may kindly see the writ petition pleadings, my lords. Because there is something wrong with what the petitioner has presented himself before the court. Paragraph number 2 of the writ petition pleadings. They can't succeed. There's no locus for them to file the petition with this. The petitioners are the permanent members of the Bangalore District Cooperative Bank. Petitioners are eligible members for contesting. Lords, it can't be because it's a federal bank. The petitioners at the most can be the delegates. There is no pleading. Let me complete. There is no pleading that they are the delegates of any cooperative society.
Until and unless there is a pleading to the effect that they are the delegates of any cooperative society, they don't have a locus to come before the court.
Page 83 may kindly be seen, my lords.
No, that
Page
pleading is
83.
not there.
No, no.
Third contention. Adu ಹೇಳ್ಬಿಡ್ತೀನಿ
They are
ಬೇಕಾದ್ರೆ.
going on, my lords, technicalities. My lords, kindly see page 83. It is the
Pleadings.
So
list.
there can be such a pleading, sir.
Lords, I am, lords, in view of, my lords, the urgency, my lords, it should have been, my lords, the primary society, not the, my lords, BDC.
Even the primary society, my
Page
lords,
83,
against.
no, page 83 may kindly be seen, my lords. This is the final list that they have published. My lords, in which, my lords, they specifically mention about.
The other
Lords, then the proceedings were taken place on the basis of their disqualification as on the date of the preparation of the electoral rolls. Lords, he has admitted he is a defaulter. Lords, may kindly see Annexure C. 16/2/2025 is the date of election. 15 days prior to the date of the election, he is required to pay the dues. The share amount, holding of the share amount, or the Susti amount, whatever is to be paid is to be paid.
Unfortunately, his name was not reflected either in eligible voters list or
Lords,
ineligible.
now after that, if your lords were to see, because what this honorable court did on the last occasion was, he was permitted to vote and contest. No contention was looked into by this honorable court. It said that everything has to be looked into under the section 70 dispute. Now, if he pays the money after the election is held, Lords, may kindly see Annexure C, he is admitted. And I'll also indicate, my lords, he is not the person. Lords, may kindly see page 29. The person who has filed is Basuraju, son of Bachappa. Basuraju, son of Bachappa, is added in this petition as the second petitioner. Basappa, whatever his name is. So far as this first petition is concerned, there is nothing to indicate that they are not the defaulters. There is no question of a defaulter contesting the elections. And worst situation, I just wanted to say this, page number 83, what my learned friend is referring to, page number 83, na?
Yes, 83.
83.
83.
Nimdu eshtiದೆ serial number?
Namdu serial number 101.
Lords, if
Page
you are
97.
Now, page number 97. Horticulture produce alla. ಇದಲ್ಲ ನಿಮ್ದಲ್ಲ ನಿಮ್ದು ಎಲ್ಲಿದೆ ಅಂತ ಅದಕ್ಕೆ ಕಾಣಲಿಲ್ಲ ನನಗೆ
101 page 97.
101 ಇದರಲ್ಲಿ ಪ್ರೈಮರಿ ಕೋಆಪರೇಟಿವ್ ಡೆವಲಪ್ಮೆಂಟ್ ಬ್ಯಾಂಕ್ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಬಿ ಬಸವರಾಜ್ ನಿರ್ದೇಶಕರು ಇಸ್ ದ ಡೆಲಿಗೇಟ್. Now if his election to the primary society itself is set aside in an election dispute raised to the primary society, not so I can understand that this is something which has happened. He was permitted to vote subject to outcome of writ petition, but vote and contest subject to outcome of writ petition. Then the court permitted him to vote and contest, then said that this should be subject to the result of the dispute. Dispute is decided now. So this is not a dispute which is arising today. It is a dispute of the yesteryear. Since 16/2/2024, he is before the court saying that I should be permitted to vote and contest. Allegation against him is regarding the Susti. So far as Susti is concerned, it's an admitted fact that he is a defaulter. But there is no question of a defaulter being nominated as a delegated. Now what happens? In a federal society, I read your lordship's paragraph number 2 for a definitive reason. In a federal society, since delegate, because he is only a delegate. Since a delegate is now held as not elected, my lords, he is held as not elected. The moment he is held as not elected, lords may kindly take section 21. They are entitled to send the delegate and send the list. Section 21(3).
No, there is only reference to petition number 2.
Lords, that's what I am submitting, that petition number 2. So far as petition number 1 is concerned, he has to pursue his remedies only under section 105. So far as petition number 2 is concerned, if he wants to claim that he is a delegate of a particular society, lordships may kindly see what is the description in the cause title. Your lordships can't even grant the relief with this description. Basuraju, son of late Basappa, 66 years, Dodballapur Taluk, Bangalore rural, member of Bangalore District Central Cooperative Bank. How can a relief be granted with this description in the cost title?
He is not a member. And that's what is stated. So far as, because ultimately, the society, if they are still entitled to contest, there is a provision, section 21 of the Act provides that in the event such circumstances are there, 21(3). 13 ಜನ ಡೈರೆಕ್ಟರ್ ಇರ್ತಾರೆ, ಒಬ್ಬ ಡೈರೆಕ್ಟರ್ ಇಸ್ ಡಿಕ್ಲೇರ್ಡ್ ಆಸ್ ನಾಟ್ ಎಲೆಕ್ಟೆಡ್ ನಾವು, ಇನ್ನು 12 ಜನ ಡೈರೆಕ್ಟರ್ ಇರ್ತಾರೆ, 2/3 ಮೆಜಾರಿಟಿನಲ್ಲಿ ಇನ್ನೊಬ್ರು ಡೆಲಿಗೇಟ್ ಕಳಿಸ್ತಾರೆ, ಅವ್ರಾಗ ವೋಟ್ ಮಾಡ್ತಾರೆ. ಇವರೇ ವೋಟ್ ಮಾಡಬೇಕು ಅಂತ ಇಲ್ಲ, because he is no more a director of that society. And I will take your answers to the findings which is recorded minutes by the authority. 21(3). Change of the delegate is permissible. So he cannot say that he has got a vested right as being a delegate.
All these
The
proceedings,
moment,
Lords, could
the
have
moment
been
he has,
concluded, Lord, if at all, if they wanted, Lords, they could have concluded it, Lords, when the proceedings were pending from
no,
the month of May
I
itself.
wanted to ask
Lord,
the
that
same
is
question.
only- No,
Lords,
that
if
is why,
this-
my Lords, I would like to borrow the arguments, my Lords, which
If
my
this
learned
order
senior
was
counsel,
passed
my
on
Lords,
4th
argue
well,
in the serial number 4. It is the same argument, my Lords, that I am advancing.
Lords, I want
That
to
is
say
why.
this. If this is what
It
was
is
to be done, they
convenient,
would have
Lords.
passed an order on 4/12. They would have passed an order on 5/12. He has got every opportunity. Lords, now what my learned friend said, your Lords will take the chronology. 27th, the order is passed. If the order is passed on 27th, he still had time. On the next day, he could have gone before the JRCS, the DRCS, who is the appellate authority, and he would have granted an interim order. If he did not exhaust the remedies there, if he does not get approach the appellate authority, straight away he can't come before this honorable court, because it is not that there is some injustice which is going to be caused to the society. There is a provision for change of delegate. So that, and what the further the petitioners does is, if your Lords were to see the array of parties in the order, which is under challenge at page number 20, fourth respondent is the PCRD. They are not even made as parties in the writ petition. At least as a respondent.
ಯಾರನ್ನ?
A PCRD, he is the director of PCRD. He was elected as a director of the PCRD on the basis of the interim orders passed by this honorable court permitting him to vote and contest. PCRD itself is not a party. Page number 24th respondent is PCRD.
They have delegated me. There is no dispute. I am not claiming any relief, my Lords, against the PCRD.
Lords,
All these technical grounds, my Lords, I fail to
Lords,
understand.
this is a cooperative society. He has to act within the force of the provisions of the Cooperative Societies Act. A member of a federal society is only a cooperative society. If he is a delegate, he is entitled to contest the proceedings, no doubt about it. But the moment he is declared as not elected by virtue of an election dispute raised under section 72C, his remedy is only to file an appeal. Lords, if he has kept quiet for 5 days without filing an appeal, he cannot come now and pressurize the court saying that no, he wants an interim order to this effect. Lords, the drafting of this writ petition, the PCRD is not a party. He says that I am the member, and the description of the petition itself is wrong. There is no way that he can be called as a member of the Bangalore DCC Bank. And if your Lords were to now kindly see the grounds which has been raised at paragraph number 10. During the pendency of the dispute, petitioners produced the share receipt dated 23/25 bank records and election materials to demonstrate that they had complied with all membership and shareholding requirements well before the initiation of the proceedings. Lords may kindly mark this. His eligibility will be considered 15 days prior to the date of election, which was conducted on 16/2/2025. He admits that this is compliance is recorded only on 23/2025. He is a defaulter, admitted defaulter.
I have not been issued notice. That is, my Lords,
But
my
we have the
primary
copies. Can
contention.
I just pursue your Lords? If he wants, I can just give the copy of the notice. We have the notice. We have the postal receipt for having sent the notice to him.
What made them, my Lords, in not providing that?
No, these
During the
notices are there.
proceedings?
No, it is not about providing every single
Where is
document
my
has been
signature?
placed.
There is no signature.
Lords, it
Nothing.
is-
There is
we have-
there
we
is
have-
nothing to acknowledge.
Lords, this is sent by registered post to his registered address. That is the society itself. Society will receive the notices. This is sent to the society. Lords, if he is disputing that, your Lords may have this matter tomorrow. I place all these documents to show that he was issued with the notices, that he is a defaulter. I can understand that he wants to now issue, say,
Lords, he admits to the fact that he's a defaulter. Without the notice, if he goes and pays 600 rupees, isn't he aware that he was required to pay it?
When that notice was issued?
Lords, this is a notice which was issued on 5/12/2024.
Much prior.
Lords, in the
That
previous
notice-
writ petition, this was produced. We are not, this was, I will produce documents to show that in the previous round of litigations, the orders of which are produced before this honorable court, these notices were produced. So even before this dispute was arisen, it was placed before this honorable court that these notices had been issued, and he has not disputed by finding a rejoinder in those writ petitions that there was no such notice. We have the postal receipts. We can even get the postal tracking record that this has been served, but it's served on a society. The address is the society.
There is a reference of the notice in the impugned order.
No, in the impugned order, there is
But
a
on page
reference to
23.
it. But that notice, my lords, has not come to us.
Page
That is all, my lords,
23.
my contention is.
That's a
My
question
lords,
of
had
fact.
it been, my lords, given to me, certainly, my lords, I would have made good. Even before, my lords, the election could be held.
Whether such a contention was raised.
My lords, I have raised, my lords.
No,
I have,
it was not raised.
in the previous proceedings, my lords, they did not bring up, my lords, this particular notice at
We'll
all.
produce that. We'll file the, tomorrow your lordship may have this.
No, no, I
matter.
have
I'll file
produced
my
the
statement
orders.
of
Kindly
objections.
see, my lords, the orders, final orders passed by this honorable court in the earlier round of litigation. Lords, kindly see at page number 31. While granting the interim order, my lords, this honorable court specifically records. No, let them not, my lords, make, lords, certain contentions which were not advanced. Lords, page 31, which is the interim order. Lords, after 6 lines, learned counsel for the petitioners drawing the attention of this court to annexure B and B1 submits that the petitioners have been neither included in the eligible voters list nor in the ineligible voters list. And the process of the election having been commenced, the petitioners are neither able to contest nor cast their votes in the election of the respondent number 5 bank, which is scheduled on 16/2/2025 due to the act of on the part of the respondent number 5. In the exceptional circumstances made out, respondent number 4 is directed to accept the nomination of so. Lord, we were, my lords, specifically contending that, my lords, Lord, I have, my lords, availed the services. Lords, I have made payments of, my lords, more than 50,000, and that amount was laying in their account. Lords, this 500 rupees, my lords, I would not have, my lords, kept as a due. That is why, my lords, I did not receive notice. That is why, my lords, I came up before this honorable court contending that.
According to you, both the petitioners are the delegates?
My lords, not the both the petitioners. My lords, only one petitioner. Petitioner number 2.
No pleading.
Petitioner number 2.
Then who is this petition number 1?
Petitioner number 1, my lords, he was also a writ petitioner in the earlier round of litigation, my lords, where
Why
no, because, my lords,
not seeking any relief?
no, the petition, my lords, this order is passed against both. That is why, my lords, they have joined together.
So your lordships may have this matter tomorrow, my lords. I
Annexure
will place
A.
on record the statement of objections which was filed in the earlier round of litigation, where we have produced these notices before this honorable court with the copies having been served on the other side. We will produce those documents. It is not as though that, no, it's to make a statement that this notice is not brought to their notice is not correct. It is because this notice was brought to their notice, they went to the authorities and then paid this 600 rupees or 500 rupees.
Even before,
my lords, I can understand. If
Counsel for the petitioner, senior advocate for the petitioner submits that petition number 2 was not and never notified regarding the deficit in payment of the share amount.
Share amount.
Share amount.
Share amount. Per contra, then senior advocate for respondent number 6. 6 contents that petition number 2 was notified well in advance when 2024.
Please.
In the year 20, you have date
For
5/12/24.
5/12/2024.
2024.
5/12/24.
You know, he was called upon to make good the.
There was a time limit given 11/1/25 ಒಳಗಡೆ ಪಾವತಿಸಿ.
Calling upon petition number 2 to make good the deficit share amount. And the same was brought to the notice of petition number 2 in the earlier petition. By producing the copy of the same along with the statement of objection. Then the senior advocate for respondent number 6 That the documents will be placed on record by tomorrow, at least tomorrow. Yes.
Please, members.
Serial number 12, Chidanandes, A.V. Arshitara.
ಬಸವನಹಳ್ಳಿ ಎಲ್ಲಿ ಆಟದಲ್ಲಿ ಇದೆ. Next. ಇದೇನಿದು ಯಾರಿಲ್ಲಲ್ಲ.
Chidanandes,
Serial number 10.
Serial number 1 in second.
Serial number 10 ಯಾರಿಲ್ಲ.
10, sir.
10.
ಯಾರಿಲ್ಲ. Council petitioner is absent, no representation. Yes. Next. ಬಸವರೆಲ್ಲ ಮುಂದೆ. ಅದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ or Tuesday something.
Serial number 4.
So fast over, please. The same may be disposed, your lordship, as per the directions of the lordship.
ಯಾವುದು?
Serial number 4, your lordship, appearing for the petitioner.
Proposal has been accepted.
First list, my lord. First list.
Serial number.
First list.
3.75 crores.
Please.
3.75.
You will pay before 15/3.
3/2020, please.
Learned counsel for the petitioner and learned counsel for respondent. You are for respondent number
And for respondent number 2.
Submit in unison that respondent number 2 gave a proposal to the petitioner to pay rupees 3,75,000.
Someone has petitioner has given a proposal for the respondent.
Contending that the petitioner has given a proposal to respondent that he will pay a sum of rupees 3.75 crores one-time settlement. One-time settlement, and the petitioner is ready to pay the same within 15/3/2026. The said proposal is accepted by respondent number 2. Placing the same, the petition may be disposed of.
As per the representation given by the petitioner, let that be.
No. Proposal 3.75. That has been accepted.
There are also conditions.
Proposal was there.
Please.
ಏನು
Conditions ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. I mean, we are also put up.
ಅದನ್ನ you should place on record, sir. ನಾನೇ ಎಲ್ಲ ಬರೀ
Only accepted for 3.75 crores.
only term 3.75 one-time settlement.
And it is also about the release of certain properties that we have.
After payment of that.
Sir, ಅದನ್ನೆಲ್ಲ ಯಾರು you have to place on record.
Please, your lordship. A date may be.
ಏನು agree ಆಗಿದ್ರೆ ಏನು
Lordship, that was placed on record in the previous date as well.
ಇದೆ
The court that ಹಾಕಿದೆ.
ಎಲ್ಲಿದೆ?
19th November 2025.
Reduced ಅಂತ. What you have reduced?
1724.
Area ನೋಡಿ. ಇದೇನಿದು? ಇದು ಬೇರೆ ಇದೆ. The same proposal is accepted.
No, my lords, but we have accepted for 3.75 crores.
ಅದನ್ನೇ 3.75
ಅಷ್ಟು ಹೇಳಿದ್ದಾರೆ. ಆದ್ರೆ ಇದೇನೇ ಪ್ರಪೋಸಲ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ ಇಲ್ಲ ಅಂತ ಬಂದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ. They have to pay the amount on or before 15/3/2026. ಅಷ್ಟು.
Here it is undertaken to clear the dues on or before 15th February 2025.
But check to the release of the funds.
ಅದು 2025 ಅಂತ ಇದು ಅಲ್ಲಿ ಇದು ಹೇಳಿರೋ.
Once you pay off the amount, Definitely, they have to release the property documents.
We release the documents.
They are bound by that.
Yes, ma'am.
Disclosed of. The submissions are placed on record. Petition is disposed of. Directing the petitioner pay rupees 3,75,000, 8.75 crores to respondent number 2 on or before 15/3/2026. 26. Yes. The amount is clear. Respondent number 2 shall release the original property documents in favor of the petitioner. Yes.
My lord, serial number, list number 2 or serial number 1, my lord. Tuesday, my lord, next Tuesday. Thank you. Wait for me.